Yes. Good morning from India, good afternoon in most parts of Southeast Asia, and good evening in the United States and other parts of the world as well. I have great pleasure in welcoming all of you to the second day of this international virtual conference on reimagining and transforming legal education and law schools. I would like to extend a warm welcome to all of you to the 11th thematic session of this conference on the theme, Role of Legal Studies in Reinventing Law School. My name is Raj Kumar. I'm the founding Vice Chancellor of OP Jindal Global University. We have a very distinguished set of panelists who will be reflecting on this theme. Let me begin by introducing my colleague who will be moderating the session, Professor Dr. Prabhakar Singh, Associate Professor at Jindal Global Law School of OP Jindal Global University. We have with us Professor Camille Nelson, Dean of the William Richardson School of Law, University of Hawaii in the United States. Professor Eric Jensen, Director of the Rule of Law Program at Stanford Law School, Stanford University. Professor Dr. Simon Chesterman, Dean of the National University of Singapore Faculty of Law, and Professor Michael Adams, Head of the School of Law of the University of New England, Australia. With those words, I'm going to hand this over to Professor Prabhakar Singh, and I'll see you a little later. Thank you. Prabhakar, you can unmute yourself.
Hello, everyone. Welcome to this session, the first session of second day of our conference. The session is titled Role of Legal Studies in Reinventing Law School. Now, former US President Barack Obama, while commenting on the nature of legal education, had said, "The study of law can be disappointing at times, a matter of applying narrow rules and arcane procedure to an uncooperative reality, a sort of glorified accounting that serves to regulate the affairs of those who have power, and that all too often seeks to explain, and to those who do not, the ultimate wisdom and justness of their conditions." But that's not all the law is. The law is also memory. The law also records a long-running conversation, a nation arguing with its conscience. While things at the heart of law are important, equally important are things around and about law, the subject matter of legal studies. Such a meta view of the law is thus indispensable to understand the functioning of legal system. Things around law also help to understand the manner in which statutes and rules come into existence and the reasons behind their success or failure. The pandemic has laid bare many shortcomings and lacunae in public law, even paralyzing it to a certain extent, prompting lawmakers and jurists to look beyond the conventional doctrinal approaches to the discipline. They have had to reorient their focus from law's functions to law's failings. At a time like this, when legal systems are being reimagined, it is imperative for law schools to encourage students to look beyond the insights of law to its history, epistemology, and phenomenology. Recent reports have explained the existential crisis faced by institutions of higher education and learning, especially law schools, in the face of the pandemic, even going to the extent of calling this phase traditional legal education's Waterloo. This is for the reason that legal training has often undermined the importance of the peripheries of law, including the voices therein, by overly relying on the internal hermeneutics of legal reasoning. The meta approach to legal studies has the potential to reinvent law schools into spaces which are more futuristic, better equipped to leverage rapid technological advancements to offer novel, data-driven and heuristic solutions to complex problems. It can teach students to speak truth to power and the ethical boundaries whose infringement has been brought sharply into focus with every industry's less than human response to the pandemic. This session will facilitate a discussion on how legal studies can reconceive and reorganize law schools and legal education during and in the aftermath of the pandemic. So that is what we have set as the perimeter of our conversation. We would like to have first response on the role of legal studies in reinventing law school, and if I could request Professor Nelson.
Sure. Thank you very much, and it's a pleasure to be with you all over the world today. Really, it's a measure of our shrinking world that we're all here today, and in this way. So I want to challenge a little bit the notion that law schools don't already, to an evolving extent, embed what you're framing as legal studies writ large. I think that increasingly over the last several decades, that law schools have really incorporated notions of the way law informs politics and politics inform law. Law involves, informs economics, and economics informs law. Technology, psychology, sociology, certainly critical race theory, cultural studies, history, the embeddedness of technological innovation and such, as well as indigeneity and internationality. So I don't know that there is a pure notion in the way it's been framed of law schools, right? I think it depends on the law schools, it depends on the faculty member, it depends on the course being taught. I think definitionally there's been much, I think what you might frame as evolution or progress in certain spheres, such that very few people, I think, hold the sort of airtight notion of law schools that perhaps is being proposed as distinct from legal studies. Certainly, I know that myself and many people who have grown up in the law, as I have, never held firm to that sort of purist sensibility, perhaps. So that's the frame from which I operate, but I'd like to learn more, and I'm certainly open to hearing how perhaps there has not been that evolution, as it were, elsewhere, but that's certainly been my sense of my legal education in Canada and the US, and certainly my role as a leader in higher ed over the last decade in the US. So I think there's been much transformation. Hopefully it's an evolution and it's progress, but certainly there has been much that's been changed in the last several decades.
Thank you, Professor Nensel. On that note, I'd like to request Professor Chesterman to reflect on this, particularly how the NUS Law School, where I had the privilege of studying, is balancing the study of doctrine and commercial law with increasingly sort of dealing issues with theory. And I've seen that, that the law school there is actually, in some ways making that switch very successfully. So, Professor Chesterman.
Thanks so much, Prabhakar. And I'd agree completely with Camille that this is a problem, but it's not really a new problem as such. Although, as I'll say, I do think there are some new dimensions to it. In terms of what we've been doing, it's really only in the last 20 years that we really shifted our educational paradigm away from a pretty doctrinal theoretical basis. And we still do doctrine. We still do that sort of what the law is. I think it's important that all law graduates need to know sort of what a tort is, the elements of criminal offences and so on. And so that sort of doctrinal part remains, but we supplement it with two others. And the second is we ensure that all of our students develop perspectives on the law, the sort of why the law is the way that it is. And we do that through theory, through comparative law. And in that sense, I think Singapore is a little bit unusual in that we're an extremely small jurisdiction. But my faculty of 70 or so faculty members, there is no one on our faculty who is only educated in Singapore. Every single member of the faculty has a degree from some other jurisdiction. So I think that helps in terms of the perspectives. And then the third thing that we try and do is give our students a chance to explore how the law is practiced, experiential learning, where I think we were a little bit slower on clinics than the United States. Australia is also developing its clinical programs. But those are the things that we try to do. But in terms of the question you're asking, is something really changing as a result of our world? I think there are two forces at work that we do need to grapple with, and they're globalization and technology. Globalization, nothing new really, but increasing pressure on the profession to embrace globalization, to outsource what can be outsourced, and that's introducing commercial pressures on the practice of law that I think imposes obligations on us at law school to prepare our students for that transformed world. And technology also, obviously, is transforming the practice of law. The role of AI, machine learning, not in overtaking the complete role that lawyers play and judges play, but in transforming that role. And so I think that those are two areas in which we do have to adapt the law school curriculum. And like other law schools around the world, we're doing our best to do so, to prepare our students not just for a world that is transformed, but prepare our students to play a key role in that transformation itself.
Thank you, Professor Chesterman. Can I now request Professor Jensen to tell us about how the Stanford Law School is looking at legal studies and legal studies during the pandemic? Thank you.
Well, I don't know what to add beyond Professor Nelson and Professor Chesterman. They stole the wind from my sail. But let me add just a couple of thoughts. Law students, as they're entering these days at Stanford, are demanding a lot of faculty. And actually, the Stanford climate is one where students take initiative and actually participate in the shaping of a curriculum. But students who are entering these days are demanding policy relevant legal studies, given the incredible challenges we have in public health, in public education, in a competent and legally objective bureaucracy. These climate change, all of these issues are on the top of students' minds. So they don't really want to engage in in considering how many angels dance on the head of a pin. It is true, and I agree with Professor Chesterman, that doctrinal studies are still important, and thinking like a lawyer is still important, and we shouldn't be ashamed of that. Nevertheless, we have a bewildering array of social, political, and economic problems in the world today that legal studies should and must be relevant to. So I'll just say, Paul Brest wrote an 11-page memorandum for new students coming into the law school this year on all of the classes that we have on policy relevant classes and social problem solving. And I think this is really at the heart of all sorts of things that we're trying to do in an expanded definition of legal studies. But I think the definition that was articulated in sort of the problematique to get a reaction to, it was a problem back in the 60s. And Mark Lanter and David Trubeck wrote about this in 1971 in Scholars and Self-Estrangement. Even that critique I thought was overstated and not as well informed as it could have been. But we've been thinking about law and political science, law and economics, law and other things for a long time. And indeed, the Stanford Law faculty has economists, political scientists, sociologists, psychologists, medical doctors on the faculty to assure that we're at the intersection of the critical problems that we face today.
Thank you, Professor Jensen. In fact, to add to what you just said, the 1960s was the generation in India where, with the help of Ford Foundation money, institutions were set up in India, for instance, the Indian Law Institute, which is just next to the Supreme Court. And there was a lot of exchange of American professors in particular, Quincy Wright and others. I know many of them in international law. And also the Wisconsin Law School, that is actually the hub of doing South Asian studies, which mixes law with social sciences beautifully, actually. So a lot of us, in that sense, get instruction from the Wisconsin group that you just mentioned. So now I request the fourth panelist, Professor Adams, to reflect on how legal studies has already started doing or has already done, or are we moving towards something which is not just law, but law and something in the Australian scenario. Thank you.
Thank you. Thank you for the opportunity to share what's happening in Australia. For the last 30 years, we have managed, I guess, to probably be different to some of the other jurisdictions that we're talking about, in the sense of the research shows that 50% of all law graduates with a law degree have no intention to practice law. So in other words, half of our cohorts, not just here at UNE, but across Australia, make the decision quite early on that with their law and their other degree, whether it be in business to go into the commercial world, if it's in criminology, into that sphere, if it's into, in fact, languages, a whole range of international studies and policy, politics, even good old Bachelor of Arts in history, it means that, in fact, in the classroom scenario, you cannot make the assumption that the people are going on to practice law. Now, obviously, every law degree is accredited by the admitting authorities to make sure students, once they graduate, can have that opportunity, but many are not as interested in practice. And so that is actually an ongoing tension. To pick up on your second point, which was really around how legal studies, I guess, informed, I agree particularly with Professor Chesterman, the role of technology has been absolutely critical. And it's interesting that this last year, this law school had a major review of its law curriculum. And in fact, we introduced a major capstone unit being technology and the law, whereby half the course looked at what are the technologies a legal practitioner really needs to handle, often things we don't talk about at law school, that's left to the practitioners. But actually the second half, and the bit more relevant to here, is what is the impact on big data, artificial intelligence, and then more specialist things such as the COVID safe app, down to specific things like drones, and then looking at the array of doctrinal laws around that problem and trying to critically think, so bring those different strands of policy and politics and underlying social cohesion. So it is interesting, as I said, the big thing to remember in Australia is that in the classroom scenario, you will find, yes, about half do not intend to practice law as a solicitor or barrister, an attorney. They intend to use their legal training in a much broader concept, and that does inform our particular curriculum.
Thank you. So now that we've had views from all four of you, I find it interesting that Professor Nelson should sort of start with the assertion that we've never thought law is always, law is this pure discipline that doesn't interact with other social sciences. In India, we are used to saying all the time that it's the lived experience that informs our understanding of the law for a number of colonial and other post-colonial reasons. So, and it's interesting that Professor Jensen said that we should not be ashamed of of the doctrine and teaching of doctrine. I think this is what is in general is the line of thinking among critical and doctrinal lawyers. Very recently, in a blog post, another professor at NUS, Professor Anthony Angie, said that the study of the critical aspect of law starts with doing the doctrine first. We must understand the doctrine and understand what are the problems that these doctrines are generating, or maybe they're not addressing or not touching issues, being too narrow and not sort of open to problems of certain community, certain group within different jurisdictions. So I would like all of you to sort of reflect on this. I mean, doctrine versus doctrine, theory, and the practice of law. And how does legal academy post-pandemic with technology respond to that? Because access to technology also a money matter. Not everyone has the same kind of internet access. Quality of phone, now I realize more and more, quality of phone is such an issue. So good internet connection, quality of phones you have, or laptops you have, to of course how we connect these day-to-day problems faced by students of different economic, socioeconomic backgrounds with their reception of the law. That already makes the teaching of doctrine rather law and something. So Professor Nelson.
So I think your question is sort of the question of the moment in so many ways for so many of us. I think focusing on context, right? So the milieu in which the law operates, functions or doesn't function, right? The law's functionality and dysfunctionality, I believe, is contextualized and historical, right? So to the extent that we find ourselves in this historical moment, at least in the United States, but certainly in many, many parts of the world where we have what's many have called racial reckoning, right? And that cuts in many ways, in many places. It's intersectional, it's post-colonial, presumably, or neo-colonial, depending on your perspective, right? There's a lot going on there that brings history to the fore. There's, of course, the omnipresence of the pandemic and its sequelae. And here we also had the sort of everything around the election. So there's a sort of heightened moment in this national context. And as was said, the students coming in are also coming into a space anxious for solving problems, including climate justice concerns, right? So on the one hand, we have a real, frankly, consistent with our accreditation dictates, need to educate on the doctrine to ensure appropriate licensure guarantees, let's put it that way, or thresholds are crossed. Even if we know that the reality is not all of our students are going to end up practicing or practicing long-term. And at the same time, we have a thirst on the part of the students and the faculty to address this looming culture and this crisis and this context. And, I think it's the moment of now, but as a professor who's taught contracts, torts, and criminal law as my 3 foundational courses, and then my seminars, I'll just take criminal law for an example. I think it's hard in the States and in Canada to disentangle the doctrine from the history, from the culture, certainly from race relations, increasingly from innovation with body cams, from critical race theory, from feminist studies when you're talking about sexual assault and rape, from queer studies when you're talking about like gay panic defenses. And so I think it's got to be real concerted attention to those threads that inform the doctrine in many cases, or else it abstracts the law to the point that it is for many of our students and diverse faculty increasingly just a fiction, right? To act as if it's neutral begs the question of how did we get to this even notion of the reasonable man, for example, as informing the elements of doctrine. So I see it as sort of like, I'm a visual learner. There's a bit of a lava lamp phenomenon, right? They meld and they merge into each other, or else what we're talking about, even as the doctrine, is so abstracted from our realities and our history as to be, anathema to anything that would make sense for so many people in our classrooms increasingly, which then begs again the diversity and inclusion question. So, which then tethers to the racial reckoning moment. So I'll stop there because I've tried to load in a lot, but I obviously see a lot of this as multidisciplinary, historical, and interdisciplinary with a heavy dose of internationality.
Thanks for that comment. And it's interesting you mentioned the idea of visual learner. Actually, in a classic social science setup in India, we always say that, it was Hegel who said, well, ideas come from the mind, and his best student, Marx, overturned him to say ideas come from our lived experience. So we're back to the same Hegel versus Marxist question of what is it that makes us learn, or what is it that puts ideas in our head? So with that view, I'd like to go to Professor Jensen to sort of get some comments on doctrine versus lived experience, and how do we balance it?
I thought Professor Nelson put it very articulately, but I will supplement to the extent I can. I think the doctrinal teaching itself today has evolved because the students have evolved, and the discipline of law has evolved, where it's become. Stanford was at the forefront of interdisciplinary legal studies back in the 1980s, but everyone's working on interdisciplinary legal studies now. And in a sense, that informs how doctrinal courses are taught. History matters a lot more. Societal context matters a lot more. So I think even within the more narrow doctrinal realm, you have, I wouldn't call it a revolution because I don't think revolutions happen within that narrow doctrinal realm, but a significant change over time. Because the student body, again, really wants to talk about problems of the day and what their training might do to solve some of the problems of the day. There are all sorts of careers. Professor Adams mentioned that half of his students want to do things other than law. Certainly that's the case at Stanford too. I would say 80 to 85% of our students go into big law, big Wall Street firms and the like to start their careers. That's not where they end their careers for the most part these days. Many are founding nonprofits. They're working in the space of environmental, climate, racial justice. They're trying to relate their legal experience to the problems of the day. I'd also say that within the doctrinal space, there's nothing wrong with thinking like a lawyer. The discipline of logical progression in writing and speaking, actually, law isn't the only place in which you can have that sort of critical engagement of thinking critically, but law classes are a great platform for honing those skills. And I'll just say one last thing about the meaning of a law degree today. I mean, I can't think of another time in my lifetime, apart from maybe post Watergate, where entering legal studies and entering legal education is more relevant. We've just been through, we are in the midst of a rule of law recession globally and have been profoundly for the last 10 years. And if you notice things that have gone on in this country and trying to undermine bureaucratic capability and the like, and the fight against that undermining of the rule of law and bureaucratic capability, that's led by lawyers. Take up the good cause.
So taking from you the cue on this global sort of awareness about interdisciplinarity, I'd like to know from Professor Chesterman, how is interdisciplinarity working in and around Singapore, in ASEAN, if I may sort of expand it to this, not just to Singapore, but generally the whole of ASEAN,
So in Singapore, we're very explicit that Singapore has to be global. Singapore has to engage with the region. That means we need to understand the region. But I wanted to echo some of the comments about the nature of law. I mean, so Michael said about half of his graduates might not practice law, Eric slightly more. 97% of our graduates practice law for a while, but 6 years later, half of them are doing other things. And indeed, one of the sort of radical things I did as dean was start promoting the achievements of our alumni outside of the law. So obviously we've got great graduates who do things in the law, the Chief Justice, Attorney General, and so on. But we've also got playwrights, we've got diplomats, we've got business people. And I think this really points to a tension which we're dancing around, which is whether a law school is a professional school or an academic institution. And of course, it's both. We do need to train people who can be competent lawyers, and that's a powerful role in society. I'll say something about that in a second. But law is also a fantastic way to understand society, to understand how power is managed and the kind of problems that Eric's pointing to that the United States is experiencing, which is echoed in other places around the world. And I'll just put this in the context of the pandemic, because I remember as the consequences of the pandemic became more and more apparent, some colleagues and some students were saying, gee, it's a shame lawyers aren't really useful in this situation. We can't produce the cure, we can't heal people. But lawyers are vital in a time like this, vital to ensure that the pain of dealing with the pandemic is spread equitably, that the vaccine, when it comes out, is shared fairly, and that the surveillance powers that have been so important in curbing the impact of the virus are limited to what's necessary and limited for the duration that's necessary. And I think that really comes back to a point that Camille was making, that you can't understand law without understanding power. And indeed, law is power. Law is about how power is regulated in society. And I think the people who study that, it's clearly an important thing to think about, but it's also an important thing when you send graduates out into the world, that they have a sense not just of how to be a lawyer, how to do that technical stuff, but what the impact of a lawyer can and should be.
In fact, yeah, my sense is that when lawyers graduate from here, and in a session yesterday, one of the leading firm partners said that, in fact, once they enter the law firm, we have to re-educate them, because law in India at the law schools are done in a very different way, and perhaps we are looking at problem solving with clients in mind. So we do some sort of retraining, and that's how sort of they restart their life at the law firm. And then, as you've mentioned, 5 or 6 years later, they sort of choose to branch out into different directions. So my question to Professor Adams is, how is it that the aspects of interdisciplinarity is playing out in the Australian academia? I mean, is it by being at the law school that they actually encounter or develop diverse interests? Or is it that they have some sort of, or this happens after the law school ends?
Thank you. That's an excellent question again. And I also, can I say, I agree with many of the comments that have already been made, particularly Professor Nelson's view of those intersections at this point in time is bringing together many issues which have been debated over the last 10, 20 years, if not longer, but it's sort of come to a flashpoint. And I loved her expression, in the moment, because so many things have been broadcast. The other is, I think we're taking for granted our ability to know what's happening in the world at any point in time. Let's just take the vaccine. As the two, I believe, American pharmaceutical companies launched theirs, and then the one out of the UK, out of Oxford University, the speed of which we know literally how many doses being bought. I'm not sure if it's in your news, but for us, our national airline Qantas, we'll only let people fly once they've had the vaccine, once it's been released, and of course that brings up a whole bunch of legal requirements. And they're comparing it to the equivalent of yellow fever, where we already have some regulations. In each of our jurisdictions, I'm sure we have some anti-vaccinators and people. In fact, I even had a senior academic colleague talk about thalidomide, and if we give medication, we don't know all the consequences. Do I have the right to decline? You can imagine the legal issues that arise. To come to the heart of your question, I also agree that the doctrinal methodologies, which are so engrounded in our profession, which date back, in that sense, thousands of years, particularly under a common law system, does have an impact. And again, Professor Nelson, I think, encapsulated beautifully when she said she taught criminal law, contracts and torts. In many ways, and I don't wish to diminish, I'm a corporate lawyer by training. Once you get those basics right, it's amazing how you can then apply it, probably with equity and trust, those sort of concepts, across a whole range of fields. And then, of course, one of the things we certainly know from education, and I've been a professor for over 30 years, is that those building blocks are interconnected. How many times do we come across a student who fails to connect that, in fact, a criminal act, for example, and I'm now thinking in the area of employment law, whereby, say, you have an accident at work, there's a civil claim under tort, that we have a compensation scheme called workers' compensation, which is also a civil law, but we also have occupational health and safety laws, which have a criminal protection to make employers do the right thing, and they all interface. And we don't understand that interaction of our civil court system and our criminal court system and the way our legal system works, it all falls apart. But it is all based on relatively straightforward doctrine. So how we then apply it, and I also agree with all the speakers around the student coming in, and again, if I can put it in a time context, you probably will remember that the Sydney hosted the Olympic Games in the year 2000, and it was a wonderful world success. My heart goes out to Tokyo, that this year, of course, they should have hosted the Olympics, and that's been deferred for another year. And my mind is thinking that when I started to remind my first year law teachers that these students in law school now weren't born when the Sydney Olympics were hosted. And so that idea that they come with a different worldview, they've always had an internet connection. Pretty well from late primary school, early high school, they will have had a mobile phone with internet access. So when they come, the idea of going to a traditional law library and pulling books out is so foreign to them. They're used to information being served in a particular way with speedy access. And our courts and our legal system, our parliaments overall, have tended to bring that information together. But I think it is that multidisciplinary aspect. And I guess I was incredibly impressed, and we don't have it here within the law school at Stanford, talking about having a medical doctors and sociologists and psychiatrists and a whole bunch of other disciplines in-house. That's something we certainly don't. But as a university, we do break down those boundaries, and we certainly have those interactions across our many faculties. So we are living in a very exciting time. But the interrelationship, I think and this is where the profession comes into play, does expect some basic understanding of the law. The other area we haven't touched on, of course, is the ethics domain and the professional responsibilities. Because sometimes in the areas, dare I say, of plagiarism and basic cheating in any shape or form, reminding that lawyers, certainly in Australia, become officers of the court. And there is that higher duty that is expected and distinguishes from society. The other is the role of pro bono and in encouraging people to take on activities outside their own personal benefits.
So far we have talked about the concept of law, as it were, about law as purely doctrinal to law, mixing law with social sciences to sort of reflect more accurately our lived experiences. So my next question to all the panelists is that how does, so this understanding this concept of law as teachers, and how do you effectively transfer this in the class? Because in my experiences of teaching in India has been that mostly people are welcome to this because they're seeing the reality, and to use Professor Nelson's idea of visual learning. But there's also some resistance saying this is not law and we would like to know law in this way. Students also demand, because now we are moving to this demand supply model of teaching or being law teaching. So reflections on how are you transferring this into the classroom effectively, and what problems do you face with Professor Nelson?
So one of the things that I think is really interesting to consider is the classroom as a place of mutual learning. So the professor, of course, is the one charged with, sort of managing the classroom. But I also want to suggest that we have much to learn from our students in terms of flipping the hypotheticals into the present moment in contemporary ways. Let's put it that way. Right. So how can we continue to have those conversations with them that take a traditional doctrine and flip it to TikTok, or flip it to some dating app, or think about the ways that it brings it alive in ways that they are more familiar with, perhaps in terms of the problems that immediately confront. And again, I'm generalizing because, of course, many of us have large spans of ages in our classroom, but they're present and lived reality, right? So sometimes the examples in the cases and the analyses seem quaint. I'll just give, I remember talking to him, we were at a cabin years ago in the Midwest, and my kids, and this was over a decade ago, there was a rotary phone, right? The dialing phone. My kids had no idea what it was. I mean, they could figure it out. But it was like this ridiculous thing connected to the wall with this, like this was just something that was like an antique to them. And I think many of us grew up with those phones, right? And even the notions of, microwaves being ancient technology, and, many of us still use forms of social media that our students aren't even using anymore. And we have to encourage them to check emails and such, right? And to check our Facebook pages and such. So I do think we have an obligation to think about how to make doctrine live in the present moment in ways that deal with the cutting edge modern problems. And I think we can do that. But I think it behooves the faculty member to also be willing to engage with those possibilities, be they in ride sharing or whatever is next. And I think that to just say we bring as faculty into the classroom our expertise, but we can also pull from the problems that are seen as most pressing for our students to make that experience pop off the paper, as it were.
Yeah, so taking from you the idea of teaching as learning, teaching is not only teaching, I would like to ask from Professor Jensen, how do you combine this teaching of doctrine with lived experience, and tie this with assessment criteria? Because as teachers, I sometimes feel that students in the moment of learning law are, for the 90% of the times, concerned about grades. So for them, grades is the reflection of what they have done, and this is a constant worry, creating all kinds of problems, particularly during the time of the pandemic, where internet becomes the thing through which everything happens. So this has also created, I think, stress among students for us. This idea of being graded and completely sort of changing the old model.
So I don't know exactly where to start in answering this question, because my whole world is being overemployed in experiential learning. That's what I do. And that's a high demand of students is experiential learning. I respect what my colleagues do in teaching doctrine. I know the importance of it, but I'm overemployed on demand for experiential learning. My students write textbooks critically analyzing the laws of Afghanistan, of Iraq, of Rwanda, of Cambodia, where we have peer review committees in each of these countries, making sure that we've got the context right, because law is all about context. And if you don't have the context, you're going to miss a good deal of what's important. So that's all I do is experiential learning. I cross many countries with different groups of students, trying to impart to them, and they get it, the importance of context and the importance of understanding what's going on, and they take these projects with a high level of humility. Paul Bress and I lead a research project at Stanford on rule of non-law. Our observation is that countries, despite neoclassical claims to the contrary, seem to grow phenomenally well, even if legal systems are underdeveloped. Take Singapore's legal system, Simon, in 1960. And Singapore was on a trajectory of economic growth long before its legal institutions came of age. And we see this China, India, all of the East Asian tiger countries. And our students actually work on case studies looking at the Yakuza, for example, how the Japanese mafia works, and to the extent to which it can be controlled by law. We critique legal and judicial reform projects around the world, case studies that my staff and I write on what's gone wrong in these legal and judicial reform projects of the World Bank and other donors. What were the assumptions made? Where did they go wrong? And on your point on assessment criteria, Prabhakar, as Stanford moved to trying to take pressure off of students to moving to just honors, pass, and fail. I think this has been a mixed experiment. Yale has the same criteria, but we actually have a curve, so we can only give so many H's. Yale isn't so constrained. I think it's taken some pressure off of students, but I must say, as one who does a lot of grading, it's rather unsatisfactory to have such a binary system where you have students who almost get an H, but because of grading on a curve, I cannot give that H. So trying to get away from grades, I think, is important. Trying to infuse, real learning in the classroom that isn't just rooted in grades is important. And Camilla, I just want to mention one point on how we learn from our students. A few years ago, I was in Rwanda with two of my students. They both happened to be African-American women. And we sat at the dinner table for 3 nights, and I learned that race relations in America wasn't nearly what I thought it was. And that was a self-correction. I'd lived out of the country for a long time, but when I came back, I thought many of these things were progressing, and they certainly weren't. And we've just lived through a summer that shows how we weren't. But I just wanted to mention that example is, listening to students and what their needs are and what their aspirations are is really important in making sure that our curriculum overall is relevant.
And that's a credit to you for being willing to listen, not just to respond, but listening to learn.
Yeah.
As lawyers, I think often our tendency is we're listening to respond. And then the audacity sometimes of us as faculties, we also forget that we are always students of the law as well. So kudos to you as well on for mentioning that and being willing to absorb it.
So Professor Chesterman, so given that in Singapore and in larger Asia, the way we see teachers is very different from the way we see teachers in Australia, US and European jurisdictions. Not that there is disrespect for teacher in that jurisdiction. The power relations are very different. I mean, and India and China are comparable, India less so, in China more. So how does, taking the cue from Professor Nelson's point of learning from students happen? Because they're generally more quiet in the US, they're more listeners than participants. Maybe this is changing with international students, but how do we deal teaching and assessment now during the pandemic in the US and Asia generally?
Yeah, so I've been I'm an Australian national, educated in Europe, worked in the United States for 6 years, and then been here for 14 years. And I think in the 14 years I've been teaching in Singapore, the students are getting more talkative. I mean, there are fewer and fewer students who, when I first arrived, I noted if you walk down a corridor, some students will stop and bow as the teacher goes past. Those days are gone. And I think that's a good thing. The students are more talkative in class. Singapore is becoming a little bit more open, a little bit more liberal. Students are certainly becoming more opinionated. I think that's a good thing. And I think two things are driving that. One is just the social milieu is changing. The idea of sort of government by meritocracy alone is no longer accepted without criticism. And again, I think that's a political maturity that Singapore is experiencing. I think that's healthy. But we've also encouraged it by essentially structuring incentives, because Singapore students, Prabhakar, you will know well, are very focused on grades, like all of our students are, but they also respond to incentives. So I have a whole speech when the students come in as freshers that many of them have come through a school system which prioritizes doing well in tests. But for many of them, doing well in tests means that the teacher knows the answer to the question, and your job in the test is to provide that answer under exam conditions. But in law school, as we all know, the question is the thing. Often faculty, when they present a problem, they don't really care what the answer is. They want to know how you frame the question, how you will interpret it, how you will interrogate it, what evidence you will marshal. And so we make that clear to students, and then we give grades for class participation and make it clear that class participation is a quality, not quantity thing. And you get 0 points for agreeing with me. I can agree with myself. That's very easy. I'm always encouraging students to criticize me, which is exactly the point that Camille and Eric have made about the extent to which we learn from our students. The only other thing I would say on this is that even as we go in that direction of empowering our students and learning from our students, and I think we all know how much we do learn in the classroom, there is still an element of the students do need to eat their vegetables. So it shouldn't just be sort of pandering to students. I think the students do need to work hard. They should work hard because law is hard, but the benefits are hopefully worth all of that effort.
So Professor Adams, what is your experience of classroom teaching and assessment during the time of pandemic? You spoke about technology at length, but how is it working now?
Yeah, thank you. So I was the dean of a law school in Sydney for a decade, and we were predominantly an on-campus university. And then I moved here to Armidale, which is 6 hours from Sydney and 6 hours from Brisbane inland, in Australia's highest city. And we are 93% fully online. So I have now a very different cohort. In fact, our average student is a 36-year-old female with 2 children living in a metropolitan area who is actually changing careers. So they are much more mature, much more time savvy. They want to be very efficient in what they're doing, but also they have a sort of different level of maturity. So our school leavers make up only about 7% or so, and COVID, they lived on campus. So when COVID really hit Australia in March, we, in fact, as a university, switched to 100% online. And obviously, in the areas of law and business, we made that transition very quickly and very easily. To pick up on your point about assessment, that certainly we, for accreditation purposes, are required to have supervised exams, and we have gone over to using OLX, online exams, which has some good and bad aspects. We use a product out of America called ProctorU, which I'm sure some of you may have heard of, for that supervision of exams. But we have found problems, everything from poor internet connections through to a cohort of students who just aren't used to doing that sort of online exam, and mental and health issues through pandemics, as well as just environments where your children are in your home, you may have lost your job, and on it goes. So, and I'm sure each of our countries have suffered through that period of change. So I have to say, overall, it has been a challenging time. I would like to just say that I mentioned technology in the law. One of the things we did do was actually provide sort of some more practical assessments, such as writing a memorandum to a managing partner and giving a statement of advice, which again, ironically, is very legal focused. But the assessment task for graduating students was around showing the sort of work they will do in practice, but around technology. And I have to say the student feedback has been very positive to understand for their future careers. So yes, you're quite right. It has certainly been a challenging time, but I also think it provides a lot of opportunities. The other, of course, is just our global availability of information. The fact that case law and legislation as basic tools, as well as the research papers, are available globally. Our libraries now have better access than ever to official government information as well as institutional information. So the free access movement has got more and more papers available rather than the paid walls, the difficulties of subscription through libraries. More research is now publicly available than ever before.
So, thank you. So the pandemic hit us at a time when we had begun to generate some kind of pride in sort of all of us in whatever corner of world we are in becoming more global through exchange programs of teachers and also students. So now, since that is stalled and everything is more, technology driven, we would like to know how what is it that we can how do we compensate the benefits that we would have had from exchange programs and bringing diversity, global diversity in the classroom now that we are in the pandemic situation? How and to what extent does technology help us replace the old model of traveling and knowing in the classroom, global classroom, so to speak?
I'm happy to fire, if I may, with a couple of quick examples, because Australia is a long way from everywhere else. So in that sense, it's something that tyranny of distance. And I want to say up front, student exchange and faculty exchange is incredibly important. I think we look forward to, even a conference like this. Yes, there's some benefits and we'll make it all available without the travel. But imagine if we'd gone for a meal, how different this conversation would be because of our own personal interactions. And as Professor Nelson said, our ability to listen to each other and understand. The examples I want to give, during the pandemic, I actually interviewed 20 different lawyers and academics from around the world, from China through to the US, the University of Michigan, and obviously throughout Australia, talking about technology and the impact of law. And that in itself would have been very hard to do previously. It was very easy to send an email, let's get the right time zone, we used Zoom and we recorded it. And I have to say, they were done like fireside chats, and the guests were fantastic. The students loved sort of 20-minute vignettes around these practitioners around the world and being able to get places without COVID. The other example is we set up, I mentioned the Tokyo Olympics. We signed an agreement with Meiji University, one of the top private universities in Japan, to provide some English common law studies by tapping them into our existing system. So we enabled these Japanese law students simply to have access to our own Moodle sites, our learning management system, with access to all the videos on common law and case law and listening to the classes, and they could do it for credit or no credit without traveling. And I don't know if you're aware, but in Japan, online learning is very unusual. That's not a concept they have. They very much have that tradition of the teacher and the classroom. And because of COVID, were willing to open the door and provided us with some great opportunities to teach their students in a whole new way. We gave a few demonstrations to their faculty, and what we treated as, and I'm sure you know the expression BAU, business as usual, this is our normal way of doing things. And for our Japanese colleagues, it was like, wow, how do you do things like that? How do you do student engagement? And that was wonderful to help, I guess, upskill. And I said, Meiji is a top private university with lots of money and resources, but it built some great friendships. But I have to say, I had visited Meiji the year before. So I built up that personal relationship. And so Zoom becomes that supplement. So I think we have a long way to go, but maybe there's some examples and others will have more.
Professor Nelson?
I think Michael gave wonderful examples of the pros and the cons, perhaps. I think for us, both, my new role and where I was previously, our concern has really flowed from the creation of virtual community, right? That which is outside of the classroom in a traditional sense, but which reinforces the classroom experience and which frankly just allows the students to thrive and to be more holistically well. Because I think one of the things that this pandemic has rendered laid bare is the well-being question, right? There has been, I think, we have to be real about instances of depression. We have to be real about anxiety, and real fear for oneself and one's loved one during the pandemic, which interferes with one's ability to excel in the virtual classroom, and other dynamics that were there before, but given everything that has transpired in 2020 has been elevated, right? Or exacerbated or caused. So, I think that virtual community building is something we're trying to be more intentional about, whether that's, social events and cooking classes and trivia nights and movie nights, but just trying to recreate, especially for our first year students who did not have the chance to have, for example, like this panel of friends who we'd study together or go out together or hang out together, walk from classroom to classroom. How do we recreate those experiences that fortify the learning is a big challenge, at least for us coming into these virtual online educational spaces. So we could learn a lot, I think, from you all, Michael, in terms of how you've done that.
So Professor Jensen was morely, he said that his work mostly was experiential learning, which meant a lot of traveling. And how have you translated your experiential teaching and learning during the pandemic using the technology?
Well, I'm probably a 5 million mile flyer lifetime, and I am experiencing a world-class case of cabin fever. I don't need to go back to the level of travel that I was doing before the pandemic, but I would like to get out of town. Exchanges are coming back. Faculty and student exchanges are coming back to the US, and I want to say that with a great deal of confidence. When the vaccine is fully deployed, I think we will open borders in ways that have been closed over the last few years to international students. And I think this international exchange is extraordinarily important. And I think the vast majority of my colleagues across the country agree with it. It's a damn shame where we are today in student exchanges. There are some unanticipated benefits of distance learning. I sit on the board of American University of Afghanistan. We are fully online now and have been for the course of the pandemic. Students wanted to come back to class because of their law schools in the country were going back to class and meeting unsafely in class. But then a bomb went off at Kabul University law faculty a couple of weeks ago, and suddenly students thought maybe this online learning isn't such a bad alternative. I give that as an example of being able to cross over all sorts of insecurities to deliver really worthwhile learning products in the midst of a civil war, essentially. I think some of my students have suffered from Zoom fatigue. I think we can't stay online as long as we would like in the classroom. I think there's some good empirical work around this. But I've got to say, I taught a seminar this fall. It was the smallest seminar I'd taught in my years at Stanford, but it was one of the best. And I couldn't believe it. It was on Zoom.
So Jensen, since we just have 1 minute to go, we'd like to have the last word from Professor Chesterman. Sorry to cut you off. Just 1 minute.
No, it's okay. I was finished.
Thank you.
So, well, just very briefly, I agree that the international dimension is important, but also the interpersonal dimension. And that's really where Eric, I think, was going. The limitations of Zoom. This is a great way to connect. I'm delighted to be in both Delhi and in Hawaii and in Stanford and in Armidale, but there are limits. And although I think, as Michael was saying, for mature age learners, time-sensitive learners, this might be the most efficient way to learn, particularly for undergraduate students. I think the point of a university, it goes back to what I said about law being both a vocation and a subject of study. So the university experience should be more than just about acquiring knowledge. It should be about acquiring an understanding of yourself, and that's an inherently dynamic process. So like all of you, I'm looking forward, hopefully, to meeting up with this panel and indeed with Raj, who's reappeared in Delhi or Singapore or Hawaii somewhere soon.
Or Palo Alto.
Palo Alto would be great.
Well, thank you very much for this fascinating panel, and we've really enjoyed and engaged with a very important topic. You actually set the stage for some more discussions. We are also celebrating the Constitution Day in India today. So just 15 minutes from now, Honorable Dr. Justice D.Y. Chandrachud, Judge of the Supreme Court of India, will be delivering the Constitution Day lecture on a theme that some of you reflected, which is constitutionalism, liberal democracy, and enlightened citizenship. So many things that you said does reflect on some of the core values of that theme itself. So I'm grateful to Camille, Michael, Simon, and of course, Eric, and also Prabhakar for being part of this thematic session. Thank you very much.
Thank you.
Very good. Thank you.
Thanks.
all of you to this Constitution Day lecture on the theme Constitutionalism, Liberal Democracy and Enlightened Citizenship. Samvidhan Divas, or Constitution Day, is celebrated in India on 26 November to mark the formal adoption of the Constitution by the Constituent Assembly. The Constitution of India was formally adopted on 26 November 1949, and it came into force on January 26, 1950. We are immensely fortunate to have with us today on this very, very special occasion two leading, pioneering legal luminaries. We have with us today Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, who will be delivering the Constitution Day lecture. We are also very fortunate to have with us today Professor Dr. Upendra Bakshi, Research Professor of Law and Distinguished Scholar, Jindal Global Law School, OP Jindal Global University, who will be delivering the presidential address. Without much ado, may I now request Professor Dr. C. Rajkumar, Founding Vice Chancellor, OP Jindal Global University, to kindly deliver the welcome address.
Thank you very much, Upasana. I would like to, of course, extend a warm welcome to all of you to this very special occasion when we mark the adoption of the Constitution of India as we celebrate it as Constitution Day. In many ways, this particular Constitution Day lecture is very special for us as we to organize a global virtual conference on
Chamber 5 here.
Yes, sir. Actually, not from our side.
Shall we start with your address, Justice Chandrachud, if that is okay. I think there is a technical glitch.
Okay, can you hear me? Everybody is, there's no problem at my end, right? Great.
IT office, can you come in, please? Are we live?
Are we live? So can I start?
Yes, please start, sir.
Great. It gives me immense pleasure to speak today at this global virtual conference on reimagining and transforming the future of law schools and legal education, the confluence of ideas during and beyond COVID-19, organized by Jindal Global University. It is hard to understate the myriad ways in which the present pandemic has transformed our lives. Digital education, once seen as a supplementary option to traditional face-to-face lectures, has now become the primary mode of accessing education. These times have posed challenges for students and faculty alike. I'm sure many of you long to return to campus lives. I still, personally speaking for myself, miss the lectures on the lawns of St. Stephen's College under the cold wintry sun of the late 1970s. Likewise, I do miss the conversations on the Constitution over chai at the Campus Law Center, where I studied law between 1979 and 1982. The problems of the world were ours then, as they should be for all of us now. Memories bring nostalgia, in this case about unpolluted Delhi and so much more. However, these unprecedented times have also revealed our capability to adapt, to be empathetic, and to lift up others, to acknowledge our privilege, and to ask fundamental questions about the state of our society. As the pandemic raged, life as we knew it came to a standstill. The shutting down of industries, shops, schools, and factories exacerbated the stark inequalities that continue to characterize our society. They have revealed the fault lines. Cities witnessed a mass exodus of migrant laborers driven out by their employers or by the landlords. Our health sector was overwhelmed. Many students coming from poor backgrounds lost access to education. Prisons, which also host a large number of under-trials, became susceptible to the breakout of the virus, and more people were driven to joblessness and homelessness. A panoply of freedoms that we ordinarily enjoyed were curtailed to tackle this crisis, the freedom of movement, of assembly, and of occupation. Humanity will weather this crisis, but this is an opportune moment to ask ourselves some profound and searching questions about the state of our society. How, if at all, can we prevent social inequality from becoming magnified in terms of the economic crisis? How can we fulfill our constitutional commitment to an equal, liberal, and democratic order in a market-driven economy? How do we as citizens ensure that our state institutions continue to uphold our civil liberties and promises of equal citizenship in public emergencies and beyond? More broadly, what is the role of courts in the realization of liberal, democratic, and constitutional values? And what role do other actors have to play in this enterprise? How can the citizen, the most critical unit of our constitutional concern, contribute meaningfully in fostering and sustaining a culture of constitutionalism and liberal democracy? Asking these questions is pertinent as we discuss the concepts of constitutionalism, liberal democracy, and enlightened citizenship on the occasion of this Constitution Day. A charge that is often made against the Indian constitutional project is that the Constitution is an elite document. Instead of emerging from popular pressure within the society and being framed by individuals who reflected its full richness and diversity, the argument goes, the Constitution was a creation of India's political elite. The powerful ideas of democracy, reform, and equality, as Sunil Khidlani says in his Idea of India, persuaded a few outside the intellectual and English-speaking circles, and the constitution could never rely on the support of any powerful group. This view was also shared by a few members of the Constituent Assembly. Kengal Hanumantaya, a member of the Constituent Assembly, expressing displeasure on the un-Indian character of the Indian Constitution, remarked, "We wanted the music of the veena or the sitar, but we have the music of an English band." Let us not forget Dr. B.R. Ambedkar's oft-quoted remark that democracy in India was itself a top dressing on an Indian soil, which was essentially undemocratic. Dr. Ambedkar was cognizant that whilst the constitution may be imbued with ideas of liberty, equality, and fraternity, its success would depend on how ordinary people and their representatives would work it. He poignantly pointed out, the working of a constitution does not depend wholly upon the nature of the constitution. The constitution can provide only the organs of state, such as the legislature, the executive, and the judiciary. The factors on which the working of those organs of the state depend are the people and the political parties they will set up as their instruments to carry out their wishes in their politics. Who can say how the people of India and their parties will behave? Everyday encounters of the people with the constitution, including electoral minorities and subaltern groups, challenge the narrative of the constitution being an elite document. It is this engagement of the constitution that provided the basis for Indian constitutionalism to emerge. Constitutionalism has been succinctly defined in 1935 by Walter Hamilton when he says that constitutionalism is the name given to the trust which men repose in the power of words engrossed in parchment to keep a government in order. The Indian encounter with constitutionalism preceded the inception of the Constitution. The Indian nationalist movement, while radical in its normative hopes, was self-consciously a constitutional movement. As a mass movement, it eschewed violence as a means for achieving political goals or for changing the social order. In abjuring violence as a response to the violence of the colonial state, India's constitutional project noticeably diverged from the path to freedom which South Africa adopted, so eloquently spoken of by Nelson Mandela in his long walk to freedom. Post-independence, citizens interacted with the Indian state using the language of the law and constitutional structure to shape its structure of governance. The executive often found itself embroiled in litigation, and citizen interventions led to delays and changes in its policy. In the first decade of the Constitution, political conflicts found their way to courtrooms and became constitutionalized. For instance, a legal challenge was mounted against the ban on cow slaughter, predicated upon the rights to carry on trade, to equality, to property, and to freedom of religion. Rohit Day speaks eloquently about them in his recently published book called The People's Constitution. Liberal democracy in India has emerged from the anti-colonial nationalist movement. The colonial legacy in India included remains of a rudimentary statehood. The post-colonial Indian state was neither a product of an industrial revolution led by the bourgeoisie, nor a result of a revolutionary capture of power by a proletariat or peasantry. Rather, the dominant political class consisted of a middle class that was adept at power sharing through competition and collaboration. The Constituent Assembly presented itself as a guardian of national interest, which transcended sectarian or regional interests. The framers of the Constitution chose to set out the basic norms that would form the governing ideology of the state in the form of a liberal democracy. Liberal democracy is both prescriptive and descriptive. It consists of a set of political practices which include popular elections, accountable government, and majority-based decision-making. But it is also founded on a set of key principles: liberty, equality, and fraternity. The framers of the Constitution recognized that the commitment to a liberal democracy is necessary for the continuance of democracy itself. Dr. B.R. Ambedkar remarked, "What should be the policy of the state? How the society should be organized in its social and economic side are matters which must be decided by the people themselves, according to time and circumstances. It cannot be laid down in the Constitution itself because that is destroying democracy altogether." How prescient Dr. Ambedkar was. At the same time, our framers recognized that for our Constitution to endure and our liberal democracy to survive, the state must fulfill its duty of ensuring an equal distribution of resources and welfare for all. It has to eliminate institutional and societal barriers imposed on individuals and groups that prevent their self-actualization and their ability to fully participate in our vibrant democracy. To forestall any violent upheavals and ensure the resilience of constitutional methods for expressing discontent, the state must remain committed to achieving equality and protecting its minorities. As Justice Subbarao presciently reminded us, a constitution is only permanent and not eternal. There is nothing to choose between destruction by amendment or by revolution. The former is brought about by totalitarian rule, which cannot brook constitutional checks, and the other by the discontentment brought about by misrule. If either happens, the Constitution will be a scrap of paper. As former American President Barack Obama said in his farewell address at the White House on 10th January 2017, the most important office in a democracy is the office of the citizen. Enlightened citizenship requires people's participation in interpreting the Constitution, in imbuing it with meaning, in making it their own. Our Constitution, like others of its genre, is a mobilizational tool for social movements. Its values provide a unifying force in recognizing, acknowledging, and respecting our diversity and plural culture. It is a powerful moral register. The ability of the Constitution to inspire citizens' movements is unique. In doing so, it ensures that we cannot overlook the importance of citizen interpretive practices. The Constitution does not solely belong to lawyers and judges. The Constitution's aspirations and transformative vision transcend legalistic formulae and esoteric legal debate. The vision and aspiration of the Constitution is captured in its preamble. While the preamble is not legally binding, it performs a far more important task, that of imprinting into our constitutional consciousness the values of justice, liberty, equality, and fraternity. As long as we view the preamble as our guiding light and continuously strive to make its promise come alive, our country will remain firmly on the path of a constitutional liberal democracy. It is the people's engagement with the Constitution which breathes life into the Constitution's founding creed. We, the people of India, do hereby adopt, enact, and give ourselves this Constitution. The people's faith in our Constitution's transformative potential has been made manifest in the way several marginalized groups have used constitutional vocabulary as a basis to seek empowerment and advancement. These groups include under-trial prisoners, bonded and migrant laborers, scheduled castes and scheduled tribes, women, members of the LGBTQ community, slum dwellers, pavement dwellers, and the disabled. They often seek extraordinary remedies. Their pleas for intervention challenge received conceptions of separation of power and call into question the distinctions between administration, legislation, and adjudication. As I shall argue in this segment of my presentation, however, it would be incorrect, both in terms of constitutional doctrine and social history, to regard courts as the exclusive avenue for the realization of legal entitlement and the attainment of constitutional aspirations. Let me be very clear. Courts do have a vital role to play in preserving liberal democratic values and in fostering a culture of constitutionalism. But the process of realizing constitutional rights is more complex than a lawyer's vision of legal strategies would lead us to foresee. Courts are but one actor involved in the constitutional project. A vital actor, yes, but one whose role must be understood. This having been said, let me now dwell briefly on the extremely important role that I do envision courts playing in furthering democratic values and a culture of constitutionalism. Justice Edwin Cameron of the South African Constitutional Court makes a perceptive observation when he says, if we accept the limited value of legal rights, if we accept that the law is an adjunct social instrument, that it cannot mend society, nor choose its pathways, and that its remedies and rhetoric should be approached with skepticism, then we may nevertheless be able to defend a modest role for it. The interaction between courts and social change is a much studied phenomenon. Lanny Guinier and Gerald Torres argue that a new statutory or judicially determined right alone is neither self-enforcing nor culture shifting. Rights alone are unable to offer us an enforceable set of policies or a vision for the better society. It is imperative, therefore, that a declaration of rights be connected with remedies as well as to the lived experience of those on whose behalf they are named. Well-organized social movements help expand the law's reach beyond the sophisticated legal grammar of formal fairness to the transcendent commitments of justice. When this happens, the language of law is stretched to accommodate the language of the people, especially those who act collectively to strengthen our democracy. This phenomenon is also captured by Richard Posner, a judge of the US Court of Appeals for the Seventh Circuit. Posner analogizes the change of view by courts to boiling the frog. The underlying idea is that if you put a frog into boiling water, it will jump at you immediately. But if you put it into warm water and gradually increase the temperature, you can boil it effectively. Worse still, if you throw both the judge and the frog into boiling water. The point is simply this. As a part of society, courts through their judgments serve as a prism through which the existing societal view on a given issue is refracted. Take the celebrated case of the American Supreme Court judgment in Obergefell versus Hodges, for instance, in which the court recognized that the same-sex couples have a constitutional right to get married. Justice Kennedy, who wrote the court's majority opinion, held that the nature of injustice is that we may not always see it in our own times. When new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. Absent appropriate social conditions, judicially driven social change may close off the possibility of a much more ambitious reform. Commenting on the judgment in Roe versus Wade of the US Supreme Court and its analysis of the woman's right to abortion, Justice Ruth Bader Ginsburg noted that the political process was moving not swiftly enough for advocates of quick and complete change, but majoritarian institutions were listening and acting. Heavy-handed judicial intervention was difficult to justify and appears to have provoked and not resolved the conflict. In saying what I have, I do not intend to abnegate a constitutional court's counter-majoritarian role, far from it. Indeed, for discrete and insular minorities whose concerns are not addressed through the political process, courts may often be the only forum for the realization of their rights. Even if the legal recognition of rights does not change the immediate reality of those oppressed, it vindicates their struggles and provides them a sense of entitlement and belonging. As Oishik Sirkar has remarked, symbols of emancipation are not mere bourgeois vanity. They have real affective consequences. However, the point which I make is this: a clear-eyed assessment of the Supreme Court's functions, of the limits of what it can do, and of the constraints, doctrinal and procedural, that inform its functioning, can help us ensure that as citizens, we channel our energies in seeking societal reform through multiple fora rather than just through the courts. Endowing courts with the expectation that they are the sole repositories of the project of bringing about social change is unrealistic. It will breed cynicism about unrealized hopes. This having been said, let me now share a few examples of cases that aptly demonstrate the vital role that courts can play in fostering the growth of constitutional and liberal democratic values. In cases and controversies brought to the court evidencing a deprivation of constitutional and legal rights, the Supreme Court of India has not just the power, but the mandate to interfere. Let me share two fairly recent examples with you from the cases of the Gujarat Mazdoor Sabha and the state of Gujarat and B.K. Pavitra and the Union of India. In Gujarat Mazdoor Sabha, we had to rule on the legality of a notification issued by the government of Gujarat on 17 April 2020 during the pandemic. The notification, projected as a measure to deal with the pandemic and the financial crisis, had the consequence of increasing the upper limit of working hours for labor from 9 to 12 per day and from 48 to 72 hours per week, of shortening rest intervals and of halving the overtime pay. We struck down the notification and ordered that the workers should be paid back wages for their overtime work in exercise of the power given to us by Article 142 of the Constitution. Significantly, we noted that the basic rights of workers could not be reduced to mere paper tigers. We grounded the guarantee of working hours and the embargo on overtime in Articles 21, the right to life, and Article 23, the prohibition of forced labor in the Constitution. We held that the government's notification evidenced an intent to capitalize on the pandemic to force an already worn down class of society into the chains of servitude. This case is a clear example of the court using rights as a benchmark to assess the legal validity of executive action and discharging its solemn obligation as a sentinel. While the Supreme Court must equally render justice to all those who appear before it, it is duty-bound, consistent with the scale of values enshrined in our Constitution, to exhibit greater sensitivity to those at the bottom of the social and economic hierarchy. In this role, the court has to act as an oversight body to ensure that executive action does not result in constitutional rights being sacrificed at the altar of market forces. As we noted in the judgment, the Factories Act attempts to neutralize the excesses in the skewed power dynamics between the managements of factories and their workmen by ensuring decent working conditions dignity at work, and a living wage. Ideas of freedom and liberty in the fundamental rights recognized by the Constitution are but hollow aspirations if the aspiration for a dignified life can be thwarted by the immensity of economic coercion. The framers of the Constitution realized that to uproot caste-based inequality, the state intervention in the nature of affirmative action is indispensable. In B.K. Pavitra versus Union of India, we found ourselves tackling negative stereotypes against the merit and efficiency of the scheduled castes and scheduled tribes, their candidates, couched in the seemingly neutral language of law and legal argumentation. Underlying our judgment was the recognition that assumptions about efficiency and merit cannot be divorced from social and economic privileges that have accrued to the forward castes and the centuries of deprivation and discrimination suffered by the members of the scheduled caste and scheduled tribe communities. More concretely, in this case, we had to determine if the government of Karnataka's policy of granting consequential seniority to scheduled caste and scheduled tribe candidates was constitutionally permissible. In concluding that what was relevant was the satisfaction of the government as to whether there was inadequate representation for the reserved communities in the services under the state, we held that the principle of substantive and not formal equality underlay the Constitution's equality code. We also construed the idea of efficiency of administration in this light. We held that efficiency cannot be based on a stereotypical assumption that promotees from the affirmative action group of citizens drawn from the scheduled castes and tribes are not efficient or efficiency is reduced by appointing them. We held efficiency of administration in the affairs of the union or the state must be defined in an inclusive sense, where diverse segments of society find representation as a true aspiration of governance by and for the people. If this benchmark of efficiency is grounded in exclusion, we noted, it will produce a pattern of governance which is skewed against the marginalized. If this benchmark of efficiency is grounded in equal access, our outcomes will reflect the commitment of the Constitution to produce a just social order. To take yet just another example, a recent example, in the Hathras rape incident that shocked the conscience of the nation, the Allahabad High Court took suo motu cognizance of the incident and framed for its determination the following question: whether the economic and social status of the deceased family has been taken advantage of by the state authorities to oppress and deprive them of their constitutional rights. The matter being sub judice, it would be inappropriate for me to make any substantive comments about the case at this stage. However, I cite this example only to drive home the importance of judicial intervention as a bulwark against the exercise of state power that militates against the key principles that the culture of constitutionalism in our country is based on. In the same vein, social action litigation has served as a powerful tool to correct deficiencies in government delivery and to protect the interests of those at the receiving end of repression, administrative inefficiency, and absence of legal protection. In order to realize the full potential of this unique form of intervention which has been developed in India, public-spirited citizens need to determine how to bring forward petitions that are well-focused and narrowly tailored. To be more concrete, I mean litigation that is based on strong evidence and arguments that form the basis for seeking the court's intervention. Litigation that is based on broad stakeholder consultation and genuinely represents the voices of those on whose behalf it is brought forward. Only in this way can we persuasively counter the well-founded concern that social action litigation is being transformed from an instrument to empower the impoverished and neglected into a means to entrench and exacerbate existing social inequities. as Arun Thiruvengadam has argued, organizations pursuing social causes should be facilitated in developing a bottom-up litigation strategy so as to mark a return of the foundational roots of PIL. In fact, the foundational days of PILs, it was social entrepreneurs, far more than lawyers, who approached the Supreme Court pro bono with social causes. To realize the liberatory potential of PILs, judges and lawyers should play a facilitative role, with the focal point of the litigation being public-spirited petitioners and the constituency that they represent. For we must remember that it is their lived realities that PILs are principally meant to address. A high point of this form of social action litigation is the Nalsa judgment, which upheld the right of self-identification of one's gender and laid down guidelines to promote the rights of transgender persons. The judgment was a culmination of active participation from the constituency affected by state repression, which, it can be hypothesized, led to a beneficial outcome. There are examples also of locally and culturally rich movement involving demands of state-enforced rights. Litigation and call for legislative reform in such instances were accompanied by non-legalistic initiatives. In Tukaram versus State of Maharashtra in 1979, the Supreme Court had acquitted 2 rape-accused policemen because the victim did not raise an alarm and there was an absence of injury marks. The judgment created an uproar. 4 law professors, including the legendary Professor Upendra Bakshi, my own guru, who is present with us today, had written to the then Chief Justice of India criticizing the judgment. 4 years of sustained protest led to a change in the criminal law in 1983, which laid down the need to establish a woman's consent and raise the punishment in custodial rape cases. Another interesting example is that of the Dongriya Konds living in the peaceful and inaccessible Niyamgiri range, which is rich in bauxite. A refinery sought to exploit this resource. Stringent environmental regulations were violated in a bid to acquire the land without Dongriya's consent. On April 18, 2013, the Supreme Court gave a clear verdict that mining clearance can be only granted if the Dongriya's consent. This led perhaps to India's first environmental referendum, which required mobilization within the Dongriya community in 12 villages who collectively rejected the proposal. The tussle between indigenous populations who have for centuries owned and managed land, territories, and resources, and the market also exists in other jurisdictions. In Australia, the Aboriginals and Torres Strait Islanders have struggled for years to gain territorial rights and have engaged in battles with mining industry over resources. We need to respect the relationships of reciprocity and kinship that indigenous people have with their land. Their unchecked displacement and dispossession are a matter of grave concern. As the Supreme Court has observed, a development paradigm depending largely on the plunder and loot of natural resources, more often than not, leads to failure of the state, and that on its way to such a fate, countless millions would have been condemned to lives of great misery and hopelessness. A critique of judicial intervention that has recently begun gaining currency is that judicial review is unable to interrogate or dismantle existing societal conditions in which litigation is brought. In the context of human rights litigation concerning access to medicines, for instance, Amy Kapuscinski argues that such litigation does not prevent or help answer the question of why such medicines are profoundly expensive in the first place. She argues that litigation may in fact have a plausibly regressive net effect. This critique also applies to the inability of litigation to question social relations of capital, patriarchy, heteronormativity, ableism, and caste hierarchy. Further, not every citizen can make equal use of legally guaranteed rights. as the popular saying goes, there is far too much law for those who can afford it, and far too little for those who cannot. We must also remember that legal intervention is often necessary, but not sufficient. As Ratna Kapoor argues, while human rights are something that we cannot not want, they cannot give us what we want. Take the decision of the Supreme Court in Navtej Johar, for instance. While our verdict helped transform LGBTQ citizens from unconvicted felons to full and equal citizens in Indian democracy, they still face the prospect of prosecution under public nuisance laws. We have seen that in cases involving two women partners, the parents of one of the partners would accuse the other of kidnapping or abduction. The project for the realization of their full humanhood has just begun. The baton now passes to society in a long walkathon. Courts cannot just make broad declarations of rights without being cognizant of the practical implementation of their decisions or the unintended consequences that a decision might produce. This is not to say that judicial intervention should not take place in such cases. It is only to say that the court needs to be conscious of its institutional limitations. For judicial intervention that is not well thought out can have a counterproductive effect of setting the movement back. There are ways in which courts can make a meaningful contribution whilst being cognizant of their institutional limitations. It can set in motion a thought process for reform. It can adopt dialogic remedies. It can use social action litigation as an instrument to broaden the conversation and provide voice and representation to individuals and groups whose interests might otherwise be ignored in decisions impacting them. At the same time, the court can ensure that it plays a facilitative role without dominating the conversation in society. Richard Bellamy, in his celebrated book titled Political Constitutionalism, A Republican Defense of the Constitutionality of Democracy in 2007, notes that the increasingly dominant view is that constitutions enshrine and secure the rights central to a democratic society. According to this view, which Bellamy describes as legal constitutionalism, a constitution of this kind, not participation in democratic politics per se, offers the basis for citizens to be treated in a democratic way as deserving of equal concern and respect. Roberto Unger remarked that discomfort with democracy is one of the dirty little secrets of contemporary jurisprudence. Bellamy has launched a defense of political as distinct from legal constitutionalism. Criticizing the overarching importance ascribed to judicial review, Bellamy observes, far from guarding against a largely mythical tyranny of the majority, the checks imposed by judicial review on majoritarian decision-making risk undermining political equality, distorting the agenda away from public interest, and entrenching the privileges of dominant minorities and the domination of underprivileged ones. As such, legal constitutionalism can produce rather than constrain arbitrary rule, detract from the rights protection of weak minorities, and damage the rule of law in both the formal and the substantive senses of treating all as equals. In his view, democracy provides a form of political constitutionalism which is superior to legal constitutionalism or their devices that are proposed as constraints upon it. While I, as a judge, may not go as far as to accept the pristine thesis of Bellamy in rejecting the value of judicial review, and I don't accept that thesis, it does emphasize the importance of the democratic process in the working of the Constitution. For, as he says, the democratic process is both constitutional, offering a due process, and constitutive, which is able to reform itself. As former South African Constitutional Court Judge Kate O'Regan notes, courts can be forums for a reasoned debate on contested issues of social and public policy. Illustratively, in the Mazibuko case in the South African Constitutional Court, at issue was the question as to whether the government's free water policy was constitutional. She held that such litigation fosters a form of participative democracy that holds government accountable and requires it to account between elections over specific aspects of governmental policy. In conclusion, let me say that over the past 71 years, as a constitutional democracy, we have traversed a long distance. The terrain has been uneven. We have transformed the ideas of democracy and constitutionalism from foreign dressings on an Indian soil into something authentically and uniquely Indian. Our institutions of governance, albeit imperfect at times, have been transformed under the glare of public scrutiny. In 1997, Indian-American political commentator Fareed Zakaria wrote an influential essay in Foreign Affairs titled The Rise of Illiberal Democracy. Zakaria argues that democracy and liberalism do not inevitably go together. He highlights that what sustains democracy is not simply legal safeguards, but rules, norms, and practices, democratic behavior. After the mammoth task of drafting the American Constitution had been completed, some citizens asked Benjamin Franklin whether the form of government chosen by them was a monarchy or a republic. A republic, replied Dr. Franklin, if you can keep it. In this popular story is an extremely important message for us. Much as it is important for courts, the media, civil society, and vigilance agencies to exact accountability from the government and to ensure that the Constitution remains the guiding light in all that we do, it ultimately falls on each of us as citizens to participate in the slow but vital everyday task of transforming our Constitution from a charter of aspirations to a reflection of reality, and in ensuring that we continue to learn from our mistakes and keep the democratic spirit alive. As I have argued here today, in this project, courts and the law have an important role to play. In closing, I would like to share the reflections of judges from the apex courts of South Africa, the US, Canada, and Australia that speak to the importance of law in creating a better society. As Justice Cameron says, the law cannot offer transcendence from human toil and limitation, but it can offer us the chance to be better than ourselves. And that is surely something worth celebrating. In the same vein, Justice Ruth Bader Ginsburg has the following message for all young people about the power of the law. And she says, I would like them to have the enthusiasm that we had in the 1970s, determining that the law should catch up to the changes that have occurred in society, the realization that no one should be held back, boy or girl, because of gender, artificial gender barriers, that everyone should be free to be you and me. Justice Beverly McLaughlin, the former Chief Justice of Canada, says, like every other human institutional endeavor, justice is an ongoing process. It is never done, never fully achieved. Each decade, each year, each month, indeed each day brings new challenges. Finally, Justice Michael Kirby, the great friend of India that we have, says, law is not just an ordinary occupation. It is not a mechanical job. It is a vocation committed to justice. It is one fundamentally dedicated to the principles of human dignity and human rights. We cannot always deliver on the promissory note to that effect. Sometimes, indeed, the check is dishonored by Australian law. But as lawyers and citizens, we have choices. And when it is possible and lawful to do so, we should take the path of justice and equality. Today, I've tried to emphasize the vital role that each of us can play in contributing to deepen and broaden the reach of our Constitution's empowering vocabulary in avenues inclusive of but not focused exclusively on our courts. The framers of our Constitution laid down the cornerstone to create a legal and institutional infrastructure to promote a culture of constitutionalism and liberal democracy. It now falls on each of us to play our part in ensuring, to paraphrase Dr. Franklin's remark, that we keep it that way. Thank you very much for giving me this opportunity, Professor Rajkumar. And thank you, Professor Bakshi, for joining us and for listening to me this morning, and to all of the participants at this Constitution Day lecture. Thank you very much.
Thank you. Thank you very much, Justice Chandrachud, for a fascinating tour de force on the evolution of the principles of constitutionalism, liberal democracy, and indeed enlightened citizenship. Before I call Professor Upendra Bakshi to share his reflections, I want to also recall this unique occasion we are marking. I also want to reflect on an extraordinary speech that Dr. B.R. Ambedkar, the chairman of the drafting committee of the Constituent Assembly, gave on the 25th of November 1949. And of course, many of us who are students of law, we recall that speech while we teach our students. But it's quite remarkable that he had this prophetic imagination about what could potentially be the future, and was very conscious of the state in which we were at that time. He talked about three critical aspects of the kind of, let's say, pitfalls that the young democratic evolution that India was about to witness. And the first was about what he called the case against revolution and the grammar of anarchy. And I quote, he said, if we wish to maintain democracy, not merely in form, but also in fact, what must we do? The first thing in my judgment we must do is to hold fast to constitutional methods of achieving our social and economic objectives. It means we must abandon the bloody methods of revolution. It means that we must abandon the method of civil disobedience, non-cooperation, and satyagraha. And then he goes on to say, when there was no way left for constitutional methods for achieving economic and social objectives, there was a great deal of justification for unconstitutional methods. But where constitutional methods are open, there can be no justification for these unconstitutional methods. These methods are nothing but the grammar of anarchy, and the sooner they are abandoned, the better for us, unquote. Of course, the second aspect of the concern that he expressed quite deeply, and many, many who believe in ideas of constitutionalism have talked about it, which is the notions of hero worship, bhakti in politics, which of course potentially leads to dictatorship. And he quotes, he says that there is nothing wrong in being grateful to great men who have rendered lifelong services to the country. This caution is far more necessary in the case of India than in the case of any other country. For in India, bhakti, or what may be called the path of devotion or hero worship, plays a part in its politics unequaled in magnitude by the part it plays in the politics of any other country in the world. Bhakti in religion may be a road to the salvation of the soul, but in politics, bhakti or hero worship is a sure road to degradation and to eventual dictatorship, unquote. And of course, the third, he made a very strong case for social democracy, where he talked about the fact that we need to, underline the principles of equality, liberty, and fraternity. So I want to say that just to, bring home the larger point that Justice Chandrachud mentioned in his lecture, which is that the delicate and critical and symbiotic relationship between constitutionalism, liberal democracy, and enlightened citizenship. With those words, I would like to express my heartfelt gratitude, deep appreciation for Justice Chandrachud for having taken time on a regular court day to actually come early and deliver this lecture. I would immediately request Professor Upendra Bakshi, who does not need any introduction, but more importantly, besides being a great scholar of jurisprudence and constitutional law, has been one of the world's great public intellectuals in the field of law and beyond, to share some of his reflections on the Constitution Day. Professor Bakshi, over to you.
Thank you, Raj, and
Greetings to all the colleagues who assembled today at this conference. This is a very unusual law day. It occurs during two major events of life, both of which threaten human existence and perhaps civilization, namely Anthropocene and what we are more familiar with immediately, COVID-19. And in this context, to hear Dr. Justice Chandrachud is a sheer pleasure. And then I have an extended footnote from Bedka, from Rajkumar. It's a feast of ideas, and I do not wish to, I cannot possibly add to what you said. Excepting when you hear Dr. Justice Chandrachud, you take two takeaways from what he has said. It is for me. One is how a progressive judiciary can empower enlightened citizenship. I think that's a wonderful message and elaboration in his talk, which we should all read carefully. And second, following on from what you said, Raj, is the question of a false choice. An enlightened citizenship must reject two false choices. One, choice between political authoritarianism and human security. And second, as Justice Chandrachud indirectly said, between judicial despotism and enlightened citizenship. Both are false choices, and one has to progress to the notion of enlightened citizenship in a way that avoids this danger. And I think it's been very well said. I will make about 3 points, and then when my time is up, you tell me. And I shall do them very briefly. Talking about both climate change and COVID and the relation between the two, our Supreme Court has done wonders, and so have the 19 high courts in dealing with COVID situation, as we all know. And more strength to their elbow, because then we need both the courage of conviction and a sense of balance in dealing with the issues of right to health, public health, and collective security. And they have shown how this is done. It's very important that we're doing that. I, first of all, assume that we know all that is been known about COVID. I doubt whether we know, or we can equally safely assume that we know all that we should about Anthropocene. In fact, Anthropocene and COVID present to us differently though. In short term, one in short term, one in long term, but a common threat to human existence, which I would like to call as jurisprudence of extinction. Both COVID and Anthropocene bring to the doorstep threats to collective and individual life and to enlightened citizenship. And these threats have to be abiding in one case, that is of Anthropocene, perhaps less so, I hope, in COVID. We know facts about Anthropocene and number of greenhouse gases, global warming, glaciers melting, vanishing species and ecosystems, Amazon fires, climate refugees, longer carbon footprint, erosion of tank and subterranean water, changes in stratosphere and biosphere. We know all that. We also know that 97% of scientists agree that there is something called anthropogenic harm, and it is steadily increasing hour by hour since 1950. And therefore, there is agreement among scientists as to the fact of this harm occurring. There is difference of opinion on measurement and models, and the difference of opinion is significant, but is confined to 3% of scientists, and that's important. What is most unfortunate and completely avoidable is climate change denialism. That such a phenomenon as climate change has at all happened. This denialism is, I believe, a crime against humanity and should be proclaimed as such, because it is furthering and promoting jurisprudence of extinction. The second crime against humanity, which we should all develop, help develop, is the environmental authoritarianism. That the state alone or the leader alone can fulfill the task of collective human security in the face of Anthropocene is wholly and egregiously erroneous. It is the task of governments and people together to fight this extinction of species and extinction of human life. And therefore, authoritarian environmentalism is also a crime against humanity, which forbids making security as security risk the idea of dissent or free speech, or which criminalizes difference, human difference, which is unavoidable in human society. And thirdly, we should also try freely to declare, as a group of responsible citizens everywhere should declare a new order of relationship between global business and global human rights. And the present corporate neanderthalism should not anymore rule us. It should in fact be declared as a crime against humanity. How far legal research and legal education can promote a milieu in which these crimes against humanity are developed and concretized is, I think, a task heavily before us. I will now turn to what is to be done and where do enlightened citizenship comes in and end with that. In a sense, both COVID-19 and Anthropocene speak to what the Ghanaian thinker, the great Ghanaian thinker, Claude Aki, I think his name was, in 1994, he wrote a book called The Democratization of Disempowerment. He talked about Africa, but both COVID and Anthropocene have brought this to our notice very sharply now and for the whole world. How are these to be dealt with? And I'll go back to one man, one person only, and that chap is called Mohandas Karamchand Gandhi. I find Gandhi, we all find Gandhi as a politically ambiguous name, last name, so I avoid the word Gandhi. Karamchand I avoid because, as I often said, it is appropriated by television espionage serial, so we are left with Mohandas. So I call simply Mohandas and Mohandas Jin. So Mohandas said three things which are relevant with this end. One thing he said, that we must think about, we must link always, we must realize the connection between always global citizenship and enlightened citizenship of democracy. In other words, we can't be citizens of a nation or a society without at the same time being citizens of the world. And he said he learned this from his illiterate grandmother. The grandmother has a great role in human life. He also said, as you no doubt know, secondly, that the world is a huge family. Ancient Indian notion of Vasudhaiva Kutumbakam. And he also said, thirdly, and that's my last point, and he said, very simply, he said, be the part of the change you wish for. There is not enough. There is enough for human needs, he said, but there is never going to be enough for human greed. So neither the ease of doing business index or the great happiness index, national gross happiness index, or transparency and accountability index, all the indices, none of these will enable us to fight extinction. What we need is a return to Gandhian thought and action. And he was the pre-industrial critic of industrial civilization. And he is the pre-Anthropocene critic of the Anthropocene. And that, I think, with which I must now end, because Professor Patnaik has to say a few words. But my time is up, but I do say what we need is ancient wisdom to fight modern menaces like Anthropocene and COVID. And in what does that wisdom consist? It consists, if I may phrase it in a oxymoron, it consists in the need to be ab-original rather than original. The greatest challenge before legal education, legal research is to stop being original and to start being ab-original. Thank you very much, Raj. Thank you.
Thank you. Thank you so much.
Thank you very much, Professor Bakshi, for that truly, truly insightful presidential address. Ancient wisdom to fight modern menaces. That is beautifully put. And thank you for putting the conversation in the context of this jurisprudence of existence, as you put it, with the threat of Anthropocene and COVID, and this environmental authoritarianism as a crime against humanity. So thank you very much. Thank you very much for that truly insightful presidential address. What I take away from that address, Professor Bakshi, is something that Honorable Justice Chandrachud also has highlighted in his address, is that be the part of the change that you wish to see. And perhaps that brings us back to the question that Justice Chandrachud raised at the very beginning of his talk, is that how do we as citizens ensure that provisions of citizenship are ensured? And it actually brings me back to Dr. B.R. Ambedkar, who, as Professor Raj was talking about his speech at the Constituent Assembly. And he, in the same speech, actually put the responsibility squarely on the shoulders of we the people. He said it is a responsibility of the we the people to create a compassionate society. He said, with the British gone, we have no longer have anybody else to blame. It is our responsibility. And while we do recognize that India in the past 71 years, have been treading a rough path, battling social, political, economic inequalities on one hand, and this dream of liberty, equality, and fraternity as enshrined in the Constitution on the other, I think going back, the responsibility again falls squarely on our shoulders as citizens, as students of law, to take this mission forward. With that, I would like to extend my heartiest gratitude on behalf of OP Jindal Global University to Honorable Justice Dr. D.Y. Chandrachud for joining us, for accepting our invitation, and delivering the Constitution Day lecture. We are truly grateful for your presence here with us today. Thank you very much. A big thank you once again to Professor Upendra Bakshi. Thank you for always being there and mentoring us, guiding us, and infusing us with new ideas. A heartiest thank you to Professor Dr. C. Rajkumar, our founding Vice Chancellor, for his constant support, guidance, and mentorship. With that, we conclude this Constitution Day lecture. I would just like to announce that we now have a break and our next session will start at 10:30 a.m. Thank you all for joining in. We look forward to having your continued participation in the rest of the session. Thank you very much.
Thank you very much. Thank you.
Thank you very much. Bye. Thank you.
Good morning from India. Good afternoon to our friends in Southeast Asia. Good evening to our friends in Australia. It's an absolute pleasure for me to welcome you all to the second day of the Global Virtual Conference on Reimagining and Transforming the Future of Law Schools and Legal Education. We are into the 12th thematic session of this conference on the theme, Setting Digital Classrooms to Facilitate Teaching and Learning. We have with us a very distinguished group of individuals, leaders in their own right, representing both academia as well as the profession. Let me introduce briefly then. We have with us Ms. Gauri Gokhale, partner of one of India's leading law firms, Nishin Desai Associates, and also honorary adjunct professor at Jindal Global Law School. We have Professor Dr. Trish Mundi, Dean of the School of Law at the University of Wollongong, Australia. Professor Andrew Lynch, Acting Dean of the University of New South Wales Law School, University of New South Wales, Sydney, Australia. My own colleague, Professor Jeremy Wade, Associate Professor of Practice, and also Director of the Office of Academic Planning and Innovation at OP Jindal Global University. And also our moderator for this session, Professor Dr. Manveen Singh, Associate Professor and Associate Dean of Jindal Global Law School, OP Jindal Global University. Part of the session, although behind the scene, and I'm going to hand this over to Dr. Manveen Singh to take it forward. Thank you.
Thank you, Professor Raj.
Thank you.
A very warm welcome to all my panelists for this 12th session. Without much ado, I'll straight away come to probably one of the most interesting aspects of this entire period involving a global lockdown caused by this pandemic. Now, one of the most overt and overriding impact of the pandemic on individuals and institutions has been the increased reliance on technology. Across the globe, different sectors, including the legal sectors, have adapted to the virtual mode of working, and the present session is evident enough of the fact that we are all sitting in an environment where we are connecting from across the world with each other through this virtual mode of technology. Now, legal education, along with the other sectors, also has had to adapt to this change, to this transformation. And this overnight transformation to the online mode of education has brought digital classrooms to center stage. Now, as we make this transition from the physical to the digital classrooms, the question is, how does one overcome the pedagogical differences between the two? We have legal aid clinics, we have had workshops, we have had the most important aspect of legal education, that is moot courts. Now, considering that they are fundamental to the study of any law degree, how can we ensure a continued experiential learning for students? Do digital classrooms represent actually the future of legal education? Now, to answer this question, I would first like to invite upon Professor Mundi for her first thoughts, and then I'll jump to Professor Lynch and then Jeremy. Professor Mundi, please.
Thank you, Dr. Singh. Lovely to meet you all and welcome everyone. Look, I think I share probably a very similar experience with much of the legal education sector, and certainly, we've seen a massive change in how we are delivering our law degree at the University of Wollongong. I guess particularly in terms of how we think about pedagogy in the context of the digital classroom, for me in leading, I guess, the change to online or remote learning at the University of Wollongong and the law school, that really I think you need to start very much still with what are the particular subject learning outcomes that you are needing to meet, and what is the appropriate pedagogy in this new environment, in this new remote online environment that will best achieve that. So just as we do in face-to-face contexts, I think we need to keep always the subject learning outcomes of what it is we're trying to achieve in mind. So keeping that in mind when we're talking about experiential learning and where that sits within within legal education, I think there are certainly added challenges when you are talking about things like, moot courts or workshops or those sorts of things. It's not impossible, but I think that there are additional challenges for sure. From my perspective, I think a balance between face-to-face and online is most ideal. I don't necessarily see that, we want to fully move online in terms of these experiential learning experiences. But this year we've had to do that, and we've certainly positioned the work that we've done in experiential learning in an online format. For example, through moot courts, we've positioned that really, I think, as new experience or key skills that are needed for students as we move forward. So we've seen throughout the world and in Australia that courts, for example, are moving online. So it's really positioning new skills for students in gaining skills of advocacy online, in using technology, and helping them to experience these new technologies more positively and placing them within the context of professional practice. I think for me, that's how we've framed it this year. Yes, we have to do this, but there are ways that and reasons that we can do it and make it a meaningful one for students.
Right, Professor Mondi, thank you so much. Professor Lynch, would you like to come up with your first thoughts?
Certainly, thank you, Dr. Singh. So I'd agree with what Trish has just said. Very similar reflections actually in terms of the necessity in 2020, but trying to put that into a larger frame when engaging students as to what we were doing and the benefit of it for them. And I think the focus really needs to be on, and I expect I'm going to repeat this idea a lot today because I've thought a lot in the last couple of months about this, which is to think about the principles of the legal education that you're trying to provide and less about the platforms or the modes. And
I think somebody used the word that, going extra mile to be that extra energy that you will need is something, the student should be sort of getting accustomed to, and also, be able to sort of last minute, if something goes wrong, how to handle that situation in the technological scheme of things, because, it's not always, that things work excellently, insofar as technology is concerned. So, these are the, sort of real life experiences I thought I should share in the context of virtual courtroom. And I do have some additional points which probably we can, deliberate later.
Sure. Oh, that's absolutely wonderful. And I must say, I might just add to what you just mentioned. Not only do students have their task cut out, but I must say, teachers have their task cut out. Because the onus is upon the teachers to train the students in a manner which allows them to take care of all that you mentioned in a virtual courtroom. That is the absolute necessity of legal education in today's date. I'll now kind of also try to touch upon these diversities that are there across different geographical locations and different countries, because the pandemic does not distinguish between nations, nationalities, cultures, and communities alike. The effect has been pretty much the same across different institutions, across different people belonging to different backgrounds. Now, in such situations, we cannot keep the universities out of the domain. Some universities are better equipped to deal with such a pandemic, whereas others might not be that well equipped. Now, what, in the opinion of the panelists, can actually be done to enable such institutions to effectively respond to the challenges of digitalization? Because the key is to move to this culture of digitalization. Everything is digital. ranging from books to study materials to recordings to a submission of assignments, so on and so forth. So, Professor Lynch, would you like to come in here and talk a little bit about these aspects of the diversities and how institutions are able to cope up with all of this?
Sure, and thank you for the question. And I think, we could tackle this in a number of ways. I do think that each institution needs to make some key decisions for itself, and growing out of the conversation we've already had. I think Jeremy's point about, identifying what are the technological platforms that you want to use and that you see as most suited to the legal education that you're wanting to provide is really key. One of the things that happened in 2020 was that there was, a very quick scramble towards an online environment for students. But across the institution, well, certainly my institution, everybody reached for different things, Zoom, Teams, other platforms, collaborate on Moodle and things like that. And the student feedback was to say, all of these have their pros and their cons, but the thing we really want is consistency. So we actually find it quite a confusing environment if different teachers use different technology, never mind what they actually then do with it. And I think guiding those choices need to be a return to what are the pedagogical principles that underpin the legal education that you're seeking to provide. So those, I think, are internal conversations. But I took your question to be broader, Dr. Singh, and really to be around, well, how can we, given the commonality of this experience, how do we share resources and how do we work towards, a sense of legal education in a digital format, as well as clearly, I think, face-to-face teaching, but how do we optimize the capacity of each institution? And I think, resources and accessibility are a big part of this. There are some enormously wealthy institutions across the globe, and then there are others who are also needing to maintain their programs at a time like this with fewer resources. And it seems to me there's a great amount of to be gained by sharing, firstly of experience through occasions like this one, which Jindal brings together people to really talk about what we're doing right now and to learn from different perspectives. But also then I think of content, and I think of the way in which assessment and content can be exchanged between academics who are working in similar areas, if not with a view to simply replication or rolling out, but a borrowing of ideas. And the wonderful thing around this experience has been the connectivity that it's provided. And it seems to me that we're only just on the threshold of really taking optimal advantage of that to, engage in a much more collaborative global project around legal education. And that's what I would hope to see us moving towards.
Right. Absolutely. I completely second what you just mentioned there. And on that note, Professor Mundi, I would want you to kind of add to this aspect of how universities in general and institutions at large have been able to cope up with this sudden transition and make sure that that lag is not there. You can easily make that transition smoothly. Professor Mundi, you are on mute, I think.
And still, 12 months later, we still have to unmute and tell people to unmute. Sorry, Dr. Singh, could you just repeat the focus of the question you'd like me to respond to?
Yeah.
Something similar that you put to Professor Lynch, or are we was there a slightly different focus?
Correct. So exactly what I put to Professor Lynch, and just to add that, how your institution has been able to make sure that these diversities are not affected, yet at the same time everybody is able to come up to speed with what this transition requires of us.
Okay. So, well, I guess what springs to mind for me, what you've mentioned there is again about the narrow thing around my institution, and then the question more broadly, more broadly across the globe. But what speaks to me there is Gauri's comment earlier in relation to access to technologies. I mean, that I can certainly appreciate that for, many people around the world and many institutions, the capacity to continue to offer legal education, because some students just do not have access to technology, and that is a significant issue. And it was certainly an issue that we experienced here with some of our students. So the university really had to make a concerted effort to be able to make available technology to students who needed it in order to be able to continue their studies. So the university purchased and made available technology to students. And I think that needs to happen both, for example, in Bangladesh and other countries, I'm aware that the government has actually been supporting financially, providing financial assistance for students to purchase technology. And I think that's really critical. So the assumption that all of our students who are studying law will have access to technology, know how to use the technology, feel comfortable with it, is clearly not the case. And certainly as an institution, we had to make sure that we had training, services, technology and support for students so that they could actually continue with their education, not just at a bare minimum, but in a really meaningful way. So that's certainly something there. And I also agree with with Andrew's point around more broadly the opportunities around sharing content and sharing resources more broadly. I agree that there are many institutions that are extremely well resourced around the world, many that are less so. And so the importance, I think, this year has shown that actually it's really opened up a whole lot of opportunities for sharing content, for sharing experiences across country. The University of Wollongong has campuses in 4 or 5 other countries around the world. We've harnessed opportunities of actually sharing, for example, being a guest lecturer or guest speaker at other campuses and vice versa. So we've really broken down some of those barriers that often, where the physical presence of somebody has been a bit shackling in the past. So we've really been able to open up some of those opportunities. But for me, in terms of how you break down that and really ensure that as many people as possible are able to continue with a quality legal education experience, it's about training, support, access to technology for both students and staff to ensure that the best experience possible is delivered. And there's lots of work to be done in that space. Still, even though we're at the end of 2020, we have improved in that space enormously. And I think we have actually been surprised at how well our technology has actually held up. I know from my perspective, as I said, in leading the change in the School of Law and how we were going to deliver remote learning at a very, very quick turnaround, that in the beginning, we actually thought that maybe Zoom and WebEx and other platforms were just not going to cut it. So we really tried to think about synchronous and asynchronous delivery and trying to get a balance there so that students who didn't have technology, that if Zoom crashed, that the whole learning experience was not going to be tied up in a synchronous, delivery. But as we have really got confident, and students have got confident, staff have got more confident with using this technology, and we know that its capacity to deliver is there and has actually been really positive in many ways, although not perfect, that actually we're now seeing much more sophisticated and I think much more nuanced use of practices as we're heading through to the rest of the year. So I agree with Jeremy's point before. We are really going to take some fantastic things with us from this year moving forward. And I think we can get the best of both worlds. We can get a balance of face-to-face, a balance of online. And in fact, I suspect the way forward is dual delivery. I think, which has some issues in itself. But yes, I think we will take forward the best of those both worlds. And I think that will be really terrific in terms of ensuring a diversity of access.
Right. It's actually interesting that you brought out the aspect of synchronous and asynchronous learning, which actually brings me to the other important aspect of online education. Now, this digital classroom basically offers both kinds of opportunities and challenges. While it allows for a synchronous and asynchronous teaching and learning with blended and flipped classroom approaches, there is also a possibility of probably ending up alienating the teacher and the student, which no one can deny. Now, at that particular moment, what is the kind of institutional mechanism that can actually be established to ensure effective pedagogical approaches? Because, no one can deny the fact that the pedagogical approaches have had to see or witness a change in the light of the pandemic. Now, how can actually law schools provide an enabling environment to their faculty to reimagine pedagogy, evaluation, and assessment so that the students' ability to learn, grasp, and then reproduce all of that as and when it is required of them, like Ms. Gokhale was mentioning in the courtroom, is not compromised. So, Ms. Gokhale, I would rather want to come to you first here because you can definitely throw some light on this aspect of how different pedagogical approaches can affect the output when it is most important for a law student.
Sure. When Professor Raj Kumar, approached me for being a professor for this particular course, the first thing I said that I will miss by Blackboard, right? So the techniques will have to evolve because I'm in the habit of really going, sort of drawing charts and explaining concepts. So I had to sort of myself reimagine all of that in a virtual world. So coming to the specific question, I think I really like the point that you mentioned about alienation or how do you sort of continue that connect, because in any even in India, as we had that Guru Shishya Parampara kind of a concept. For the others, it is basically the relationship between a professor or a teacher and a student is at a much higher level. It is sometimes even at a philosophical level or a spiritual level. We go to that extent also in the Indian context, right? So what is very important is that connect. Right from the beginning, how do you and how can the institutions also enable that initial connect between the professor and the student in when you have never met before, right? So because typically in a sort of and especially in the context of legal education, what is very important that the professor equally teaches also in my mind is the assessment of human behavior, because as lawyers what you're really doing is assessing the human behavior, right? Or so the mind game, that kind of concepts, right? How do you sort of connect with the minds? So I think the most important thing is which helped and just as an experience which I had with Jindal Law School, they assigned a faculty to me who can help me navigate this entire situation. So that was one very good thing, because the professor knows their students from before probably. So I was able to sort of navigate that situation. Now, coming to the specific teaching techniques, I think we have to go much beyond as professors. We have to, the expertise has to be at the highest level, and the engagement of the thought, of the concepts has to be at the highest level throughout the class, because it is very easy for you to lose a student who is, who's on a phone in some, place where the technology may not be as great or otherwise, and may not even be able to see you, your expression, etc. So how do you constantly keep at the top of the game, in terms of the concept? So the teaching methodology, I realized that it is very important. It has to be interactive. There is no way that you cannot have an interactive classroom. Initially, you will feel that some students are not answering. How do you get them out? How do you make different groups to be able to sort of, compulsorily get that engagement? So what for example, what I try to do was, give them assignments, which are every class assignments, to throw questions to them to say that, okay, come back on these answers, during the next class. So just, get their mind working in a, even in the remote setting at every minute of your classroom. That becomes a very, very important aspect in my mind. And insofar as the institutional support is concerned, of course, the technology, to ensure that each student, as Professor Mundi said, each student has equal access on that particular day, because, on that particular day, there may be something going wrong. So that continuous assessment between the institution and the students to say that, okay, at so and so time, if there is any issue, what is the backup, etc. So that will definitely help. And the second aspect I would mention is the tools that are made available, sharing of screen, or ability to sort of even do the drawing, and all those additional sort of technological tools that are now evolving. So if those are made available to the professor, and that training is taken in advance, that would absolutely help enhancing that particular experience in a digital classroom.
Right, absolutely. Jeremy, considering that this particular aspect of online teaching and learning and the different pedagogies that are adopted, as well as the right choice in terms of picking an assessment which is a fair reflection of the students' abilities, is universal. It's not just restricted to legal education. So I would want you to kind of chime in with your thoughts on how best can one assess a student's ability in terms of the learning outcome.
Sure. I think I'd start with maybe zooming out a bit, and how I think the university or the law school can help create an environment where that would happen. I think one is setting up, centers of excellence in teaching and learning with, dedicated staff with expertise here. And I think they should be doing research on these topics, with case studies and presenting those to faculty regularly. This is a big change. It's a big transition. And I think that would be really key from my experience. I think certainly the technology enables new types of assessments and new ways of assessing, and I think those opportunities should be explored. There's also challenges, I think, that are faced there as well. But I think, coming back to the point earlier of the asynchronous versus synchronous in kind of the design and more to the holistic design, I think asynchronous is and can be a real key, but only if it's, the design of that is done, in a thorough and thoughtful way. It's, I think platforms like Coursera, FutureLearn and MOOCs, and even digital media companies, they have expertise, and we've seen how you can design learning outcomes in a highly engaging way. And I think, taking insights and learning from those platforms is a key, I think, to ensuring that design is high quality, because I think the digital fatigue that students face, it becomes a real concern. And I don't think you're gonna be able to overcome that without, thoughtful, high quality production, curriculum supplementing those live interactions. And just to conclude, I would say that, again, I think as the kind of the theme has been, talked about throughout the session, it's this blending of, the human and the technology, and ensuring that the future brings out the best of both.
Thank you, Jeremy. Just kind of concluding thoughts on this, Professor Mundi and Professor Lynch. Any preferential pedagogies that are being adopted or are being considered at Australian institutions, which you would like to talk about, just to kind of bring a universal dimension to this very discussion regarding the pedagogical approaches to be adopted to ensure that the learning is not compromised. Professor Mundi, I'll go with you first.
Okay. Look, one of the things that leapt out at me when we're talking about assessing some of the key outcomes or learning outcomes that we hope to get from legal education, which is around the communication element that we've all talked about, and that personal human connection. How do you try to recreate that online? Certainly within all of the subjects within UOW law degree, we have a communication component that is accessible. So we generically call it class participation, but essentially it's about turning up, it's about active engagement, it's about demonstrating communication and preparation and engagement with the topics at hand in a classroom environment. So the challenge for us was to think about how do we translate that into an online environment, given all of the complexities of Zoom, how you navigate the quality and essence of communication skills in an online environment. In the first half of this year, when we were thrown very quickly into it, as a law school, we made the decision that we wouldn't assess this component in our subjects. And in fact, the feedback from students was pretty vocal that they wanted this type of assessment. And the reason that we made the decision to remove it was because, one, we were not sure that, as we said, the technology would be able to survive. We weren't sure that students would all have access to the technology in order to be able to participate. So the fairness and equity of an assessment task for me was one of the most critical elements. But we have, in this second half of the year, actually now reintroduced what we're calling online engagement. And one of the online engagement is essentially for students a way of capturing their communication engagement, both quality and to some element quantity, of contribution and engagement in the online environment, also combined with some asynchronous activity that they would supplement with that. So it's become a holistic way of assessing student engagement in the online context. Now, one of the significant issues that we've grappled with, because as a law school, we meet weekly for a remote teaching catch-up where we share good practice, we talk about what are the issues that are happening and how do we resolve them. One of the significant themes of our remote teaching catch-up has been this question of cameras on and cameras off, and what's the expectation that we have that every student will have a camera on, while recognising there are a whole range of equity issues for students who don't have a camera, students who are in public places or private places, and really, for whatever reason, are not able to have a camera on. But I think the general feeling is that there is a direct line, relationship between that communication and engagement and having the cameras on. So as a law school, we've really thought about a strategy of how we encourage cameras on, how we encourage online engagement, both through the chats, through a range of tools that we will use online, and try to really use a mix of strategies to engage and be able to assess online engagement in a range of meaningful ways, because I agree with Jeremy, the Zoom fatigue is real. We need to really seriously have some pedagogy that I think is not simply a 2 hour on a Zoom, that there is some really considered thought given as to to the pedagogy in the online classroom. And for me, the online engagement element has been something that's been a theme throughout 2020. Whether we do it, how we do it well, and I feel that actually the way that we have got it right now at the end of 2020 is actually the sweet spot. I think we've got the sweet spot between students feeling as though it's not simply a subjective series of criteria that we're looking at, how do we assess on Zoom subjectively, but actually to realise that there are a range of indicators that we're looking at, and we're both synchronous, asynchronous, use of the chat. It's a holistic assessment, and I feel like we've kind of hit that sweet spot right now.
Right, absolutely. Professor Lynch, I would really appreciate a quick 2-minute response, because then I'll take in the audience questions. So I'm getting a lot of audience questions here, and once we get a response on this, I'll directly pitch all those questions to the entire panel. So anyone can come in and answer those questions. Please, Professor Lynch.
Sure. No, look, I think Trish has said it really, really well. I mean, interactivity is the issue. That is the great challenge, I think, of digital education. And we've had exactly the same problems. So this is why sessions like this are so great. The only thing I'd add to her remarks is the issue relating not just to interaction teacher-student and amongst the class as a whole, but breakout groups, small group work. In a classroom setting, you can create those and you can in fact view them all simultaneously to an extent. The idea that we've had of people in breakout rooms on various platforms and teachers kind of pop into them, it's not a culture of constant surveillance that I'm emphasizing, but I do think you can read a room in the way that you just cannot read a group of people on Zoom. You can gauge the understanding and engagement of an audience in face-to-face classes. So I think, to return us to where we almost began, as we emerge from the pandemic, I mean, what we've been doing in this term at my institution is students are blended, and we've had to observe social distancing in our classrooms, but you are able to come into classrooms for our core courses. And those are small groups of about 16 to 20 students. And the rest of the course is online. So there's that mix of synchronous, asynchronous, digital engagement, but also a return to face-to-face. The diversity is really important. And I think what you need to be doing is creating the culture and expectation setting in a classroom setting, and then replicating that in the online space.
Right. Absolutely. Actually, it's quite fascinating, the fact that the audience is kind of following the discussion so closely that there is an absolute link between the questions that are coming in. So where we just finished, I have a very interesting question to the entire panel, and anyone can come in here. Classrooms are not just about theoretical learning, and we pretty much agree with that, because the role of a teacher is to ensure that his or her students are not only learning the basics of the course, but also evolving to be better and responsible citizens. Now, how can we impart the knowledge of basic human values like punctuality, discipline, and integrity in a digital classroom? Ms. Gauri, I'll start with you, and then I'll come back to our other panelists.
Sure. I think the simple answer is that the teachers will have to lead by example. For the first point, in terms of punctuality, I try to, at least for most of my class, try to be there 5 minutes before. So, that it's a very simple method. And the second one, I think, which I was, sort of constantly saying the same thing, that it is this one-to-one relationship that the student and teacher develops. That something is likely to get missed if we continuously are in a virtual sort of situation. So that is something the teachers will have to go out of the way to have that one-to-one connect between with the students. Whether it is always possible or not is different, because in a campus you often in the campus, you interact of outside the classroom equally, as you do inside the classroom. So these are the things which you need to, the institutions will have to go out of the way to ensure that this happens, almost maybe to the 70%, if not 100%. But that is absolutely critical. I completely agree with the question.
Right. Thank you, Ms. Gokhale. Jeremy, would you like to pitch in here your comments?
Sure. I think one opportunity that a digital classroom could create to instill a value, let's say around citizenship or even global citizenship, could be, there could be better opportunities with the digital classroom of bringing people from around the world at a much cheaper cost. Various people from different backgrounds, coming into the class. So there could be an example, I think, maybe of an opportunity. It's something that I've had some experience with. We through a massive open online course, brought that into the traditional curriculum on the campus, and students, here in Delhi got exposure to people from hundreds of countries, something that typically would never have been possible or unimaginable in class experience.
Right. Professor Mundi, your comments on how we can basically look at emphasizing on these basic human values. I mean, is there something that is being focused upon at your institution?
Yes, they are definitely critical to our delivery of our law degree and the way that we engage with students. So I would certainly agree with Gauri's very first comment about leading by example. I think that is absolutely the case in everything we do in terms of our own ethical practice, our own punctuality. The way that we relate to students is the way that we expect to be related to. I also agree with Andrew. It certainly reflects my own remote teaching experience this year and that of my colleagues, that we have, as a result of the pandemic and moving to remote teaching and learning, much greater access to a diverse range of people. So I think our students are being exposed to and really getting some fantastic, exposure to a very wide, diverse range of people that I think helps model and reaffirm the importance of diversity, the importance of, for example, in one of my own subjects that I'm teaching this semester, we're able to have a range of guests join us from around Australia that looked at ethical practice in rural, regional and remote communities. For example, we had an Indigenous person who came to talk with us about access to justice issues for Aboriginal and Torres Strait Islander people. So for me, it allowed me to build in such a wealth of opportunities in really having students connect with very different experiences to their own, and that was absolutely brilliant. But I guess more broadly as well within our law school, one of the things that we have at UOW, and we began this a number of years ago now, is what we've called the UOW Law Student Pledge. It's actually something that we introduced to students in the first semester, and we continue a focus on this throughout the first year of law school. And essentially the Law Student Pledge is an invitation to law students to see themselves as beginning professionals. So it's not about waiting till you finish your law degree in order to become a professional. become a lawyer, that actually your journey is beginning now. And part of that is a range of professional values, ethics and integrity, but also the importance of focusing on one's own well-being and all of the values and qualities that actually go with seeing yourself as a professional, as a commencing law student. And this is, we focus very much on this, and we embed it within our Foundations of Law subject and continue to look at that in the second half of the year in our Ethics and Professional Responsibility course. So for us, for me, I think this has been a really key, a really key way of embedding some of these more ethical, or some of the kind of ethical and very human value-based elements. And it's been positive through a remote space as well, although very different. But I see that law student pledge as being a kind of anchor and a thread through our first year program.
Right. Thank you so much, Professor Mundi. Professor Lynch, I really apologize for always coming back to you and giving you very little time, but I have an interesting question which I want you to answer, and I'll give you 3 minutes this time, 1 minute more than the last time around. The question is, a traditional in-person law degree, especially in a foreign jurisdiction, entails a panoramic exposure to the global legal fraternity for a law aspirant. Now, incoming batches in this entire period of the pandemic have been forced to start their law school life over a laptop and probably sitting in a corner of the house and attending classes, or even if coming to the institution, probably then sitting in a hostel room and attending classes and not being able to physically visit the campus or experience that entire fulfilling campus life. Now, do you think this online format is affecting applications coming from law school aspirants? Perhaps you could give your own experience on that particular note.
So I think there's two parts to your question. Thank you. Which is what's the effect of all this upon applications and interest in studying? And at the moment, those seem to be high, both amongst our domestic students who will also be largely working online into 2021, but also international students. The number of applications is high for my own institution, but there's a huge question mark over converting those to actual acceptances and enrolments. Australia currently has very strong travel restrictions in place. So I think a lot of it is the international student market is just waiting and seeing where they'll be able to go. And I think they'll go where they feel that they can start face-to-face study sooner. But the deeper part of your question, Dr. Singh, I think takes me to something that I wanted to respond to the earlier one on, which was not just about the ethical student, but in terms of student well-being and a culture and a community of peer-to-peer connection and support. And I think we've talked a lot in this session about really positive developments that digital education can provide. But I think the massive challenge is, how do you create a sense of camaraderie, collegiality, and care amongst students? These are often people who are at a stage of life in which they're quite vulnerable. And I think the answer that I've come across to that, which I didn't engineer in any way, it sort of presented itself to me, has been the efforts of the students themselves. So in most Australian law schools, there will be a society or a club for law students. And I have done my utmost really to support their endeavours to find ways in which to connect amongst the student body, because I think otherwise the students just, it can't simply be about a remote study experience. They need to have a sense of community, if only to drive the kind of interaction that Trish was talking about before. I mean, if we want students to engage online as they would in a classroom, they need to know each other. They need to have an existence in relation to each other, which isn't just when we are facilitating Zoom classes.
Thank you so much, Professor Lynch, and I must appreciate you didn't even take my 3 minutes there. Thank you so much. It was absolutely fascinating. I want to thank every single person who in the panel who took out time and joined us for this insightful exchange of comments. I personally learned a lot from the session, and I'm sure there are certain things that I'm going to focus on when I take to my next class. And with that, thank you so very much. And I would, pass on the baton on to my Vice Chancellor, Professor Rajkumar.
Thank you so much. And thank you, Dean Mundi and Jeremy and Gauri and Andrew. It's such a pleasure to see all of you. It was a fascinating discussion. In fact, all of us are living through the kind of experiences that you have all discussed about. So I'm grateful to you. We really appreciate your presence, and I look forward to hosting all of you on campus sooner than later.
Thank you, Professor Raj.
Thank you.
And thank you, Jeremy and Manveen as well. And we will now be back in another 15 minutes for the session, the 13th thematic session on teaching professional ethics during COVID-19. Thank you.
Thank you.
Good morning from India. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. It is indeed my proud privilege to welcome all of you to the second day of this global virtual conference on reimagining and transforming the future of law schools and legal education. We are moving into the 13th thematic session of this conference on the theme, Teaching Professional Ethics During COVID-19. We have with us a very distinguished set of panelists, including deans of law schools, but also higher education leaders. Let me begin by introducing Professor Anna Cody, Dean of the School of Law, Western Sydney University in Australia. We have with us Professor Fu Hualing, Dean of the Faculty of Law, the University of Hong Kong in Hong Kong. My own colleague, Professor Faid Tajuddin, Associate Professor of Practice at Jindal Global Law School, OP Jindal Global University. Barrister Vishwajit Chowdhury, Advocate of the Supreme Court of India, and my another good colleague, Professor Sean Starr, Associate Professor and Associate Dean of Jindal Global Law School and Director of the Center for India-Australia Studies, who will be moderating this panel. I'm going to leave this to Sean to take it forward. Thank you very much.
Thank you so much, Raj, for that warm introduction.
Speak a little louder, Sean. Yeah.
Okay. Am I audible? I hope I'm audible now. Thank you so much for that introduction, Vice Chancellor Rajkumar. And it's a pleasure to be here with you today. I will be first introducing the topic of today's thematic session. And then I'll invite my colleagues who are on the panel with me to say a few words. I'll start with some introductory questions and we'll take it from there. There will be scope towards the end of this discussion for questions and answers. If you have them, please write them on the YouTube channel, and I will address those questions to my colleagues on the panel at the conclusion of this session. So I just want to start off by taking note that during yesterday's inauguration of this very conference, Mr. Ravi Shankar Prasad, India's Minister for Law and Justice, actually noted that during the pandemic, it was the digital ecosystem which kept the world together. He noted further that while technology creates opportunity, it also poses challenges. Indeed, in many respects, technology has sped up the evolution of legal practice in recent years, even prior to the pandemic taking effect. Lawyers and legal institutions are facing novel and changing circumstances as a result of technology in the form of both opportunities and challenges. As lawyers and courts continue to embrace technology, one wonders what impact this might have on ethical considerations within our profession. Taking this one step further, as law schools, we need to consider how we can educate our students about legal ethics in the context of this changing landscape within the legal profession. Of course, in the year 2020, it's been a very challenging year for a vast number of people all over the world. The COVID-19 pandemic has meant that lawyers, just like other professionals, have had to adapt to new work dynamics. From the perspective of lawyers, this has meant that court proceedings in most parts of the world, after a brief gap at least, have resumed through virtual courts or where possible through strict social distancing protocols. Even the International Court of Justice amended its rules of the court to effectively facilitate online hearings. Many courts around the world have made similar arrangements in order to respond to the challenges that have been posed by the pandemic. However, the pandemic or the practical responses to the pandemic should not compromise the delivery of justice or the ethical obligations of the legal professionals towards the court, as well as their obligations towards clients and other stakeholders in the judicial system. So this poses the question of whether the response by the judiciary and by our legal systems to the pandemic has impacted the ethical challenges that we face as lawyers and therefore that we need to teach to our law students. So there are several instances where the scope of codes of conduct and principles of professional conduct have had to be amended in order to make them more suitable for the digital framework within which we work. Some rules have required, for example, lawyer-client privilege and non-disclosure information regarding shared information from clients to be amended in the practice of law in digital context. In fact, I was recently reading a brief prepared by the State Bar of Michigan, which was entitled Ethics in the COVID-19 Pandemic. And this brief set out how lawyers can meet ethical obligations during a crisis, including with respect to confidentiality, communication with clients and court, and supervision of other lawyers, amongst other roles and responsibilities of the lawyer. These new challenges are in fact consistent with the theme of Minister Ravi Shankar Prasad's inaugural address yesterday, where he noted that the digital ecosystem needs a legal framework for governance. In terms of ethics, we should perhaps consider whether codes of professional conduct need to be reimagined in order to suit the requirements of a digital workspace. If codes of conduct are to be reimagined, these new frameworks or professional norms would need to be taught to law students and new entrants of the legal profession. So law schools and academics have an important responsibility to provide situational awareness to students and inform them about the rationale behind changes in the judicial and legal process, not forgetting the importance of upholding the values of ethics and justice. This panel session will focus on such considerations by particularly discussing the role law schools can play in preparing students and future generations of lawyers to face professional challenges posed by the pandemic and by the changing landscape of the legal profession more generally, as it evolves as a result of technology, for example. Despite sweeping changes to the profession, it is critical that law students and lawyers continue to uphold the fundamental principles and values of ethics within our legal profession. And on that note, I'm going to ask a sort of a broad general question to each of our panelists to get the ball rolling, and try and ascertain your understanding, my colleagues on this panel, on what impact the pandemic has had to legal ethics, before we talk about what role law schools can play in training and teaching future lawyers, I suppose. So given the ongoing pandemic, and this is a global challenge, of course, does the way we look at legal ethics need to be reimagined in light of the changing practice of law, at least in the digital context, but even more generally? Do we need to reimagine how we look at legal ethics in light of these new challenges? So it's just a broad question to get the ball rolling. I'll pass it over to you, Professor Anna Cody, if you don't mind.
Thanks very much, Sean, and it's lovely to join you all and to enter into this discussion with you. I think this is an interesting question. I think that in terms of whether or not we need to reimagine our code of conduct, I would probably take a fairly broad approach to ethics and our code of conduct. I think our code of conduct, well, certainly in Australia, is quite narrow. I think in Canada, it can be a lot wider, and in other jurisdictions as well. So I would even blow it a little bit further apart, in that not just the pandemic, but also our broader understanding of what is our ethical duty as a lawyer. And in fact, I would say that it includes a duty to create justice within our legal system and our law. So I think that we need to be thinking about our clients, and particularly those who are disadvantaged, communities who are more marginalised. How are our individual clients experiencing the practice of law as we have moved more online? I think there are obviously great things about that, but I think we need to be thinking about, well, is our code of conduct able to respond to some of the breaches which may occur, I guess particularly around confidentiality, impact or influencing of witnesses, all of those sorts of procedural issues. I think we need to be thinking about our client at the centre of that, and particularly those clients who are disadvantaged in some way. So not just what works for the court, but what works for the people who are actually appearing within the court system, and then thinking about their experience of justice, which I think is a part of our ethical duty as lawyers. So a broader conceptualisation of our ethical duties.
Perfect. Thank you so much, Professor Anna, for that overview. I might hand it over to you, Professor Fu, to give your thoughts on this question.
Right. So we could define ethics narrowly. In traditional sense, the competency of lawyers, confidentialities, fiduciary duties, which are the three pillars in the code of conduct for Hong Kong solicitors and barristers. The pandemic doesn't change that. I mean, those remain the core principles. The challenges, I think, is the online communications. Right? As you well put it, the information technology that we are relying upon. We have discovered the strength of the online communication. I think they are going to stay with us even the pandemic is gone. So for legal education, I think the main issue is take confidentiality, for example, right? I think the first question is, can we do a client call using Zoom, given the challenges we have with Zoom? I mean, that's the first question. And now we all work at home. I think in the future, more lawyers will be working at home in a cozy home environment, if I may use the term to describe Hong Kong's, the shoebox. I mean, can you maintain confidentiality while doing your work, making your phone call? Is your Wi-Fi safe, right? Are we teach students enough? I mean, not the ethics, but the basic information technologies, so that we are confident that they are competent in a tech sense. I think that probably is the first question. I mean, we had this question way before the pandemics. Of course, so the smart contracting and the e-filing happened long ago. So there was the need to teach the technology. But now you have the pandemic. Now it's really, you cannot run away from that anymore. So, but now we are so busy with our online teaching, online exam. I don't think we have the resource and energy to really think carefully about how to move forward in the future. I think that remains a difficult challenge for all the law schools. I will stop there. Thanks.
Thank you, Professor Fu. Mr. Abdul, I might hand it over to you now to give a practitioner's perspective.
Right, thanks very much, Sean. First of all, it's a pleasure to be here. And I think that's a very, very good question. And I think I would say there are, at least from my experience, three essentials which we need to consider. And I think they've all been touched upon. I think the first one is how you manage your practice, in terms of confidentiality, whether the files lying around in your house are safe and secure. That has to be absolute paramount, and that has to be taken care of. The second is a slightly more practical consideration, where in India we had a few cases where, for instance, the Bar Council is very clear on its code of conduct of what to wear to court. But with the pandemic, we've had to reimagine what you wear, when you're not really in court, but you're appearing on screen. And there have been instances where some people have worn a vest and they've appeared before a judge. I think the last I checked, there was another one where somebody was appearing before the High Court and he was lying down on the bed and making his submissions. And the court did rebuke them, saying, just because things are happening on technology, you can't let the morality of the institution down in that way. So those are the other things that we as practitioners and as academics need to consider. And the third, and perhaps in my view, the most important one, is that the role of a lawyer, especially in an adversarial system, is probably the most important role when it comes to making your case in the court. And that has to be linked in with the access to justice and what sort of opportunities we as lawyers afford the clients to appear before judges. And that access to justice has to be worked out not only from this, not just the court's responsibility to ensure access to justice. The onus, I think, in the times that we are in becomes more on lawyers to ensure that there is access to justice throughout the society. And I think that's something that, especially in the technological era, we need to be thinking about, because not everybody has the resources, for instance, to appear before the courts. So those are the three things that I think we really need to reimagine and think about going forward.
Thank you so much for those insights. I'll now hand it over to you, Professor Fu, to comment as well.
Thank you for that, Sean, and thank you for having me on this panel. And it's really a pleasure to speak with you all today, this morning. I just add a little bit of granularity to some of the points which have already been made. I think that in the Indian context, at least, there are a couple of complications which arise in the sense that when you look at the question of clients being disadvantaged, you also have to look at the fact that when you look at the court system, not everybody has the same level of electronic resources available, even from the infrastructural point of view of the court system itself. And so the way in which the Supreme Court can respond to the pandemic through its senior advocates and so on and so forth, who do have resources available to them, would be very different from the way in which lower court or a district court would be responding to the situation. Not just in terms of access to technology as far as the lawyers are concerned, but also at the court level. So I think there's a sort of infrastructural issue there, which sort of goes into my next point, which is that I see this as a combination of transitory issues and permanent issues. So when you have a situation where in the long term, you are moving towards more online interactions on a permanent basis, it's one thing to say that you develop an e-filing system, which to a certain extent India is moving towards in any case. But when you have a sudden event, a shock to the system like a pandemic, then there are a number of problems that arise from a transitory point of view. And you can fold in an economic aspect to this as well. What I mean by this is that when you look at some of the issues that have been addressed by the Board of Practitioners in US states, for example, some of the questions that arise are dealing with a situation where you are laid off from a firm because of an economic hit. And do you have an obligation to your clients in that situation? How do you deal with that? When you're moving into a smaller setup where you have to coexist with other people because you may have a partner who doesn't have a job any longer. So there are economic implications to this transition from an office environment where the economy is moving at a certain clip to a situation where there's a macro systemic shock to the system in terms of not just the legal process, but also people who are working as human beings in an economic system, who may be partners of lawyers, lawyers working in firms that may not have much business. So I think there's a sort of interweaving of issues over here, which I think we have to sort of work through. Some of these things are being dealt with on a long-term basis, for example, moving towards an e-filing system. But some of these issues are issues of moving through the shock, I think. And I think there's a big difference between the ethical standards that a senior advocate can easily comply with. He has enough space. He doesn't have to deal with a problem regarding his internet connectivity. And somebody who's a young lawyer, who's just starting out, who took up a low-paying job with a mid-level practicing lawyer who sort of gives them space in their chambers, and suddenly even that ends. So how do you sort of deal with that situation? So I think there's a sort of spectrum over there which perhaps we could think about. So I'll stop there.
Fantastic, thanks so much. And quite a spectrum of comments from our panelists today covering on so many issues, really. I think it would be worthwhile picking up where Professor Fez left off there, because the theme across a number of comments just now was access to justice and the potential inequity that I suppose both the pandemic and the reliance on technology have sort of manifested, I suppose. And that's not just true, of course, in the legal profession. We see it and have seen it in education. Heavily relying, of course, at the moment on technology, not just higher education, but of course, primary, secondary, and the list goes on. So I wonder if you could each very briefly comment on how you feel and to what extent professionally, lawyers, law schools, and institutionally, the institutions of government have to kind of remedy this growing or potential growing inequality. I'll start again with you, Anna, if you don't mind.
Yeah, I think that in some ways, because the framing it within the pandemic environment, that because it came on so quickly, that certainly there was a real speed. We have to get everything online fast. And there were some good things about that from a client perspective, in that e-filing, as one of our other speakers just mentioned, e-filing, like bringing the courts into the 21st century really, and the ability to do lists that were just fair and mention, doing those really speedily. So I think from an access to justice perspective, so for example, prisoners who are being held and who have to get up at 4 a.m. in the morning to get ready to be checked, security checked, lined up, and then just go for a 2-minute mention in court and spend all days waiting in the cells. All of that can now be changed so that they actually have mentions of those sorts of quick matters. So I think it's not just it's all good for justice or it's all bad for access to justice. I do think we need to texturize that. So in some ways, I think it has been constructive. My fear would be that because it is speedy and cheap, that we will not return to, I think particularly for hearings and for vulnerable clients, I think, and having face-to-face access to a lawyer is really important for the building up of trust within a relationship. And we do have that fiduciary duty, lawyers to their clients. So ensuring that we can properly exercise that, I think, does rely on having a relationship. And if the relationship is only through electronic means, I think it does impact on the relationship. Of course, you can have a lot, through Zoom. We've all been doing it for many months now, but there is nothing that quite replaces face-to-face contact either. So I think it does have a potentially detrimental impact. And I think that I think there's a temptation, because access to justice issues are always going to be pressured. There's never going to be enough resources to really provide the proper access to justice that disadvantaged people need. So one of the things, for example, that I would be worried about would be, say, in protection visas or refugees, those asylum seekers, where those sorts of hearings might be heard purely online. That sort of development I would worry about. Similarly, serious criminal charges, having hearings that are happening online, that sort of development as well, I would be worried about. So I think there is a role, but I don't think we can see it as a one-size-fits-all type of approach, because I think that will definitely have an impact on access to justice for disadvantaged communities.
Thank you, Professor. And Professor Fu, did you want to add anything on top of that? I think just if you could unmute yourself.
Right, sorry about that. I think the key question is whether technology would enhance inequality or provide some remedies for it. Right. I think it is context driven. It depends on what type of case I was talking about. For example, the Chinese death penalty case, right? Before the technology, information technology is commonly used, judges would have to have a physical meeting before he or she sign off a death penalty. Right? There will be a meeting to hear what the condemned person would have to say. Now it's easy. It's just online 5 minutes Zoom meeting. I guess you will never see the body language. Right? You only see a faceless face answer a few simple questions. So in that sense, I entirely agree with what Anna said. Is there are things that can never be replaced by this human interactions, right? That is what judging is about. Taking out that human interaction, justice it will be very different, right? So that is an important dimension. I presume access to justice is enduring challenge for all legal systems. In Hong Kong, for example, I doubt there's that much the government can do more given what it has done. I think probably the legal professions, NGOs, law schools could contribute a bit more. If I cross the border to China, then my question will be very different. Then probably I would say the government would have more capacity and could contribute more to legal aid, for example, because the government has been doing so little. So it's really context-driven, depends on where we are situated, what are the prevailing issues in the society.
Thank you, Professor Fu. Mr. Jake, from a practitioner's perspective again.
Right. So I think a lot of what what I wanted to say has already been said about the unequivocal point that trials are meant to be to put it in a layman's term, it's meant to be judging people. And I don't think that's possible online, and I don't think there can ever be a replacement for an actual physical trial. But moving to the context in which the courts moved, I think the first thing is that it all happened so quickly that there was not enough time to deliberate, and there wasn't a plan. When all of this happened, so the courts initially just went into complete lockdown, and then slowly and steadily they started reopening. And some of the things that practically happened included, for instance, giving adjournments, giving bail in some cases where the people who were incarcerated were particularly vulnerable. So those were some of the practical things that happened in terms of the technology. Now, there's been a recent parliamentary report, however, which says that even after the lockdown ends, we will maintain some form of online interactions, and many of the cases would be dealt simply online. There's no hint that trials will be replaced by online hearings or anything of that sort. But this is just, as you very rightly pointed out right at the beginning, when you said that this is just catching up with technology. So, for instance, one of the things that's happened is that they've started. They've given permission for court proceedings to be shown live throughout the country, so that the Supreme Court and the High Courts can be streamed live. And I think the positive side of that is that it gives everybody, for want of a better word, it gives everybody a sort of stake in the justice system where, you think that it is so accessible that you could be sitting in your drawing room and seeing what's happening in the Supreme Court and the High Court. And when such big things are at stake, especially in the constitutional matters, I think that's a very, very promising move. Having said that, I will be cautious in replacing the physical hearing aspect of especially criminal trials and moving forward somewhat cautiously in the other areas as well.
Thank you so much, Professor Fraser. If you want to start on this.
Thanks. Thank you, Sean. Just a couple of points in response to my colleagues' interventions. The way I think this debate about whether things should stay online or not is going to play out, to a certain extent, there's going to be a weighing of different benefits. For example, the big issue in India is the issue of pendency. And so you have a massive backlog in courts, right? And so keeping in mind the fact that in some ways having an online system tends to accelerate the process, which sometimes comes at a cost of face time and enough opportunities being afforded to the litigants to make their case. I think that from a policy perspective, these kinds of arguments are going to be made in terms of the benefits of having a quicker justice delivery process. Because one of the big issues in terms of our system is that people have to wait too long. That's one sort of complication I wanted to add to the discussion. The second point I just wanted to make is that I just wonder, when we're making these arguments about the impact that an online system, since that seems to be the focus at the moment, has on the rights of litigants, then to what extent is this something that will be purely discussed from the perspective of ethics, professional ethics? And to what extent are we going to actually go into a substantive discussion from the perspective of constitutional rights themselves, right? So, the discourse changes when you get into your fundamental rights in the Indian context. So what are the rights that a litigant has? So there is that issue of where we're looking at this from, and is professional ethics really the primary, and not even saying it's the only, but I'm even asking whether it's a primary locus, I would say, to actually discuss these questions. For example, if it's a matter of whether a prisoner is getting an opportunity to be heard, or whether he, if he's making an argument saying that if it's a matter of the death sentence, I need an opportunity to actually be present in person. And there have been a number of cases around the world where prisoners have been informed via video conference sometimes that they are on death row, or the penalty has been upheld. So there have been mention of these kinds of cases. So the kind of argument over there would probably be more driven by some kind of a constitutional law angle, because if you're looking at the rules that we have in India, for example, it's couched in the language of duties. A lawyer, he has duties towards the court, towards clients, towards his opponents, and towards fellow clients. So there's a sort of division into different categories of duties. So these categories don't necessarily fold in all the complications that can be addressed when you're looking at fundamental rights and other areas of law. So I just wanted to sort of add in those dimensions just to sort of see where the parameters, where do we draw the line in terms of what we are discussing, and whether we can really solve it purely from an ethical perspective, or does it go into these other areas as well?
Perfect. Thank you so much. I suppose I want to pivot a little bit, and in light of everything we've said from the perspective of how the pandemic, how technology has changed the profession, how we practice, how that might impact our ethical responsibilities, codes of conduct, etc. What role do law schools have to play in light of this? And you've got a creative license to take this question how you want. I'll ask it quite broadly, but consider in your answer, if you will, whether pedagogically how legal ethics should be taught in light of this, and also whether we need to adopt a multidisciplinary approach when we're looking at legal ethics. I note that Professor Hu mentioned this is sort of focused on information technology, but of course there are ultimately a lot of philosophical, social theory. We've been speaking about access to justice and other ethical considerations. So how do we approach legal ethics in light of everything we've just been speaking about when we're teaching it in law schools? I'll start with you again, Professor Cody.
Thanks very much, Sean. So obviously this is something that I am very dedicated to in the law school, and certainly something that I've written quite a bit about. So I do think that we need to think about how we teach ethics. I think that there's always a temptation to look very individually. So I guess I would make 3 points perhaps. One is that we need to think about what framework exists to enable our lawyers to act ethically. I think it can be too individually focused, and in that way bringing in a more holistic interdisciplinary approach, a sociological, philosophical understanding of what determines behaviour can actually really help us to think about how we create an ethical legal system and ethical lawyers within that system. The second would be that I think we need to teach reflection skills, that for our lawyers, they need to be able to look into themselves as well and get used to it. So actually be taught how to reflect both on themselves, their own assumptions, their own ideas, their preconceptions, their own racism, sexism, homophobia, you name it. So when we're talking about how to teach our students to be ethical lawyers, I think we need to teach them how to reflect. And Michelle Leering and Tim Casey and various others have written quite a lot about that as well. And I think that clinics and clinical legal education are a great way of teaching ethics because it gives real legal issues and experience in a very structured and supportive environment, so that students can meet real clients and actually have an understanding of the sorts of issues that are going to come up, and that ethical issues aren't removed. I think when you teach ethics as a separate subject, I don't think students realise just how daily and mundane ethical issues are, as well as really big philosophical questions around how do you represent a client with a disability? You know, what sort of empowerment model do you work out of if you're working with disadvantaged clients? So I think that there is certainly a lot of issues around how we teach ethics. So I think that COVID-19 and the pandemic, I don't think it brings new issues. I think it more just, it reveals existing issues with how we think about ethics. So that would be my take on how we're thinking about the way ethics are and how we teach them are impacted. One final point, which I really liked, was that idea of an ethical muscle. So actually getting used to exercising an ethical muscle. And so Mary Gentile talks a lot about that in her work. And so she talks about in business, but, you know, obviously in law as well. So getting used to recognizing ethical decisions and being able to make ethical choices around it, and thinking about the structures that we can put in place to do that.
Fantastic. Thank you so much, Anna, for that. Professor Fu, if you could please share your thoughts.
Right. I think there are big issues and small issues, right? Small issue, for example, should we teach legal ethics in year 1 as a compulsory course, as the profession is asking us to do, or we leave it to the final year, right? Before you graduate, we have some mini classes. We talk about some of the dry lessons which nobody will be interested in. So that is a design issue in law school, right? So in law and development literature, right, scholars would say, you know, before you change the legal system, you should change law school legal education, right? Because it's easier to change your students than change the sitting judges, right? So if you have all the freedom to do, the question still is what we're going to do with the substance, right? Now, we're given the code of conduct. Those are the things we teach. We have never really departed meaningfully from those very, you know, the pillars I was referring to. I think Professor Cody raised the issue, you know, are you going to talk about individual cases? Are you going to talk about larger structure issues? Let me just raise one question that Hong Kong is facing. In the past 2 years, I'm sure you are aware of the social movement, the protest. So there have been over 10,000 arrest charges against young people, right? Same case, same age group, same offenses, same agenda. What are we going to do with it, right? You could say access to justice means we have lawyers for them, you know, have a rigorous defense to each and every one of them. That would last for another 10 years to finish off those cases, right? We are still handling the cases happened 5 years ago. It's a huge political movement, right? I just feel law is sort of powerless in sorting out those political questions. But then everything has been legalized, right? There's a, you know, if I may use the term, juridification of political contention in Hong Kong. So for law school, we have students who have been charged with some of the offenses. So what we're going to do about that? So I think it's just like a racism and other structural issues we are facing. Sometimes we may have to step back and then look at the larger picture, talk about access to justice from like a law reform perspective. Otherwise, it will be, at least in the Hong Kong case, it will be very meaningless, and not that meaningful, then put that way, to talk about legal aid to one particular student. Thank you.
Thank you, Professor Fu, for that. Vishabjit, if I can turn to you, please.
Yeah, sure. I think
I feel we may be having technological issues, so we'll come back to Vishabjit. Professor Fez, I might turn to you in the meantime.
Yeah, sure. Thank you, Sean. I would actually sort of mirror Dean Hualing on this issue of political questions being shunted to the courts, because that's a very universal experience. And I think that you're quite right in pointing out that this creates immense stress on lawyers and the responsibilities that lawyers ought to normally take on in normal scenarios. So I think that's something which we experience as well in India, not just from the perspective of protest movements and people, being incarcerated or, cases being hoisted onto young people, but also because there's already the pressure of pendency. So in any case, legal resources are in short supply. So I think that's very true. And I think that it creates a complication, especially when you're looking at the way in which, not just from an ethical perspective, but also from a larger perspective of what the legal system is supposed to do. There is perhaps a large scale trend across many parts of the world where these things are being put onto the shoulders of the courts, where they really shouldn't be put onto the shoulders of the courts. The other thing is, from this perspective of the way in which we teach professional ethics, it's a sort of a and maybe it's foreshadowing some of the discussions we can have for the remainder of our time also. It's a strange sort of creature, because at one level we teach rules, and so we have these standards and guidelines that have been put out by the relevant bar council or professional body. But at the other level, we also have this initial module where we're trying to figure out what the relationship is between legal ethics and philosophy, and these areas of knowledge that lie outside the legal system itself. And so when you're looking at this issue of what we include in the curriculum, what we struggle with initially is to get the kids to, the students in our classrooms, to sort of grapple with the distinction between, a legal analysis and something that is external to the system, and whether there's any legitimacy that should be given to a critique that comes from outside the system to a legal decision that you make as a lawyer. So perhaps that's something which we'll probably come to, but it'll be great to have your thoughts on this dilemma, because it sort of divides the course into two distinct halves. There's a philosophical module at the start, and then we have a very rule-based discussion, which is probably common across many jurisdictions. And then finally, we may have these little interstitial issues which are specific to a particular jurisdiction. For example, in India, whether lawyers can advertise or not. These are things which may be issues here, but may not be issues in other nations. So I think that in that sense, the course sort of neatly falls into these different categories. So perhaps we could, maybe Sean could reflect on that for further discussion.
Thank you, Faiz, for that. I'll definitely get back to that. But Vishavjit, did you want to get back to that final point before we lost you?
Yes, sorry, I got locked out. Right, so the three things that I think are absolutely essential in terms of what we are teaching in the law school. I think the first thing is that institutional morality and professional courtesy that are completely non-negotiable and have to be inculcated. I think the second thing is that, what is happening is almost like a problem question that when I was a professor that I would give my students that, the entire world is shut and courts have gone into lockdown. What are the sort of duties of a lawyer in those times? So for those reasons, I think that some level of imagination as well as philosophy is crucial to be used in the classroom. And the third one, and perhaps equally important, if not the most important, is that ability to be a part of the system and ownership of being in the system. Because I think a lot of the students, they come right to the fifth year, they only take law as purely academic subject, which of course it is, but they do not understand the intensity of being a lawyer. And I think that has to be inculcated, because people change and, institutions as well, the institutions change, but what must remain is some principles. And those are what we need to make sure that our students leave law school with.
Amazing. Thank you for that. And I suppose taking off where both Faiz and you've just left off then, Vishwajit, the segue goes to, the Q&A. There's been some fantastic questions posted by our listeners, so thank you for sending them across. A couple have actually tied in very nicely with that last round and where we are now in terms of how do we imbibe some kind of creative pedagogy in terms of teaching lawyers or law students about confidentiality in practice, about communicating with clients and the courts and stakeholders, and these underlying principles and duties that have just been mentioned in a virtual context. And in fact, I can tie that in with another one of the questions that's just come. How do we teach or redesign professional ethics in terms of a post-pandemic pedagogy or framework? I know, Professor Fu, you just mentioned it's been a pretty overwhelming year for most academics. And we haven't probably had the time to reflect that we would have wanted to, but now we have the opportunity, at least for the next few minutes, to reflect on what might need to change, what might we need to redesign. There's already been some fantastic suggestions and practical suggestions, but I liked your point, Professor Fu, that when do we teach professional ethics? I learned it in 5th year. Jindal students get taught in their final year as well, but it's not the same everywhere else. When do we teach it? How do we teach it? And how do we redesign the current course and framework in light of everything that's going on, just in a nutshell? I'll start with you, Professor Cody, again.
Thanks very much, and great question. I think that one of the opportunities, I'm very much a first year teach ethics, Professor Fu, because I think it's really important. One, it gives the message that it's important. You can't leave it to the very end, and that it's fundamental to our practice of law and of being lawyers. Because for me, it involves what is a lawyer? What is your role? What is your responsibility? So I think that's why it fits in the first year, as well as what are the actual roles. So probably the second half of first year is where I'd go for. How we could do it differently. So I talked a little bit about a clinical methodology, or trying to use at least clinical components within an ethics teaching. If you can't do that, then I think we have an obligation to try and bring in real clients in some way, and practitioners as well, and the diversity of practitioners. And that's the opportunity that we have. I mean, who would have thought that we would be all, from all the different places that we are speaking from, sharing our ideas so easily and being able to be nourished and stimulated by the different ideas and discussion that we're having. So I think students as well, we could draw on that rich international experience into our understanding of our ethical duties and what that means to be an ethical lawyer and to contribute towards justice. So I think that's the potential, is to try and draw on some of the cross-fertilization that's possible virtually, which isn't possible in the just teaching on a face-to-face methodology.
Thank you for that, Professor Fu.
Right, I don't teach legal ethics. So as you, Sean, I Googled in the past 2 days. I read quite a few reports, including the Michigan State report. Went to my ethics professor to ask, what are the key questions. No, I think the issue is, I think what Professor Cody said is really important for me, is we do have lots of experiential learnings. We have a walk-in legal clinic, but for some reason we have never tied those two pieces together, right? It's experiential learning is for hands-on experiences, nurture public interest law spirit. But then legal ethics is entirely regarded as entirely something else. I mean, we don't even teach them in a normal curriculum. It is something in our post-grad legal education curriculum. So I think the inspiration I get from discussions really, we could embed ethics teaching into the experiential learnings, right? And so make the teaching more meaningful and also rich. It would have an enduring impact on students in their 4 or 5 years legal study. So that is an excellent way of thinking about teaching ethics instead of leaving it to just cases and doctrines. We could have live, real cases, and then we have some embedded discussion on ethics. So thank you for that.
Thank you, Professor Fu. Faiz, over to you.
Thank you, Sean. Just to take forward the points made by Professors Cody and Hualing, I would just make 3 points. To take the last one first, from the perspective of looking at an ethical course as a distinct course versus something that's related to everything, all the other courses that you have in law school, not just clinical courses, but perhaps something to be explored in a more serious way, in a holistic fashion, would be to look at folding in an ethical component in most disciplines taught in law schools, at least from the perspective of the hard law subjects, each of which may have an ethical aspect. So I think that's something to think about, because it goes back to the discussion that Dean Cody was just having, which is, when do you teach ethics? And at some level, we in law school here have ethics as a final year course. That's what the course I teach. And what ends up happening is that the way we pitch the course is to say to the students that, okay, you've got a sound understanding of these areas of law over the last 5 years, but you haven't really had an opportunity to step back and think about what it means to be a lawyer. And now is a good time to actually have that discussion in a setting which is also a classroom, just before you enter the profession. So that's the way in which one can sell it. But there are great benefits to actually starting your legal education itself with a course in professional ethics and understanding what ethical standards in the law would require. So I think that there's something to be sorted out over there, and perhaps having some kind of a hybrid model where you have ethics being taught as a component of all courses could also be explored. The biggest issue that we have in terms of dealing with these students is to address there's a sort of built-in cynicism about the legal system that militates against them taking an ethical course as seriously as perhaps they could. Because what ends up happening is that they're sort of deeply cynical about, and in some ways prematurely jaded about the legal profession. And so what you need to do is get them involved by highlighting the areas of reform that are taking place on a live basis. And one of the ways we deal with that is to highlight current developments. And very often these developments in terms of reform in the practice of law are driven by young lawyers like themselves. And so that's the way we try to pitch it to them and try and show that there is some hope for positive interventions from people like them. So, I think there's a lot of scope for thought and improvement in this regard.
Thank you so much, Faiz. A couple more questions that I've got. There's a question from our audience here about whether and how technology has paved the way for an increased, whether technology has paved the way for an increase in the amount of times or the scope in which we can breach confidentiality as lawyers. And this is really central to the lawyer-client relationship in terms of trust and legitimacy. So how do we kind of mitigate that, and how do we teach that in a law school context? I'll start with you, Professor Cody, again.
Thanks, Sean. And I do think it's confidentiality is the one that really does spring to mind, because as one of the other panelists was saying, when we are working from home, I'm at home now, the ability to have client files, or when if I were having a conversation, I actually volunteer in a community legal centre, but when I have a conversation with a client, whether I can be overheard by my children, by family. So there is, and obviously if you have separate space, that makes it easier, but if you don't, then it's very hard to actually maintain that confidentiality for the client. And many of us don't have that luxury of having a separate office space, for example. So I think that there are real issues attached to it. So I think all we can do is try and identify them, name them, see what solutions are available, and work with that. And then I think that confidentiality as well works in terms of hearings and, you know, when we actually get into legal proceedings as well in front of a court. So how we teach it, I think that is a challenge. And I think that's something that will grow as we're getting used to this way of working. I think as well as we're moving more to e-files and e-filing, electronic document use, and the lack of paper, in some ways, that's not so much the breach of confidentiality of having papers lying around, well, certainly in our system. But I think we're still on the cusp of that transition as well into more electronic versions of client files.
Thanks so much. Definitely an evolving issue for everyone in many respects. Professor Fu, did you want to add anything to that?
Not really, except just we don't know whether the e-filing is safer or not than the traditional practice, which is that we don't say because it's just so new. Thanks.
Thank you so much. Professor Faiz?
The only thing I would, sorry, there's a train going in the background in case there's noise. The only thing I would add on this issue is that, you know, one of the sort of complications that arise as a consequence of you know, these electronic hearings and online hearings and the lack of human interaction is the pleasing reduction in the potential for corruption and graft. So, you know, what's going to end up happening is when you have a more streamlined process where you have the separation between the parties involved and there's less human interaction, the processes that would corrupt the system and subvert the legal system would also be caught out of step, which is something that when we have discussions with people who are practitioners, there is this complication that has arisen, which is a good complication. So I think that there are lots of little subtle things that are taking place under the surface that we may not necessarily be aware of, which will take some time to unwind and to understand. It's almost as if, you know, it's a complex network of cause and effect, and some consequences are good, some consequences are bad. So I think that there's a lot of scope for sort of discussion on the implications of moving to this kind of a system. And we'll get to know more and more about the consequences as time goes.
Thank you. And I suppose in the interest of time, I've just got one more question for our legal ethics teachers and sort of academics on the call. And that is, you know, what don't we know? And that's a tricky question to answer. But where I'm going with this is, from a scholarship perspective, is there a research agenda that we really need to reflect on in terms of perhaps empirical research for legal education and ethics and clinical, you know, the practice of law and ethics? What should we be thinking about from a scholarship and academic perspective? I'm just putting that one out there. I'm sure there's so much to consider, but I'll start with you, Professor Cody.
Well, I'd be really interested to know clients' experiences of the virtual world and both relationships with lawyers. So some sort of empirical work around how they experience the relationship, I think, as well. Finding out from legal practitioners, what do they think are some of the impacts of having a more virtual relationship. And then, so the client, you know, lawyer relationship, and then also going into court and the range of experiences that then are going to be happening in a court proceeding, how that impacts. Because I think we can assume, but I think we're going to actually have to do some of that empirical work of interviewing clients, interviewing lawyers, and finding out a little bit more about how it's impacting, because otherwise we will make assumptions.
Professor Faiz, did you want to add in one final thing from an Indian perspective?
Sure. I think, you know, just to take that point forward, one of the interesting things that I'd like to know about is the impact on fundamental rights. For example, habeas corpus petitions, and so on and so forth in the Indian context, for which we need data, really. And that's something which has to be studied. What's been the impact of the pandemic on access to justice from these very, very fundamental points of view? And the which I think is going to be interesting is to look at the flashpoints that exist in the legal system, particularly from the perspective of the way in which the system interfaces with the general public. Sometimes what happens is that we have issues regarding live reporting of what's happening in a court, and the court is trying to address it by, in some instances, allowing the broadcasting of hearings. So that's going to be an area of some interest going forward.
Thank you, Professor Fez. Professor Fu, did you have any final comments before we finalize?
No, thanks. I'm fine.
Amazing. Well, yeah, I mean, we've set ourselves a research agenda, empirical. I mean, there seems to be an appetite for qualitative research, certainly on how the pandemic in particular and technology generally has impacted, legal practice and the ethical considerations that underline that. Arguably also scope for some content analysis on how laws and regulations have changed from an ethical and professional conduct perspective. But some fantastic insights from our esteemed panelists today, and some really broad insights into how the pandemic has impacted us as professionals and how we as law schools and academics need to reimagine how we teach legal ethics. And this conversation has not finished in many respects, but our time has expired for this panel, and I'm sure there's a lot of food for thought for our audience on the future agenda. So in wrapping up, I'll hand it over to our Vice Chancellor, Professor Raj Kumar.
Thank you so much, Don, and what an extraordinary panel. And I really appreciate Dean Phua Ling and Dean Anna Cody, my colleague Faiz, and of course Vishwajit, for really spearheading the discussion surrounding ethics. In fact, even during ordinary times, the issues surrounding ethics gets ignored. And I'm happy that all of you reflected so thoughtfully about the situating ethics and study and research relating to ethics in these times. I appreciate you for so skillfully moderating the panel. We will take a short break, and we will be back in the next 15 minutes for the 14th thematic session on the theme reopening campuses and social distancing norms. Thank you very much. Good afternoon from India. My name is Rajkumar. I'm the founding Vice Chancellor of OP Jindal Global University. Good evening to my friends in Southeast Asia and Australia, and early morning for our friends in United States and North America as well. It is such a pleasure for me to welcome all of you to the second day of this global virtual conference on the theme Reimagination and Transformation of the Future of Law Schools and Legal Education. We are in the 14th thematic session of this conference, and on this theme, reopening campuses and social distancing norms. We have a very distinguished group of individuals, leaders in their own right, transformative individuals who have been part of the institution building efforts and initiatives in their own law schools and societies. Let me begin by introducing Professor Dr. Nurul Bariza, Dean of the Faculty of Law, Universitas Erlangga in Indonesia. We have Professor Narufumi Kadomatsu, Dean of the Graduate School of Law, Kobe University, Japan. My good old friend, Professor Dr. Lutz Christian Wolf, Dean of the Faculty of Law, the Chinese University of Hong Kong. My very dear friend, Professor Dr. Purvi Pokhriyal, Director of the Institute of Law, Dean of the Faculty of Law, Nirma University, India. And of course, my colleague, Professor Dr. Oishik Sirkar of Jindal Global Law School, OP Jindal Global University, who will be moderating this panel. My colleague, Professor Sridhar Patnaik, our registrar of the university, is not able to join us, so I will be standing in for him as a co-panelist in the session. Let me request Oishik to take forward the proceedings.
Many thanks, Raj, and I again extend a warm welcome to all of our panelists for, I think, which is one of the most crucial themes as one kind of works through unprecedented ways of thinking about higher education, both in India and elsewhere. So just to restate the theme of this panel, it's called Reopening Campuses and Social Distancing Norms. There's something particularly troubling in the opening words with which this panel is themed, which is the word reopening. And I say troubling because the idea of the university to begin with is, somewhere founded on the idea of it being an open space, both in metaphorical terms, but as well as, material terms. It's an open space for the exchange of ideas and knowledge, but it's also an open space in material terms in the ways in which universities work towards creating inclusive spaces for students and academics from all walks of life. So some of these kind of almost obvious ideas with which we think about the university space as an open space has kind of completely been unsettled in these months that we have lived through and tried to negotiate. I'm guessing some of the key things that we might want to focus on as we move through this panel and hear from our panelists can be broadly thought about under four heads. The question of reopening, I think, requires an attention to these four kind of areas. One, of course, is the question of infrastructure. What does it mean to reopen campuses in this week, and when that might wake, in fact, begin? So, of course, there are major infrastructural concerns there that are sometimes beyond why it's so important to think about the role, the key role that university administrators play in making the university an open space, and more so at a time like this. So from the infrastructural concerns, one also moves to the pedagogical concerns, which is that what might a classroom really look like or feel like? How would one experience the classroom space? Would it be a completely reimagined classroom that, for example, uses hybrid methods of knowledge production and sharing? Would there be a need for an attention to different ways of teaching? For example, I'm aware that other panels that have come before this one in this conference have attended to the question of pedagogy and research. The third component, of course, is one about technology. Again, I think one that this panel would share some thoughts on, because it has kind of become the obvious source of possibilities in the wake of both the kind of experience that we are going through, as well as what higher education spaces might become if and when the process of reopening begins. What is technology in a situation like this for reimagining education? Experiments are abound. I think there are lots of interesting models available to us that we are working with, but we also know that technology isn't always necessarily an equalizer of the kind that it promises to be. So how does one make technology a more democratizing process of enabling access to higher education in the context of plans for reopening? And finally, so we have the focus on infrastructure, the focus on pedagogy, the focus on technology, but there is a fourth aspect to plans for reopening, which somehow the first three don't tend to be able to address very well, which is the aspect of, fear. So there is a certain kind of psychological dimension to the process of reopening, because it would require on the part of universities to be able to both promote a sense of safety at a symbolic level, but also at a more material level. What would it take for administrators to be able to convince parents to, for example, send their children back to campuses? So I'm hoping, I'm just opening it up in that sense to our panelists to, speak to anything else that they think might be important as far as the theme of the panel is concerned. But if they want to, take us through the theme by attending to one of these four, thematic areas that are quite key to discussions around questions of reopening. So I'll repeat the four kind of key components again: the infrastructural, the pedagogical, the technological, and the psychological aspects connected to the ways in which universities are gearing up for even kind of producing a blueprint of what might a reopened campus look and feel like. So we could follow the order in which the schedule has listed our panelists. So if I could invite Professor Nurul Bariza to start us off.
Yeah, thank you very much. This topic is a very wonderful and excellent topic. And first of all, thank you for the opportunity given to me. Thanks, Professor Rajkumar and Professor Isaac Sikar and all distinguished presenter here. First of all, I would like to explain that in the context of how we should opening our Faculty of Law and facing the new normal, new normal condition in the context of this situation in which, like in Indonesia, particularly in Surabaya, the number of infected COVID-19 people are still increasing until now. So probably what we think now is that we should not reopen our campus because if we reopen our campus, so there is we have to prepare many things. Actually, we already prepare it, but we have to make more convenient because there is change of physical face and also model of classroom. We have to change our library design, our canteen, room design must fulfill the requirement of health protocol with physical distance criteria. In Indonesia right now, particularly in my campus, Ministry of Education has already provided us with the guideline on how to conduct learning process at campus during this COVID pandemic 19. For example, we have to have clear distance in all area of our campus, including circulation of air, number of students in class to minimize the risks on or anticipating the new cluster of COVID. In the entrance of a law school, we must be, that a special place for clearing our body. For example, like washing hands, check the temperature. We have to ensure that when we come to campus, we have to have masks, and this mask have to properly use. And all the sign of Faculty of Law must comply with the standard of physical distancing requirement. As I told you that in Surabaya, in which the Faculty of Law Universitas Airlangga located, the rate of COVID-19 is still high, and university, I think, will not take the decision to return to the normal like pre-pandemic in physical mode. That is what not happening, I think, in the future, in the near future. I mean, of course. We do hope that the next semester, we plan already in the next semester by the end of February, the campus will reopen for the student. But I don't think, because this already December and the number is still increasing in Indonesia now, every day the number is still increasing 5,000 people. And it depends on the situation in our province and our region. And in Surabaya, now is still red or orange. So I don't think that by the end of February, we will open the campus and adapting with the new normal condition. And in the context of this, the university has already prepared and provide guidelines for all aspects of business process with health protocol. Campus have policy in all every activities when the student can come to campus. But until now, there's no student come to campus except for the most important one. And it's just only one or two that make appointment to the university leader, dean, or something like that. And lecture also do not come to campus. We work from home, and we provide a strict rule and strict control to the movement of people in campus. Administrative staff also, just only few administrative staff that can have opportunity to come to campus. We also, in the context of a student group or something like that, we have to avoid like the crowded of students. So there is no student at campus until now. And we provide the guest policy for the student and activities for student in case for like last few months, there was a new student enrollment who coming in our campus, and then we have to everything was conducted online. So all facilities in class shall be added with a new device to make less hand contact, for example. And when we are going to the sixth floor or going to the third floor, we should, for example, did not use our hand to push the lift button or something like that, but all we have to change with a less hand contact. So that experience in sorry, is and we have to think carefully before we decide to reopening our campus in the next semester, for example. And decision shall be made not only for the perspective of economy, because in the last few months, the government also thinking we should come into the new normal as soon as possible. Because we have to make our economic development into normal. So the decision for opening the campus, we have to consider many things, and we have to apply many principle like precautionary principle, transparency principle, and many other principles that is very important like safety principle, safety standard. Right now, the number of people without symptom is increasing, so we have to ensure accurately for those who are going to come to school, who are in our campus, are not what we call is has people without symptoms or infected by COVID pandemic 19. That's all from my perspective. And then in the context of transition, I know we are going to think about a transition situation. Last 3 months, we already set up the rule from transition or a new policy for transition. And we try that transition shall be made if we can guarantee that the number of infected COVID-19 pandemic among the community around Surabaya city are decreasing. Surabaya already got the mark of green line from the government to enter into transition era. And in this context of transition, we think that the best policy that we already decide is to offer blended learning. Right now, 100% learning, what we call online. And in the context of transition, we decide that 25% the student can enter into campus, or 25% the lecture, or not the lectures, 25% what we call is subject course can be delivered through on campus, I mean offline, and then 75% we can deliver through online. What is the reason for this? The reason is because the number of students that we have, we do have more than 38,000 students in campus. And we have to reopening in the process of transition one step by one step. So when if on the next semester we can implement transition process, so it means that 20% of the 20% of a subject can be delivered through offline, and campus student can come to campus around 25% of the student, and then the rest still that study from their home. And after that, the next semester, the next semester, I mean second semester for this, we can use a blended learning, 50% offline and then 50% offline online. If after the first period of transition, we got success in this period. That the idea. And yes, thank you for reminding me and about the time. And in the context of infrastructure, it is also very significant issue at this moment. We already during the COVID-19 pandemic, we do a number of activities that we are not, we are postponed it. We are postponed it, like visiting scholar and also student mobility, lecture mobility from one country to another. And because there is no traveling, there is movement of people. So that's the fund that usually we dedicate for that, we change it, we shift it into developing infrastructure. In addition to that, we also asking the government because the government also have a number of fund, even it limited, if distributed to many university, on how to make our campus is safety. So we already set up our infrastructure in facing a new transition and facing a new normal era. But now it is the time, it is the time, because there is no student to set up all infrastructure that dedicate for new normal era or entering into normal era. The last thing that I would like to say is about whether the technology that we use now in the context of COVID-19, we are benefited very much. The technology provides us with a tremendous benefit, particularly for like internet and what we call is internet, cloud data that support the teaching learning process. And I believe that because we are benefited from this type of technology and we getting used to, and we already aware that it make efficient for doing something, particularly for teaching. So I believe that this is part of benefit for the purpose of digitalization of legal education. Last time, before COVID-19 spreading into the globe, there was idea on digitalization of legal education. And I believe that this COVID-19 pandemic speed up the digitalization of legal education, and I believe that we will still use this technology even after the COVID-19 already disappeared. So we actually try to improve the availability of technology that can be used for all aspects of pedagogical learning process in our campus. We also adjust pedagogical what we call is techniques in our campus, including curriculum into the what we call is to adapt with the new situation of COVID pandemic 19. I think that for me, thank you very much.
Thanks a lot, Professor Bariza, for your thoughts. Can I now request Professor Kadomatsu, and just to use the prerogative of the chair, if I could request each of our speakers to restrict their initial comments to about 3 to 4 minutes, so that we do have some time at the end to field questions from the audience. Thank you very much.
Okay, thank you very much. And it's a very honor for me to have an opportunity to talk in this precious symposium. First, to begin with, it could be mentioned that the pandemic situation in Japan is relatively stable, as in many East Asian countries. There have been about 2,000 total deaths in Japan, so it's a lower number compared to the other countries. But nevertheless, government had declared emergency in from April to May. So every university had locked down during the period and moved into remote teaching. However, in the autumn semester, there is the reaction of the university differs. Some of the universities has opened themselves, but the Kobe University has still the policy to basically focusing on remote teaching. And there are very strong public opinion who has a kind of nostalgia to face-to-face education, and they demand that the university campuses open as soon as possible. But Kobe University has been rather very careful to react to such kind of demand. But nevertheless, from April next year, April 2021, we are basically we are planning to basically move on to the face-to-face teaching and reopen the campuses. And our colleague, Professor Oisik Riska, has summarized the task in 4 points. First, the infrastructure, second, the pedagogy, and third, the technology, and fourth, the theory. For the infrastructure, the most difficult task for us is we do not have big enough classroom in enough amount of classroom which is big enough to keep social distancing. So what we are going to do is very difficult. So at least our faculty took the policy not to continue remote teaching for at least a large-scale classroom, large-scale courses, and we just begin the face-to-face teaching for the very small-scale classes. Secondly, for the pedagogical point, our aim now is to make a plan to achieve the, so to say, best mix of remote teaching and face-to-face teaching. We are trying to get the benefit of remote online teaching, which we for the first time experienced in these 8 months. And so we are trying to combine the best point of the merits of each style of teaching. And third, technology is of course the base, should be the basis for that, and that is also connected infrastructure. However, in order to achieve the best policy, we must on the curriculum level, we choose which class courses will be taught online, which classes will be taught face to face, and at the same time we must try to experience the so-called hybrid teaching, that some students participate online and some students participate face to face. But there is also a technological difference in it. We may not have a very good video equipment or the microphone equipment in order to achieve this response. So this remains our task. And fourth point, fear. We do understand that at least the sense of fear to this pandemic is differs among people and differs among our university, and it is very changeable based on the public opinion, which is very volatile. So we must take a policy to at least allow students, for example, to shift from face-to-face to remote when there is, of course, a real risk, because, for example, because of the age or because of the past disease or so on. But what should we do with just not the objective, but the subjective risk is very difficult. So how we evaluate this policy, we are still discussing about this, whether we can allow students to take courses online just because of subjective risk, and we are beginning to such discussion on that. So that's all from me. Thank you very much.
Thanks a lot, Professor Kadomatsu, for your pointed responses. As I said earlier, I hope that we'll be able to take some audience questions to return to each of our panelists. If I could now request Professor Purvi Pokhariyal to offer her comments.
Thank you so much for this honor. The Professor Oisik has put 4 points before us, and that is pertaining to the infrastructure. And I look at it, this infrastructure is a university spaces. And then comes the classroom spaces and pedagogy and the curriculum, and then the technology, learning through technological advancement in the educating process. And the fourth is fear. Well, friends, I feel that we all live in VUCA 2.0 world, which is vibrant, unreal, crazy, and astounding. And in this VUCA 2.0 world, we are dealing with Generation Z learners. And these Generation Z learners have a very different characteristics than the millennials. And this is how this pandemic is providing us an opportunity to explore this learning needs of this Generation Z. And this is how I look at it. Because when it comes to the learning needs of this new generation, they are looking for the autonomy of learning. And when we are trying to shift the face-to-face classes to the online classes or to remote teaching, and providing them the ample opportunity and the resources and the recorded lectures at their disposal on the Moodle, on the LMS, at that point in time, they are exercising their autonomy, and they are also getting an opportunity to the pace with which they are comfortable to learn. So I always feel that asking all 60 students to sit in the class at the same point in time and compelling them to study or compelling them to learn what I'm teaching as a teacher in the classroom is somewhere an undemocratic way. Whether they have an opportunity, whether they have some kind of an autonomy over the learning processes. So probably how I look at it, this pandemic situation is exploring a way for the education administrators that how can we enhance the autonomy of learning with this generation said. When it comes to the university spaces, no doubt our perspectives towards all public spaces is going to be changed during this pandemic as well as in the post-pandemic world. But especially when we talk about the university spaces, how I look at it, that opening of the market or opening of the offices, or for that matter the malls, shopping malls, they all have a purpose, and it includes a transient process. But when we talk about the university spaces, I feel that it is a Shangri-La of body and mind. It encompasses the whole life wherein the students interact. They don't only learn at the campuses, they interact. There is a cultural communications, there is a holistic development, there is a fun, there is a life, the whole life in itself. So I would feel that when it comes to the allowing or reopening the university campuses or opening the university space at this point in time, probably may not be considered as a human approach, because and that's the reason how I feel that how I feel is that we need to shift our focus from education to the students, to the learners. I mean, so far the education institution has been only focusing about the type of the education, the quality of the education, the curricula, the pedagogy, the assessment. But probably we need to focus more on the learners. What do the learner want? What kind of a curricula probably the learner is wanting? What kind of a pedagogy the learner is looking for? And this is probably, I feel, is this remote classes and online classes, helping us to cater to the new needs of these learners. And I always feel that, when in face-to-face classes, there are 60 students sitting in the classroom, probably I would not be able to interact with each one of them so closely. That is very much visible in the online classes, in the tutorial form, or in the what you call the different classroom which I'm creating, a smaller classroom which I'm creating in different learning platform. So I mean, I look at it as a very welcoming step, a very transforming step, and probably we as an education institute, I mean education administrators and all the teachers need to reimagine our role as a teacher. Because so far, our pedagogy, our style of teaching in the face-to-face classes was very, very different than in the online classes. Because we all know that learning is a constructive process. Learning is being enhanced through giving different kind of an experiences. And learning is always a collaborative process. So how do we create these experiences in the online platform? So probably we need to shift towards our ability, our skills. We need to redirect our skills and orientation of teaching to these online classes in the during and post-pandemic world. And when it comes to the last part of technology, again, I would like to link it with this. Are we being able to create a kind of augmented reality, or for that matter, the virtual reality in the classroom spaces? Because especially when we talk about law education, the clinical legal education, it is a big question that how to impart clinical legal education, how to go to the field, how we are being able to make students experience the societal realities. Can we do something through creativity and innovation by incorporating the AR and VR things in our classrooms? expose the students to these experiences with the help of this VR technology and AR augmented reality technology. This is how I feel for the opening remarks. Thank you.
Thank you so much, Professor Pokhriyal. If I could now invite Professor Lutz Christian Wolf.
Thank you very much. Can you hear me?
Yes.
Great. Thank you. This is a very interesting and very important discussion. I'll start with infrastructure. Hong Kong, as you may know, is currently experiencing the fourth wave of COVID-19, but we have been back to in-class teaching since this term. Of course, some of the students, the international students, can't come back. And it's for this reason, amongst others, that we have to rely on dual mode teaching. So we all teach in the classroom. At the same time, we are Zooming all the lectures. The lectures will also be recorded so that students can afterwards watch if their internet is not available at time of the teaching. And of course, the in-class teaching is done with social distancing, which also requires that some of the courses cannot be delivered, as in Japan, due to venue constraints. But that has worked quite well so far. We will observe how the situation will develop, and that will then determine how we will move forward next term. But so far, so good. Everybody is quite positive and optimistic. As far as pedagogy, teaching pedagogy is concerned, Hong Kong, as you may know, had experienced the protests first, and then since January, as one of the first countries after jurisdictions after China, we had the pandemic outbreak. And that means for the last year, we have been teaching online. Much to our surprise, the online experience was much better than we thought. Students are happy. Feedback is very good. We experience, as everybody else, new dimensions of teaching. Some colleagues tell us that some of the courses, such as legal writing, are better taught online because you can share documents. You can share documents easier. So these are new aspects which I think need to be considered in the future. I think it is for this reason, and also because you can reach out to faraway areas, that online teaching will stay with us. Everybody agrees that in-class teaching had its major advantages, in particular because the teacher personality comes across in a much better way, but there are also advantages linked to online teaching. Just a very short remark. I would like to echo what Professor Pokhriyal, sorry for mispronouncing your name, has said about independent learning. I'm a great fan of independent learning, and I believe that this should be an opportunity for us to consider how we can empower our students to engage in more independent learning. Next point, technology. I'd first like to make the point that the pandemic has certainly not triggered the use of technology in legal education and in other areas. It has just accelerated the use. And I will regard this as a very positive thing. We are quite happy. I'm a great champion of flipped classrooms, for example, where we use technology even prior to the pandemic. And I think this will carry on, and everybody will learn from this situation. So there are also positive aspects about it. There are also negative aspects. I don't know whether you have experienced this morning. There was a technical problem in the United States, which meant that Zoom was not available for the whole morning, and we had to reschedule an exam, and that happened for the first time. So it's not everything is perfect. The last point, fears, psychological issues. There are certainly issues that need to be addressed. The perception of students and teachers and other colleagues has changed. We are not as easygoing any longer. But I must say, in Hong Kong, I cannot feel fear. Everybody has adjusted to the new normal, and we are dealing with it. what I think is probably a fifth dimension and which needs to be addressed is the social dimension, which again, Professor Pokayal has already addressed. In-class teaching is something which I believe is not just in order to deliver, to teach and learn, it's also a social event for our students and for the teachers, and that is completely gone if we are teaching online. And that is one of the major disadvantages. And when going back to opening our campus, your campuses, our campus is open, to open the campus again, I think the social dimension is something which needs to be appreciated and needs to be supported. I'll stop here because we are running over time already. Thank you very much.
Thanks very much, Professor Wolf. If I could now invite Professor Rajkumar to offer his remarks.
All right. Well, as a host, I'm going to mostly give away my time to my other panelists, but I'll quickly say that in a vast country like India, with so much of diversity and complexity when it comes to both governance and resources, there is clearly a dichotomy when it comes to the kind of institutional capacity for reopening campuses, including following social distancing norms. Of course, the most important challenge still being the state of COVID-19 itself, and to what extent government bodies, including regulatory bodies, will actually allow the full opening of campuses. Be that as it may, Oishik's typology of the four aspects that he has articulated clearly shows that infrastructure will, in each of those four aspects, will have different, let's say, institutional capacities for responding to it. For example, as we are probably, better suited than many other institutions when it comes to having the necessary physical infrastructure and capacities to deal with it. We're very fortunate that the faculty members are conscious and sensitive about the kind of pedagogical innovations that they need to bring towards, responding to the new normal that we are all going to have. But when it comes to technology, I think all of us, to a large extent, have adapted. Many institutions, even those institutions which have slightly lesser capacities, have innovated themselves. I must confess that this conference and also the 1,000+ webinars that we have conducted in the last 6 months or so has really democratized and provided greater access to knowledge, brought the world and Indian institutions much closer than we would have had otherwise. So there is technology has actually become a very important tool for greater democratization of knowledge, but also creating greater access as well. The aspect with regard to how the new opening up will look like, I think a lot of us are anxious about the physical opening up of the campuses, but I think many of us are also closely observing the situations in different parts of the world. We knew that many European universities and American universities, including British universities, ended up opening the campus, and then they had to close down. And if they did open up, then after having students come to their own cities and university towns, they moved into online teaching as well. So I think while all of us, particularly in residential campuses, are eager and anxious to bring the students back into campus, we can't wait to have them here. We are also extremely mindful of the complexities involved. So in that process, one of the things that a lot of emphasis has been, at least in our case, is that we have tried to see to what extent we can reimagine the curriculum, the pedagogy, the assessment, the grading, the entire framework of examinations, all those things, recognizing the situation that we are in. So I do believe that there is so much that this crisis has provided us when it comes to rethinking the way we function. But part of the things is also about learning what we have experienced and then to translate some of those things even beyond COVID-19.
Thank you very much, Professor Rajkumar, and to all of our panelists for such a rich set of initial comments. We do have some time with us to take audience questions. They're not specifically directed at any panelist, but whoever would want to volunteer a response. So let me start with this one, which takes off from what something Professor Rajkumar was saying. So the question is, and I'm going to read it out, economic capital is central to the extent and nature of measures that campuses adopt to ensure effective reopening with social distancing norms. How do you suggest one can deal with this challenge with limited economic capital? So whoever wants to take this question, I think there will, in a certain sense, be a geographical dimension to where the experience of fund crunch will be felt more than in other parts. But I'm guessing the question of the role that finances would play in enabling or disabling the possibility of reopening is a priority for every administrator. So anyone who'd want to start us off?
You want anybody specific to answer the question, Ashik?
No, it's not directed at anyone in particular, but whoever might want to take it first. So.
Okay. Is Dr. Barisa answering the question, or?
I don't see her hand up though. No, I
can volunteer.
Please.
Yeah. I think this question is not COVID-19 specific. It's a matter of finding resources to support education, in particular legal education in our case. And every crisis, be it a war, be it economic crisis, be it a health crisis, will trigger the need for additional funding. And I believe it will be, in the first place, the promoters of these education institutions to look into ways to support a continuing high-level, high-quality education through injecting additional funding, and also for the institution to look out for donations and other ways to support themselves. And maybe this is also an event which triggers thinking about additional funding models. Thank you.
Thank you, Professor Wolf.
Yeah, may I add?
Please.
In Indonesia, I think when we talk about how to fund the education in the context of the crisis like now, is that the government already set up the policy, change the policy for the at the beginning when the COVID-19 spreading into Indonesia, and then we close the campus, we close the university, and then some people asking on how to fund what we call online learning process for it's not only for university but also for all education institutions, and the government decided to shift some funding from other project into the project of education to fund it, and we also ask a number of donator philanthropy who pay attention to this issue. But as I mentioned earlier, I talked earlier that we also try to shift some of the project that we are unable to conduct it due to the COVID-19 barrier into support the student for having like a quota of internet or something like that, including the lectures. Thank you.
Thank you, Professor Bariza. We have another question, which I think does speak to some of the points that Professor Pokhriyal, that you were raising with regard to kind of, turning the focus back on the learners. So, maybe you could start us off with your response to this question, and we could, take any other responses that might be there. So I'll read out the question for you. So for all its benefits, social distancing has affected the mental well-being of several people across the globe. At least working from home has allowed students to stay in the comfort of their homes. However, if campuses are reopened with social distancing, students will have to move back to living independently in hostels. In such a scenario, how will universities address the mental health concomitant to social distancing and the pandemic? So once one kind of turns the focus onto learners in the process of reopening, what would universities do to attend to their mental health concerns?
Well, it's a very vital point because during the entire period and even before pre-pandemic world, mental health amongst the youngsters was a great crisis. And, that has been a mandate to all the universities to, provide the services of the counselors for them who can occasionally, talk to them and, try to resolve their issues and concerns, because these generations, with reference to their socializing ability is also in crisis, because most of the time this generation are on Snapchat or Instagram. So there is no screen time limitations for them. And we all know. So, they at times, the way in which the older generations were socializing, the whole socializing context is being changed for this generation. So even pre-pandemic also, we had a great concerns for the mental health of these youngsters. And probably during this pandemic time, because you are not being able to meet, you are not being able to move around, you are not able to experience different things in life. And that's the reason that probably you have a greater concerns and greater issues that you may be facing with reference to your mental health. But when we talk about the reopening of the campuses, I am individually of the opinion that the campuses should not be reopened all of a sudden, no matter whatever the investment that we do with reference to the safety and precautionary measures. But if at all we really want to reopen, it should be always in a very phased manner, and allowing the students to be there on the campus and to be there in their home in an independent way. Without having the protective cover of their parents, because the Indian family system has a very different kind of an approach and orientation towards the kids. The kind of a care and the warmth that is being provided by the family members during this crisis is something which they will be devoid of when they are there on the campus. So yes, I feel that till the time everything is being, everyone is being vaccinated and is being properly taken care of, one should not, probably I would consider that as a very inhuman act on the part of the education administrators, because no matter how much care and precautions that we do, the safety measures, the sanitization, everything we do, but campus is campus space is the space wherein you can't stop one student to socialize with the others with a lot of precautions and social distancing norms. So at times it will become very difficult for the university management to control and regulate the behavior of the students in terms of the socializing pattern of them. But yes, even when they are on the campus or when they are off the campus, and even today when they are sitting at the home, the kind of a mental health crisis they are facing, that's the reason I say that, that we need to be more human in our approach. We need to shift our focus on learners' needs rather than what we believe is the right thing or what is the learning outcome. Because this is the time wherein we require to have that hand-holding approach and human approach, focusing on their needs. And this is how probably we'll be providing the mental health support. We need to have a lot of one-to-one interactions with them. And I am pretty sure that it is going to increase the load on the part of the faculty members, because they have, they're required to reorient the teaching approaches. At the same point in time, all of a sudden they have to be more human, more friendly, more supportive to the students, catering to the needs of each of their concerns and issues is really challenging task for the teachers as well. But this is how probably we need to devise a kind of a proper mentoring and support system, even in the offline way. And online, in the on-campus thing, probably I think it is premature even to think to reopen the campus, no matter we have received a lot of guidelines from the regulatory bodies. But looking to the present crisis and the increasing number of cases, even in India, probably it's a little premature to think about the opening of the campus.
Thank you, Professor Pokhria. I've been informed that we do have some latitude with time. So I know, Professor Wolf, you need to, you have another commitment. So we'll be sad to see you leave the panel at 1, but we can go on until 2:15.
Maybe Lutz can give his closing remarks before he leaves, probably.
Sure, certainly.
Thank you very much. I unfortunately have to leave because I have another engagement. I apologize for this. This is a fascinating discussion and a very important discussion, I think, which needs to be carried on. I think the last remark about the human aspect about this whole tragedy is very, very important. We need to consider that we are dealing with humans, that all this affects human beings, students, young people who are the future of our countries. And it is for this reason that, of course, health and safety must be absolutely ensured, and that all the other aspects that we are discussing here and in other panels must come second. I will stop here. Thank you very much for having me. It was a pleasure to meeting all you, and I hope to see you again soon in a different forum. Thank you very much. Bye-bye. Best wishes from Hong Kong.
It was a pleasure to have you here, so thank you very much.
So may I have this time to, I have to leave, also have an appointment, so I must leave now. And I would like to also thank you very much for this precious opportunity. I learned a lot from your comments, and I hope we can see, although I'm very in favor of the merits of remote learning, but for the next time, I hope I have an opportunity to meet you in person and face to face. Okay, bye-bye.
We all hope the same. Yes, please take care.
Thank you very much. Goodbye.
Bye. There's another particularly important question from the audience, which in different ways our panelists did address, but this is a more pointed question about how to maintain quality standards, especially if social distancing norms would require, in the context of reopening, smaller classrooms with lesser number of people. So in effect, this would mean that the number of lectures would increase. This would also require more number of faculty members. And so how does one in fact maintain the quality of teaching as one has to kind of really thin out the nature in which teaching is conducted? So maybe Professor Rajkumar, if you could offer some initial comments on that.
Well, no doubt about the fact that, those institutions which are seriously committed towards providing, education with the highest academic standards need to put in the resources. It could be faculty resources, it could be technological resources, it could be new innovations that they need to bring in. One of the things that I have noticed, I realized, at least more personally in the course of the evolution of our own university, is that if you really want to do it well, it takes enormous financial resources. And that, I think, is unfortunately not sufficiently recognized by many stakeholders. And so we need to be sensitive about the fact that education institutions today, schools, colleges, universities, are under enormous stress to ensure that they are able to provide the best possible services to the students, to be able to have the necessary faculty members, to ensure that the faculty members' teaching responsibilities are not unreasonably long and large, so that they are not able to fulfill other commitments. So in a way, the question that you've asked is almost so central to the idea of institution building in these times. And most of the time, this particular challenge that the education institutions face are not sufficiently appreciated by even those within the institution. I think it's very, very important for us to at least put forth the fact that managing and developing new ideas in the course of the pandemic requires enormous institutional innovation and capacity, while trying to bring as much normalcy to the educational project, requires both commitment and dedication on the part of the faculty, but also, as I mentioned earlier, significant financial resources. And I'll give you an example with regard to financial resources. For example, you mentioned about the teaching responsibility. I think including, for example, people end up doing is that good are also expecting the faculty members to go beyond the call of duty. The faculty members are spending more time than they would normally spend when it comes to physically engaging with the students in the campus. The gradual, let's say, diminishing of the time and in which one meets and have meetings, all of that has changed. People are working during weekends, people are working in late evenings, people are having meetings across time zones in the morning. So in some ways, I have come to believe very strongly that the unsung heroes in this entire COVID-19 crisis happen to be educators, professors, teachers, institution builders, deans of faculties and other administrators, because to ensure that the continuity in education is not in any way affected, and to provide the best possible educational ecosystem for the students, and to protect the interest of the faculty members and the staff is no small task. And I think they deserve a lot more appreciation when it comes to dealing with this.
Thank you, Professor Ritlab. Particularly important set of thoughts. I wanted to kind of return to all three of you, and maybe we can start with Professor Bariza and then Professor Pokhriyal and come back to you, Professor Rajkumar, about because all three of you have particularly kind of spearheaded the process of making your own institutions respond to the pandemic. So what might have been the most difficult process here? And of course, there's a lot of coordination required, but there's also a certain kind of leadership that's required to overcome some of the key difficulties. So from an administrator's point of view, what might have those key difficulties been, especially those that are so intractable that it frustrates the administrator, because that, in a certain sense, that also helps us, just the way in which Professor Rajkumar was pointing out, the human side of the person who's leading an institution, instead of just considering that person as this vague thing called the administration.
You, my I first.
Please.
Yeah. What is the most difficult challenges? The first, as already Professor Rajku said, that is about how to control the quality of learning process. We do have control through the system, actually, that we have the capacity to monitor by using technology how many minutes the teacher teaching, what is this module or something like that. But some of our lecturers still did it in unprofessional ways, because they do many things. They have many another commitment. So the control is very difficult. And another second challenge is coordination. The problem is until now, since March until now, the academic staff or academic support person who are working in the law school are very limited. just only for few people, but the leader of the school should come to campus because the vice chancellor and rector are at campus for all time to ensure that everything is running well. Business process is running well. We have to think that actually the campus is not closed, but we are still walking. But the work is outside the campus. But for faculty leader, we shall enter into campus for every day to ensure that every business process is running well. And the coordination is the big issue because some of academic staff can claim that I have no equipment to work at home because all the material or the data are provided at campus. It is of course difficult to bring a computer from campus to home. That the big challenges that is facing right now. But now it's getting to counter by providing them a number of laptops that can be shared, and so there is no reason for them to what we call to excuse for the job. That the challenges that we are facing. Thank you.
Thank you for those frank remarks. Professor Pokhriyal, please.
Yeah, I agree to a great extent with Professor Nurul. Well, yes, coordination is a great time-taking efforts. But apart from that, what I feel that capacity building of the teachers, as I said earlier, shifting the focus, reorienting ourselves as a teacher, because today teachers are also the content creators, right? I need to create a content. I need to create a resources for learning. I need to create a resources for get enhanced experiences of the learning. So, the role of a teacher is being transformed in number of ways. So the capacity building of teachers, their orientation, in the same way, orientation of the new normal orientation to the students, making them prepare for the online teaching and, online assessment and online quizzes and online collaborative projects and simulations and all these things, requires a greater amount of efforts, and it also includes a lot of coordination on the part of the administrators. In addition to that, I just would like to highlight one point from the earlier discussion, if you may permit. So, Professor Raj has very rightly pointed out with reference to the quality of the teaching, and it requires a greater amount of efforts, finance, and of course on the part of the teachers as well. One thing that is missing out from the whole discourse I have been observing for the last couple of months, are we ready? Are we as a law school be able to prepare ourselves and foresee the future in the context of the curricula? Whether this pandemic is going to transform and going to change the way in which people are getting into the trade, business, and how the legal spectrum is going to be changed. And what are the curriculum alignment that we are required to do? Generally, what we do, the new insolvency law has come, we put it into the curriculum, we add as one of the courses, we enhance our elective courses. But it's a larger picture, the curriculum and alignment with reference to the post-pandemic challenges the society is going to face, the institutions is going to face, the different institutions of the governance is going to face, and the trade and business is going to face, and how this pandemic is shaping the world around us, and how we are preparing our students with reference to these new orientation, providing them the list of the courses and designing a new curriculum. So that is also probably we need to focus on.
Thanks a lot, Professor Pokhriyal. Professor Rajkumar?
So, Ashik, I didn't quite fully get the question that you wanted me to answer. I know that both Professor Mirza and Professor Pokhriyal did respond. So can you quickly...
Yeah, the question really was that, what are those primary challenges that as administrators you've had to work through? And when I use administrators, I mean, these are human people who are also facing a range of difficulties, not only as leaders of an institution, but those who also have to kind of negotiate other parts of their lives through this pandemic process. So to think about the administration as a human person rather than this kind of,
Well, one of the things that one good administrators need to remember is that no good act will go unpunished. So it's a constant, thankless work that one has to do. But I think this particular pandemic also, one major challenge that all of us faced is that the extraordinary degree of uncertainty on the basis of which one had to take decisions, and one had to follow one's own gut instinct when you do it. So, for example, in the month of March, most of us believed that it might just be a month-long problem. And then by April, people were thinking it may be another month or so. And then when May, people began to think it is going to be a couple more months. So in some ways, we were all trying to, a little bit predict the future, but then consciously aware of the fact that we can't, and hence had to reimagine many things. So I think the most important part of that exercise is that decisiveness in leadership does matter. This is a moment when institutions expected to have decisive leaders. It expected a higher degree of communication. Never before so much of communication was needed across all stakeholders. It also expected people to have high levels of consultation with different stakeholders. Again, in the normal course, one could have taken decisions and did not consult, but since this particular aspect had a huge impact on all stakeholders within the institution, the consultation was definitely a major challenge. The fourth aspect of the leadership that was expected is innovation. Innovation at all levels, be it in examinations, in assessment, in entrance examination, moving towards technology. The fifth was also, of course, making certain investments as a priority, and in that context, make some tough choices and tough decisions. So, in a way, it has been a very continuous journey. It's not even over yet. As Dr. Pokhriyal seems to be much more confident about the fact that we'll all get a vaccine soon and we will be vaccinated in the next several months. And I would like to believe that. But the point is, we are constantly working in that space in which there is so much of uncertainty, but yet we need to decide as if we know it. And that's not easy because, and people, particularly students and their parents and others who believe in our institutions and our leadership also expect us to provide that guidance, that direction, that sense of confidence when we don't have it ourselves. So in a way, there is so much that goes into in all of us who are doing what we're doing. But I must say that the heart of this type of activity or leadership is more about taking responsibility in one's decisions rather than asserting what one does with the sense of confidence, frankly, which does not exist. All of us are learning and constantly reinventing ourselves. And as we are reimagining and transforming not just the institutions, but also ourselves in this process.
Thanks a lot, Professor Rajkumar. I think that's quite a telling note to bring the session to a conclusion. In fact, what you said, because a lot of this period has been a period of gloom and disdain and worry. And so, you use the word uncertainty. I think uncertainty is accompanied by contradictions. We are kind of second guessing our moves while trying to be confident. It kind of reminded me of the German theater practitioner Bertolt Brecht's, very well-known quote where he said that in the contradiction lies the hope. So I guess, that's what we would possibly have to hold on to, at least to imagine what a post-pandemic reopened campus might be like, even if it's something that is only a blueprint as of now. So I take this opportunity to thank all of our panelists for taking out the time and for sharing your very important thoughts. Thank you very much.
Thank you. And thank you so much, Dr. Pokhriyal, and thank you, Mr. Marisa, and thank you, Aisha, for sharing.
Yeah. Okay.
Thank you.
Okay, hope that we can meet you again in another occasion, in another forum. Yeah.
Thank you.
Take care, everyone. Bye.
Yeah.
Good afternoon from India. Good evening to my friends in Far East. And of course, good morning to people in North America and Canada. It's such a pleasure to welcome all of you to the second day of this global virtual conference on reimagining and transforming the future of law school. We are in the 15th thematic session of the conference, which is entitled Shifting Focuses in Legal Research During the Pandemic. We have a very distinguished set of legal education leaders, transformative individuals, and researchers who have played their very important part in institution building efforts during this time. We have with us Professor Dr. Susan El Karmanian, the Dean of the College of Law at Hamad bin Khalifa University, Qatar, Professor Dr. Bertil Emrah Oder, Dean and UNESCO Chair on Gender Equality and Sustainable Development at the Faculty of Law, Koç University in Turkey, my very dear friend, Professor Tan Shenghan, Dean of the School of Law of the City University of Hong Kong in Hong Kong. My own colleague here, Professor Kagesh Gautam, Associate Professor at Jindal Global Law School at OP Jindal Global University. And the session will be moderated by another colleague of mine, Professor Dr. Vishwas Devaya, Vice Dean of Jindal Global Law School at JGU. With those words, I would like to now hand this over to Vishwas, and I will join in a little later. Thank you.
Thank you, Raj, and thank you for that lovely introduction. Getting on to the theme of the session itself, which is largely looking at shifting focuses in legal research during the pandemic. All of us do understand that the pandemic has pretty much kind of, pretty much kind of created, things go, created a havoc, wherein it is pretty much kind of forced people to get into research areas which they probably have not thought of in the past. And of course, a lot of the pandemic research, especially in the science, is actually going into trying to understand the virus, the way it works, trying to actually come up with a vaccine that can actually deal with the coronavirus. Whereas a lot of social science and legal research is now focusing on what kind of impact the pandemic has had in terms of society and life, and more specifically within the realm of law, various aspects of law, including stuff like contract law, corporate law, evidence law to an extent, criminal law, and areas like bioethics and health law have largely kind of started focusing on the pandemic itself and the kind of impact it has had in terms of how law and legal research tends to operate. So this actually brings in a whole range of questions that one really needs to address. And I have pretty much kind of flagged 4 specific concerns out here. More specifically, are we kind of making a shift in terms of our research where we are largely focusing on various aspects of law and society, bringing in the element of the pandemic and the COVID scenario at play? Has it resulted in certain changes in the approaches as far as researchers are concerned? Has it kind of, pushed legal researchers more specifically to kind of get into multidisciplinary research? Has it had an impact in terms of how funding has actually gone about? How has research funding and grants changed during the pandemic time? Has there been a shift, a paradigm shift in terms of the funders actually kind of preferring research that is largely related to the pandemic, regardless of the fact that it is within the field of law itself and many areas of law itself? And of course, the other important element which is part of research is dissemination. How has dissemination gone about when the pandemic hit us? As the last 9 to 10 months pretty much kind of resulted in publishers actually going and clamoring for more publications related to COVID-related aspects. Has this kind of made things easier or difficult for legal researchers? How are law journals, law reviews kind of reacting to this kind of clamoring for articles and publications, which is largely focusing on the pandemic? And lastly, of course, a very important element in research that we all need to keep in mind is, of course, the students. We have students researching at various levels. but at level of doing their dissertation, at the level of doing their doctoral theses. How has this kind of impacted, their research, and what can law schools actually do to kind of enable them to pursue their research? And that's largely the four segments that we will be dealing with. And I'd kind of, shoot off my first question, which is largely, has the pandemic resulted in a lot of legal researchers focusing on pandemic-related issues, even within the realm of law, as a lot of research kind of started now focusing on COVID and its impact on various aspects of law? If so, what are the motivations? What is the guiding force for researchers to kind of actually move or make the shift? What kind of adjustments do researchers have to make? And the second aspect of it is, has it really forced, especially legal researchers, those scholars in law, to kind of look at it from a multidisciplinary approach? And to what extent have law schools kind of accommodated and encouraged multidisciplinary research during the pandemic time? Over to Professor Cheng Han.
All right. Well, thank you very much, Professor Vishwas. You've actually raised a number of issues. I'll try to deal with them as concisely as I possibly can. I would say that there's of course been more focus on pandemic-related issues, because that, as you say, is the issue of the moment. But I have to say that, for many of my colleagues and many of the other people I collaborate with, they continue to work in the areas that they specialize in without necessarily any reference to the pandemic. So in many ways, life still goes on as it has in the past, right? But what I've certainly seen a lot more of are people working in the fields of public health regulation, in constitutional law and public law, certainly turning their attention to pandemic-related issues, because that's had a greater impact directly on the fields that they work in. Particularly the extent to which there might be infringements even of civil liberties. So I think that's certainly very relevant to them. But I think for the most part, people have continued to do their work. I've also seen, of course, some publishers being more interested in this area. I recently contributed a chapter to a collection of essays by Oxford University Press. But again, I think that this is to be expected. There are always topical issues that emerge from time to time. There's interest in that, but ultimately, the law is about general principles and general approaches, and I think it doesn't stop research going on in many other areas as well. Certainly, the interdisciplinary part of it is quite important. We are certainly trying to push that, but more as a general approach, because I just think that interdisciplinary research is good for law academics as well. It broadens our perspectives. It makes our ideas more informed and more grounded in reality as well. And it opens up new insights into the law that we might not otherwise have been alive to. And so for instance, one of my colleagues has put in a COVID-19 interdisciplinary research project, looking at it obviously not just from the perspective of law, but from the perspective of business and social sciences as well. And I think that these three areas really do have a convergence here, because the economic impact of COVID-19 is immense, both at present as well as its anticipated future effects as well. And certainly on the social side of things, my goodness, the social impact it has on people and how they're going to cope with this, both now and in the future, is also great. And what kind of legal framework might we then have to try to manage this as efficiently as possible? These are big, big ticket issues. And I think COVID-19 has certainly given us more scope to find real areas of interdisciplinarity where things do fit in and work quite nicely together. So maybe with these comments, I'll pause here and let my other colleagues jump in. Thank you.
Professor Kugesh.
Thank you, Vishwas.
I think I agree with the suggestions, the remarks that were made by the first speaker. I think if I was to put it in my words, I would say that a shift of focus is necessary in times like these, but you must know very carefully what you are shifting and why. Now, I think I would agree that attention has certainly been shifted, but the deeper concerns, they continue to be the same. I can give you a little bit of an example from my personal experience. Since the beginning of the pandemic, since the beginning of this year, when there was nobody could see, for example, in December of last year or January, that there would be a lockdown so soon. It was not something on the horizon. The concerns that were there, at least in my particular case in the research, they continued to be the same. One of those concerns, for example, was a delay in quotes, about which I've written briefly with Vice Chancellor Rajkumar as well, and myself. So that is something that we have always been paying attention to in the law school. My colleagues before have done it, and this tradition will continue. But one of the things that suddenly came to my attention was the fact that there are a lot of cases in the criminal justice system that we don't actually have to prosecute. There is no reason for that. And taking that approach, for example, there are a lot of check bounce 138 cases. Now people in Delhi have started saying that this is essentially a civil problem. There is no need to have a criminal case. And there are issues like that which keep on going on. But working with a team of dedicated students, and we did all this online, about which we can speak perhaps later, but we were able to identify that if, for instance, cannabis is legalized in India, suddenly a lot of pending cases will disappear from the courts. There would be no need to prosecute these cases, no need to investigate these cases. Proportionately, that much resources, that much money, public money, is also available to be spent for other endeavors. So we worked on that, and slowly some recommendations followed. And the concern therefore remained the same, but the pulls and pressures of the pandemic that eventually we all have to deal with, they certainly brought other possible solutions to our attention, solutions that perhaps might have escaped attention if there was no pandemic. That's what I had to share. Thank you.
Professor Susan?
Thank you very much. And it's an honor to be here, and I'd like to thank Raj for the kind invitation. I think what the pandemic has done, and this is picking a bit on Dean Cheng Han's theme, is that it's caused each faculty member to look at their subject in a different light, not to wholesale say I'm shutting down my work in constitutional law and I'm going to focus only on X and Y, and that obviously is a predictable response. Yet I would like to pick up on a theme that I think Vishwas, you touched in your introductory remarks, and that is that if we consider human rights from the perspective of the right to health, then I think we're going to start focusing more on some of the profound changes that could develop as a result of the pandemic. Since we've seen a rights-based society develop since World War II, we have constitutions that talk about rights. We have, of course, the treaties and the like. This has had a strong focus on the individual and claims individuals may have against the state, and freedom of expression, the ability to gather. Of course, there are going to be there's always a conversation of religious freedom, the ability to gather, and limits that are put on that, and the like. But I think that with the pandemic, what we're seeing is the need to re-examine the role of the state in this process, and invariably under certain constitutions, as well as under various national laws, or even under human rights treaties, there is the right to health is recognized. And here in Qatar, the Constitution mandates that the state take action to protect the health of individuals. And so I think one of the more short-term and long-term implications is, to what extent are we going to move beyond this this rights approach that has an emphasis on the individual. If I could just quickly touch on the multidisciplinary approach, and I think that it's incumbent upon law schools to reach out to our faculty in engineering, in medicine, and computer sciences and the like. Many of those faculty don't want to hear from lawyers. They want to conduct their research freely, and it's only after they create the technology, the tracing technology, or it's only after they have started to get some important data about each individual that they say, oops, what can we do? What can we do with this? And so having outreach early and coordinating some of their work, getting legal perspectives on the table, I think is very important. And I can just give you an example. I think what's been going on with online medicine. People can't go to the doctor, so now the doctors are online. Well, what are the legal implications of that? And so my colleague here at HBKU is working with Weill Cornell Medical School, which is just across campus, and they had a conference or a workshop dealing with the legal implications of getting your diagnosis via this medium.
Right. So, Professor Burton.
Thank you very much for your very kind invitation to this utterly significant event. The COVID-19 crisis has a huge impact, not only on the legal architecture of different jurisdictions, but also on the legal assumptions, prepositions, frameworks that have been developed in years. And from emergency regimes to the socioeconomic crisis that Susan has recently mentioned, we have witnessed both the responsiveness and the incompetency of the current constitutional or statutory structures. And in the field of private law, there are various challenges as regards to application of force majeure clauses or the clauses to be applied to temporary non-performance of contractual obligations. In general, the COVID-19 has had a disruptive impact on the constitutional premises and the legal settings that inequalities, injustices, and particularly the vulnerable groups come to the forefront. The parliamentary oversight has been impaired in most of the jurisdictions, that we face the reality of the augmentation of the executive power due to the rapid responsiveness in crisis management. Another phenomenon is the expert committees. The expert committees composed of health professionals have played a very significant role in the decision-making process in most of the jurisdictions, but the lack of transparency and the rise of technocracy both have replaced the democratic oversight and legitimacy. And the COVID-19 has led to a convergence, in fact, between entrenched democracies and the electoral democracies and electoral autocracies as well. In this respect, particularly the crisis management in form of declaration of emergency or using different tools of soft law is quite remarkable. However, we truly observe that the principle of legality, the erosion of civil liberties, and in some of the jurisdiction, the erosion of socioeconomic rights, and in some of the jurisdiction, the endorsement of the right to health, as well as the right, the welfare state, have been similarly challenged. And under the pressure of current economic regression, disruption of the rule of law and the inequalities, including poverty issues, domestic violence, scarcity of public resources, there is an urgent need for a revival of critical theories of law, however, from a new perspective that COVID-19 has underlined. And here, the class, gender, race, equal distribution of economic wealth, nature, the climate change, strong democratic, as well as international institutions should be at the center of legal research. And such a critical studies of law should also go hand in hand with a global approach to the legal teaching and research, both in the field of theory and applied disciplines of law. I generally think that the policy-oriented legal research may play a more significant role in the aftermath of the pandemic. And in this respect, not only the multidisciplinarity, but also interdisciplinarity should play a crucial role.
Right. Thanks a lot, Professor Bottle. And taking a cue from what you've said, it also kind of raises a very important question, especially the pandemic struck at a time, obviously, when there are a lot of doctoral students, young research scholars who are kind of embedded in our law schools or who are kind of pursuing different kind of research. And of course, you have master's students pursuing their dissertation. How do we really, within the law school framework, kind of encourage students to kind of pursue research? What impact has the COVID had in terms of how students have kind of re-emphasized and refocused their research? How do we even ensure, one of the biggest problems, especially students who are doing or pursuing empirical research, is the fact that the COVID pretty much kind of put a halt to any kind of field-based research. So how do we as law schools kind of encourage students to kind of pursue research, and how would we accommodate certain kind of research endeavors of students? Professor Tan?
Well, thank you. And I have to say that this is a challenging question to answer. I would maybe start by saying that I feel very sorry for many of the students who are pursuing their doctoral studies today, because many of them, no doubt, are looking for academic appointments. And I think that academic appointments in the next few years are going to be very challenging to get, because there's been a general cutback in funding for higher education. Not only because the public finances of many countries are going to be stretched, but also because it's been more difficult to admit foreign students, and many law schools depend a great deal on foreign students as part of their revenue. So I think that's going to be a real challenge. So if you're a PhD student, how can you, in a sense, try to differentiate yourself? I mean, I think that's fundamentally, the question that you've posed. I would say this, the pandemic has really opened up important avenues, and I think created a sort of laboratory within which we may well have a once-in-a-lifetime opportunity to observe and comment on. I mean, a number of my colleagues have already said, for instance, that there are challenges on the part of constitutional lawyers, there are civil liberties issues, and so on and so forth. Questions to which you have to weigh public interest against private rights. And I think it will bear, I think, dividends if one were to sort of consider these issues using the COVID-19 pandemic as an experiment, just to try to draw out, and here I need to stress this, just to draw out general conclusions and normative answers that could well apply beyond the COVID-19 situation. Because the last thing that you want to do is focus very narrowly on COVID-19 research, such that the work that you've done becomes not terribly relevant once we ride out this crisis, right? So you need to look for normative answers. You need to look for lessons that are of greater interest, broader interest to humanity, to legal systems, to the whole idea of the debate between rights and between the common good. I think if you can focus on drawing out the broader lessons that we can learn from the COVID-19 situation, you will perhaps be in a very good position, because you will have made the most of a very difficult situation. Thank you.
Thank you, Professor. Professor Kurgesh?
Vishwas, thank you for that question. I'm personally very grateful, because I believe I'm the only one on the panel who can answer that question from the student's perspective, because I am a doctoral student right now. So for the record, I'm enrolled in an SJD program at Maurer School of Law, Indiana University, Bloomington, under the guidance of Professor Joseph Hoffman, who's my thesis advisor and a wonderful guide. Now, I'm going to answer this, Vishwas, completely from the perspective of a doctoral student. Now, surprisingly, before I left last year in December, my arrangement with my thesis advisor was that I'll go back to India, and my entire work is doctrinal. All I need is access to a decent library, a lot of literature review, but most of what we do, as you probably know, goes on in the head. We don't have to go and collect any data. So on that side note, I think doctrinal work can continue, but my arrangement with my advisor was that I would make a Google Doc and I will send in the link and we'll do a WhatsApp call and we'll manage this way. I did not know Zoom existed. It did. I had no idea Zoom existed, and a FaceTime call was far too problematic. I did not know screen share existed. Now, as a result of all this, I was able to do what I actually had to do much more efficiently by planning a Zoom call and sharing my screen, and then he gives me his comments and so on and so forth. So I think that way it's much easier for my thesis advisor, who's sitting in a completely different time zone, to guide me, and for me to be able to take time with him. And this is the same experience that I have had with the students who have worked with me. So I think, see, one thing that I saw, that in the beginning of the session, speaker said, and then throughout the sessions yesterday also, many people said the same thing. I think all those on this panel will agree with me that the new normal that's going to come out of this, it's not going to be the old normal that we are used to. That's not going to happen. Some version of, some sort of hybrid is going to come out. And my experience and that of I've spoken with my friends who are practicing law in Delhi and Bombay and Bangalore. I've spoken with my professors abroad and some of my lawyer friends. And everybody seems to be of the view that a hybrid is going to come out. So for example, in Supreme Court, online hearings highly likely will be continued, but whether they will be for the miscellaneous days, Monday and Friday, or for actual regular hearings, that seems to be something that in due course people will have to decide. And I think the same is going to be true of academics. So I think that's the what. So one thing that was said was the speaker before, he talked about academic appointments, and I think the manner in which academic appointments have been done in law schools, at least in law schools that tend to have a common law shared heritage, for example, India or that in Singapore or that in the West. I think the criteria on the basis of which appointments are made in law schools, at least in these shared jurisdictions, will have to be completely rethought whenever the new normal is, which I hope will be so soon. I think the ability to deliver online is going to be a key factor. And I think the people who are good with these technologies, they're going to play crucial roles as we go along. They should anyway, because I think some sort of hybrid is going to remain. And in that hybrid, meeting with students, conducting office hours, conducting tutorials, dealing with seminar courses, which earlier would have to be scrapped for the availability of, so 10 people have to enroll, only 6 did. I think a lot of challenges can be now done away with, but along with that, I think people using this technology will have to evolve. What that would look like is for us all to see, but I think that is an inevitability that can't be denied.
Professor Susan?
Thank you. Let me get back to just sort of the premise of the question, and that is that are we going to ask or encourage our students to do a wholesale shift? And I think Dean Cheng had picked up on this. I think what we need to do is to look at what has happened and ask our students to look at the assumptions that they have made. Like if somebody is working on a dissertation or a master's thesis that doesn't make reference to perhaps duties individuals now owe to society, the duty to wear a mask, the duty not to go out of the house, and if they're dealing with individual liberties, that would be something that would be missing, I think, if we have a student who's working on a major constitutional paper and the like. I am very cautious first in advising students to take a topic that they want to work on that will be socially significant. I think it is absolutely incumbent upon us as faculty to alert students to issues that could be relevant. And clearly out of this pandemic has come a whole host of relevant issues. Let me just pick up on a second point. Students do need access to sources. A lot of our students work with library sources, and the good news is that we have access to substantial databases and the like. I find it a bit challenging unless the students have been completely trained in using them to getting them up to speed even through this medium. But I think that one of the important developments is the extent to which sources are now more readily available, open sources. I think this is going to have a profound change on research. Have we now got past a lot of firewalls? Because otherwise, when a large portion of the world is dependent on getting information online, yet they can't afford the substantial cost of this information. I know that a number of publishers are offering a lot of that information, and it's incumbent upon us, again, as faculty to help steer the students to those sources.
Okay. Thank you. Professor Burton?
Many thanks again. In terms of library sources, we had to enhance our databases considering the needs of our PhD students, our Master of Law students. In general, we had a threefold strategy, which is based on the meetings, establishing certain milestones and providing support, particularly to the PhD students. We have organized, and we still organize regular individual meetings, ideally monthly. However, we also organize weekly or bi-weekly meetings with the students to talk beyond research as how they are doing. And we also run regular research group meetings, and we have tried to establish a network that the PhD students may share their progress reports with their own community so that they can receive the feedback from their peers. We organize different types of meetings, not only for our own PhD students. However, we organize graduate workshops gathering the PhD students globally or at the domestic level. We have tried to set realistic and achievable milestones, and these may need to be revisited as COVID-19 situations shift. And we try to celebrate, in fact, even the smallest of the success. We try to provide an empathetic ear and to be aware of the fact that we cannot solve all the problems. However, we are aware of the counseling services that our university offers, and we try to openly discuss the support issue, because the mental health issue can be also a problem besides some of the financial issues, and we encourage the students to take the advantage of support of the universities offering. And we also try to be sure to look after our own well-being too, because this is also crucial. I also hold the UNESCO Chair on Gender Equality and Sustainable Development, and we have organized the chair as a research hub, having a very strong multidisciplinary perspective, that we organize different types of events for sharing our experiences in the field of research. And in the meantime, we have developed a very strong focus on research methodology, because it seems crucial when we take into account the shifts towards the policy-oriented research, evidence-based research, empirical legal research, and it was just a advantage for the PhD students, because now they have the opportunity to rethink about their own research methodology in line with the recent developments.
Thank you, Professor Bertel. A very closely connected aspect related to research is, of course, the resources required to actually run research centers and certain kind of research, which is largely financial aid, either in the form of research grants or big funding coming through big organizations. Do you think, to all the panelists, do you think as this pretty much kind of, as COVID kind of created a shift in priorities as far as funding in legal research is concerned, do you think there would be a forced reallocation of research funding and grants towards research that is catering to COVID-19 at the expense of research areas funded prior to the pandemic? And do you envisage post-pandemic, is there going to be a recalibration in terms of funders and those who kind of allocate grants? Are they going to kind of rethink their strategy for funding legal research? Professor Chan?
Yes, I think that actually the major problem for law schools is, the extent to which a lot of the, well, let me put it in a different way. I would say that funding agencies and funding institutions are always looking for research that has an impact, right? That's novel and that can make a big impact, because obviously they want their money to have the biggest possible bang for its buck. And there's always no doubt that year on year or over every 3-year cycle, there are bound to be certain issues that are more topical than others and where the attention of the funding agencies will be more directed at. So the pandemic may be an obvious situation of this, but I think it is something that law schools around the world have always had to navigate, right? It's nothing new in itself. And therefore, to that extent, I don't really see a major shift, because as far as law schools are concerned, it is incumbent for us to, if you like, fight our corner, right? We need to, as we have in the past and we have historically, we always have to go to funding agencies, very often dominated by scientists and engineers, and tell them why legal research of this nature is impactful and novel. And I think this is a wider problem that generally people in the humanities and social sciences face. So I think this is in many ways an old problem. And I think we just need to continue to be smarter about it. And sometimes linking the research that we do to the topics of the day is one way forward to try to bring in more research money, and yet at the same time, do fundamental research that is useful to the law as well.
Right.
Thank you for the question.
Thanks, Professor Chang. Professor Kogesh?
Thank you, Vishwas. I think the question has two elements. One is the source of the funding, second, the application of it. I think so far as the application of the money is concerned, I mean, to what ends the money will be used, I think that authority ultimately vests in the person who actually has the final decision to spend that money. To that extent, if the government decides to, I mean, any state, not just the government of India, any given state decides to use the public money to fund COVID-related research in sciences as well as the law or other humanities, I think that's a decision ultimately that the elected representatives of the people make. And ultimately it's the public purse, so there will be no dispute with that proposition. But I think as we move more towards solution and management of the issue, I think eventually there will come a point of time when those concerns will change, and I think public concerns should be left with the public. But I think so far as the spending of that money institutionally is concerned, private institutions such as ours and across the globe, I think it'll be quite COVID-related research. See, if somebody comes and says that there are many ways to link any research project with anything, if you have enough command on the English language, and you played a little. So I think at that point of time, the role of the senior people in the academic profession becomes very important. And I think people who know that this is actually useful research, and this is just a way to get across, try to convince people to spend money on where it shouldn't be spent. I think that's where people who are much higher than at least me in this field, I think one should rely on their guidance and one's own gut feeling. And ultimately, I think as far as the source of the money is concerned, public spending notwithstanding, I think philanthropy is going to be the way forward. I think Raj might want to say a word on that at the end, but I think the money coming from industrial houses and so on and so forth, but with no riders attached, though that's an ideal world, but I think that's the objective anyway, to achieve a world as close as possible to the ideal one.
Right. Professor Susan?
Yes, I think that we need to look at the question from the context of the consequences of the pandemic. And in my mind, there is no doubt that one of the biggest ramifications is the fact that we now have society that is communicating through this medium, conducting business through this medium. And so when we consider the pandemic, I'm looking at the consequences and roughly by way of digitalization. And that concept has resonated, at least with some funders here. We recently submitted and got a grant for work in the area of digitalization of trade finance. And thinking about ways in which our communities, and a number of the speakers have already alluded to this, are going to be completely different, whether it be law related, such as courts, okay, in the way courts will be doing their business and the like, or whether it be, as I mentioned earlier, with medicine. But further, I think we are going to see some profound changes in the regulatory regime. Think of the ways in which a vaccine is coming to approval on sort of a fast track basis. What changes have been made? What assumptions did we make about the way things needed to be done? Are we changing anything? And what perhaps would enable us to have a better regime that is more cost effective and the like. And so the pandemic has caused us to question a lot of things. It opens up so many new horizons. So we're not submitting proposals, COVID-19 and whatever. Instead, it's looking at the consequences of this. And in that respect, I don't think we'll ever go away from the profound effect that digitalization is going to have. And also in the area of data privacy too. So,
Professor Burton?
The funding opportunities always shape the research, and this is equally valid for the legal studies. In May 2020, the European University Association has published an official briefing, and in this official briefing, the association noted that the pandemic is likely to affect income resources for universities across Europe, and that this impact may have a far-reaching ramifications. And according to the European University Association, again, as the countries digest the economic consequences of coronavirus crisis, there is a significant risk that public funding allocations across Europe will decrease in the next 2 to 4 years. Then considering particularly the competition for public resources across various sectors of the economy. And that is the reason, there are good reasons we should worry about research contracts, philanthropic sources, and other types of university income will be also affected. And the probable post-pandemic economic recession will play a key role in this respect, and the competition, particularly for the European Union grants, may increase to an unsustainable point. However, both for the Europe, particularly for the Horizon 2020 program and the new Horizon Europe program, there are also different types of opportunities that may enhance particularly multidisciplinarity and interdisciplinary research. Of course, there is a shift in priorities, but this also opens a new avenue for developing new research ideas and opening a space. In the field of human rights, the neglected areas such as gender equality, domestic violence, poverty, the democratic institutions may again gain importance, not at the expense of nanotechnology or similar science and engineering disciplines, but for the benefit of social sciences, including the law. In case of Turkey and in case of many other countries, they have also witnessed rapid response funds for research related to the COVID-19. And this has been also a very good opportunity for making the right assessment. We have to wait and see the announcements as regards funding. However, we should be rather cautious and careful to follow the developments in terms of income.
Thank you, Professor Batul, on that. I want a quick response from all the panelists, more specifically with respect to the area of publication. And we know that with the advent of COVID, a lot of in-house, law review journals, publishers have emphasized a lot on COVID-related topics to be published. Is there a serious problem in terms of trying to kind of, it's almost like, first to get to publish, and law reviews want to kind of publish on areas and topics related to COVID. Is there a problem related to that kind of an approach? How can we address concerns where we ensure that there is quality in terms of publication as well, because everyone wants to hurry and rush and get publication, something related to COVID. And we've seen in science-based journals, there have been a number of instances where there's a backlash and there have also been withdrawal of articles. So how do we ensure quality, and how do law reviews kind of tend to respond to situations like this? Professor Tan? I think you need to unmute.
Yeah, so thanks very much for that question. And I think we can kind of look at it from three perspectives. I think first we have we have a lot of online platforms now where you can, in a sense, self-publish, SSRN probably being the most well-known. I think I'm not particularly worried about those platforms because many of us understand that this is not peer-reviewed work. It might even be exploratory drafts in progress. And I think people tend to look at them and, in a sense, take them for what they are and sort of look at them very carefully as well. Then you have perhaps an output of books that try to capture COVID-19 and all its legal and socio-economic implications. And I think, in this field, I think a lot really depends on who the publisher is, who the editors are as well. And I think that's certainly one indicator. But I think, again, for anybody who's a serious researcher, you can't just take it at face value, right? You've got to exercise good judgment in terms of, what is credible and what perhaps might be a little more questionable. As far as journal articles are concerned, I think that with respect to the very best journals, well, obviously, certain things can get through from time to time. Again, I think the quality is generally quite high because there's really rigorous peer review. I mean, I just submitted a couple of pieces this year, and my goodness, the peer reviews are very rigorous, and I think that makes the final product even better. So I think I'm less worried about that. Now, to your question of whether there's such an emphasis on COVID-19 type work that other scholars who are not quite so interested in this area or don't work so much in the kinds of intersections with this area might suffer, I personally have not found that to be the case, because I think at the end of the day, with the very best journals, with very good journals, they're ultimately looking for quality pieces. right? And quality pieces really are pieces that have a certain novelty to them, that really push the avenues of our thinking, that in a sense advances the field of knowledge. And frankly, in whatever field, as long as you meet that criteria, any good journal will be interested in getting the piece. Maybe you have to queue up longer. We all know the queues are getting longer and longer, but you will get an admission ticket at the end of the day. Thank you.
Right. Professor Gagesh?
Thank you, Vishwas. I think I agree with Professor Tan to a certain extent. I think it's undeniable. It's a force of nature that a lot of publications will now have a more COVID central theme or a COVID central focus. I think that's something that nobody can dispute. It's bound to happen, and it's been seen to happen from time to time. So nothing special there. I think if I understood Professor Tan to be correct, which is also my own impression, the standards of peer review and the internal standards by which quality is maintained, the existence whereof I think is paramount to having any good journal, as you from your own experience are very well aware of. Now, those have not been affected by COVID. As I said, attention has been shifted, but the core concerns, they have to remain the same. And if they don't remain the same, I think our institutions have enough history and practice of precedent to make course corrections. So I think I think it's possible in some journals, suddenly a lot of COVID connected publications come, but ultimately I think that course will correct itself. Secondly, I also have published a couple of pieces recently. None of them even used the word COVID except for a short newspaper article. So I also personally have not really experienced this shift in the standards, which ultimately decide the worthiness of the product that you have created. So I think to that extent I agree.
Professor Susan?
Yes, I think that we've seen in blogs sort of the focus on the topic of the day, and this is the topic of 8 or 9 months now, and that's a convenient way to at least have a conversation and not have quite the standard of the peer-reviewed publication and the like. But in anticipation of today's session, I talked to some of my colleagues about this very subject, and there are these journals that may have an issue dedicated to COVID and the like. Okay, but in terms of the wholesale shift, I agree with the other speakers. That said, a colleague did mention that he's been doing a lot of work in the area of the blockchain. And we actually had, getting back to sort of the research areas, looking at blockchain and smart contracts and dispute resolution. That's one thing, again, getting back to the digitization. But he recently got an article accepted, blockchain and clinical trials. And mind you, it's not COVID specific, but there may be a greater interest in the subject in light of what we're going through. So again, it's looking at the full ramifications of the pandemic and what does this mean for various aspects of society and the extent to which faculty members, students can contribute and perhaps build legal capacity in certain areas, I think is the absolute critical focus. And the quality issue, I would agree with the other speakers. That's law reviews don't crank out publications in two months. It takes a long time to go through the various peer reviews to finally get your article out there.
Yeah. Thank you, Professor Susan. Professor Bertel?
I totally agree with my colleagues. Some of the journals have issues, of course, spatial issues on the pandemic. Some of them have not prioritized the pandemic at all. However, we need research on the social and economic impacts of this crisis to assist policymakers to understand the impact of current legal interventions. Because we should be very cautious and we should prepare ourselves for extraordinary times, not only as regards of this serious pandemic, however, as regards natural disasters, including the ramifications arising from climate change. We need this to plan future policy to mitigate unintended consequences of such extraordinary responses. We need to map and understand the legal challenges as to the social disruptions, including closing down parts of the economy, increasing unemployment, forcing some people into social isolation, restricting the freedom of movement, closing schools, universities, reducing democratic decision-making of governments, and generally disrupting the social order of the pre-COVID-19 world. Although some journals have not opted for a special issue, there are rising topics related to the pandemic, such as right to health, risk society, significantly digitalization, and the role of experts and their epistemologic authority in a democracy, neoliberal constructs, or biotechnology and the law. Another serious issue is the open access. In case of the EU funding, open access plays a very significant role. And the European Code of Conduct on Research Integrity states that researchers, research institutions and organizations should ensure access to the data. And the data should be as open as possible, as close as necessary, and very appropriate, in line with the principles, the so-called principles, the FAIR principles for data management. These are findable, accessible, and interoperable, and they're reusable. And all partners in research collaborations agree at the outset on the goals of the research, and of course on the process of communicating their research as transparently and openly as possible. However, the open access should not remove the responsibilities arising from research quality and research integrity. That is the reason we need a clear framework to remind and impose the rules of research integrity to protect the quality of the publications. There are various conferences and symposia discussing this very significant issue. However, this issue has not been tackled right now because of the predatory journals in the field of open access, and there are various other issues of research integrity related to the open access.
Okay. Thanks, Professor Bertel, and I thank all the panelists for such rich views and perspectives on these various questions, various aspects that we've dealt with. Interestingly enough, I hope we have just about enough time for a question. We've had a set of questions asked by the audience. I'm going to read out one of the interesting questions that, we have the time to kind of take at least one question. What are the new initiatives taken, and what are the various research tools used by universities across the globe to ensure that the fundamentals of research are not compromised? Obviously kind of the pandemic throws a whole range of challenges. And how do universities deal with an issue like this, especially with lockout, with virtual kind of functioning, when people pursue research? How do we ensure that the fundamental blocks of research are not compromised? So, any of the panelists?
I'll be very succinct. It boils down to one word really, which is culture, right? And that sort of culture is built up over time with proper leadership, with deans and associate deans who have a genuine sense and understanding of what it means to be a scholarly institution. I think we have that and we can preserve this. We might run into crises from time to time, but the fundamental mission of the university and what everybody appreciates to be our role will not change.
Right. If I could chime in on that, and it needs to be understood, the culture, but also to the extent it could be put in writing as reflected in a policy, and also for the faculty supervisors to instill that in everything they do with each of the students. It's building it from the ground up so that. And I think Bertel addressed some of these concepts in just the last few seconds of her remarks about standards within the European Union too.
Bertel? Yep. Something to say?
Yeah, I totally agree with the explanation as regards the culture and the policy, and not only the universities, but also the national research institutions, as well as the academies of sciences and humanities should play a crucial role to keep the value of the fundamental research under current circumstances. And there are ongoing studies to emphasize the significance of this fundamental research, and there are also different types of schemes and programs developed by the national research institutions and also by the international actors such as the EU, and there are also different types of developments under European Research Council projects to support the fundamental research, however, to keep up with the developments or the stress created by COVID-19 pandemic.
Okay. Kagesh, do you have, Professor Kagesh, you're on mute.
Sorry, may I just ask you to briefly repeat the question? It's fundamental. What's the word used after that?
So the point is, the COVID has challenged the way we tend to pursue research, and how can universities kind of ensure that the fundamental core aspects of research be preserved and ensure quality?
Yes, fundamental or core aspects. I have a slightly spiritual approach towards it, which is, I think the fundamental or the core aspect of research is primarily mental. It has to do with habits of mind. And after that, and only after that, anything else is irrelevant. In my particular case, I've tried to do this with the 120 odd students that were under my charge this semester, to whom I taught evidence, is by, first of all, telling them you have to calm your mind and you have to be in the right frame of mind to be able to do any research of worth any value. I think this is the way, and this is the guidance that I have received since I joined the bar. This is the guidance that I've received from the family, watching my father practice law and others. I think the fundamental way in which universities can do this is by helping students obtain states of mind that allow them some calmness, for which meditative practices may be used, but ultimately it's each his own. Meditation and prayer are two different concepts symbolizing the same thing. This is the approach that I take. I look at a statute and read it as if it was scripture. Just doing that gives me a peace of mind that I hope by suggestion others are able to obtain.
Okay, thanks, Kagesh, and thanks. I once again take the opportunity to thank all the panelists. Raj, over to you. We are not going to run into the 15-minute time that we have.
Thank you so much, Vishwas, and of course, thank you, Cheng Han and Susan and Bertil and Kagesh. What a fascinating panel, because so many issues that you touched in the course of this discussion is, as we speak, debated and discussed in faculty board meetings, as well as institutional policies. Regulatory bodies are also talking about it, to what extent legal research needs to be reimagined. So I am grateful to you for your time. It's an absolute pleasure to see all of you. I look forward to seeing all of you on our campus sooner than later. Be safe and take care. We will have a short 12 to 13-minute recess, and then we'll be back at 3:45 p.m. Indian Standard Time for the Constitution Day Forum. India is celebrating its Constitution Day today. On 26 November 1949, we adopted our Constitution. We have a plenary panel on the theme Women, Law, and the Legal Profession. Honorable Ms. Justice Geeta Mittal, Chief Justice of the Jammu and Kashmir High Court, is delivering a keynote address. We have the presidential address by Ms. Geeta Ramaseshan, Advocate of the Madras High Court, and another colleague of mine, Professor Juma Sen, will also be delivering a special address. So I look forward to seeing you back there. Thank you very much.
Thank you very much for the invitation. It's a pleasure.
about to start. And then we will become less disciplined.
Don't make me nervous, Raj.
All right. Good afternoon to all of you. My name is Raj Kumar. I'm the Vice Chancellor of OP Jindal Global University. Good evening to our friends in Far East and Australia. Good morning to people who are watching us in North America and Canada. We are in the second day of the Global Virtual Conference on reimagining and transforming the future of law schools and legal education. We are also celebrating today India's Constitution Day. On 26th November 1949, we adopted the Indian Constitution, and that day has been since celebrated as Law Day, and for the last few years as Constitution Day. We are also very fortunate that to mark this special occasion, we are organizing the Constitution Day Forum as a plenary panel on the theme Women, Law, and the Legal Profession. Early this morning, we had the Constitution Day lecture delivered by Honorable Dr. Justice D.Y. Chandrachud, Judge Supreme Court of India, and also shared reflections of Professor Upendra Baxi, another colleague of ours at Jindal Global Change. Social change has been a subject matter of a number of discussions, but to have a sharper focus on the role of women and law in the legal profession has been less studied and less examined. We are very delighted that we have with us Honorable Ms. Justice Geeta Mittal. We have Ms. Geeta Ramaseshan, Advocate of the Madras High Court, who will also be delivering the presidential address. I also want to thank and appreciate the presence of my colleague, Professor Juma Sen, Associate Professor at Jindal Global Law School, who will be delivering a special address drawing upon her own research. Now, the question of role and representation and indeed participation of women in the legal profession in India has been a subject matter of a number of discussions. Simply speaking, in terms of pure statistics itself, it's hugely embarrassing. Nearly 7% of judges in 25 high courts, we have, and in fact, the data shows even more that there are 6 high courts which do not have even a single, woman judge as well. And of course, we can discuss and debate about the data, but more importantly, the real question as we celebrate the Constitution Day is that to what extent we can shape the future of Indian democracy and indeed the Indian legal profession by recognizing the challenge of the deeply institutionalized discrimination that is prevalent in the legal profession. To what extent women contest these notions of the legal profession and how we as a society need to contest this notion of law and the legal profession itself. The distinguished speakers who we have with us today will be discussing some of these issues. I will be taking some of the questions shared from the audience who are watching. We are live on Facebook and YouTube. With those words, I am going to request Honorable Ms. Justice Geeta Mittal to begin this plenary panel with her keynote address. Justice Mittal, over to you.
Thank you very much, Raj. Greeting, which I think reaches out from South Africa all the way to North America, from South America all the way to extreme north of Asia and Europe. It would be Namaskar, Assalamu alaikum salam. Namaskar is a greeting which I think the world over is being adopted and followed given the current pandemic. I wish all of you good health, and I wish all of you greetings on this very special day, which is celebrated as Constitution Day in India. It is a matter of grave concern for me that conversations which I heard 30 years ago or 40 years ago when I joined the legal profession in 1981 are still relevant and seriously an issue even today. For this reason, the conversation in this session of this very important conference is extremely significant. I congratulate the Jindal Global Law School and the OP Jindal Global University for enabling this dialogue. Thank you, Professor Rajkumar and your entire team for giving me this opportunity to join you in this program. The glass ceiling is one of the most compelling metaphors for analyzing inequalities between men and women in the workplace. It applies to women as a group who are kept from advancing higher because of their gender. The glass ceiling implies the existence of an impermeable barrier that blocks the vertical mobility of women. Below this barrier, women are able to get promoted, Beyond this, they are not. Such a situation can be considered the limiting case of a more general phenomenon, that is, situations in which the disadvantaged women as a group face relative to men, which intensifies as they move up organizational hierarchies. This ubiquitous glass ceiling obstructs women across jurisdictions and subjects women to unequal treatment all over the world. In the context of the legal profession as well, history is replete with examples of regressive gendered perspectives. The eminent jurist Lord Coke in England about 350 years ago openly stated that, and I quote, women are generally unfitted for the duties of the legal profession. Female attorneys at law were unknown in England, and a proposition that a woman should enter the courts at Westminster Hall in that capacity or as a barrister would have created hardly less astonishment than that one that she should ascend the bench or be elected to a seat in the House of Commons. Unquote. This is from Henry Bradwell, 1850. It is reported at 1850, 55, 3, 5.35. Furthermore, in 1914, a three-judge bench of the Court of Appeals in Bob versus the Law Society, by relying on the positive prohibition of the common law of England, denied entry into the legal profession to women. Historically, in the Indian context, on the 29th of August 1960, a special bench, 1916, a special bench of the Calcutta High Court, Inri Regina Guha, refused the enrollment of Miss Regina Guha as a pleader. It was observed that the legislative intent of the Indian legislature while passing the Legal Practitioners Act of 1879 was, and I'm quoting the court here, which said that it would be repugnant to the idea of decorum to permit women to join in what I may call the rough and tumble of the forensic arena, unquote. It was only in 1921 that the Allahabad High Court ignored the above decision of the Calcutta High Court, and Cornelia Sorabji was admitted as a vakil on 24th August 1921. Finally, it was on the 28th of February 1923 that the Legal Practitioners Women Act was passed, removing all doubts about the eligibility of women to be enrolled as well as to practice as legal practitioners. Taking a statistical view, in 1999, only 10% of the total lawyers admitted to the bar were females. In recent times, India's top law firms are said to have only 30% women partners, a third of these firms having a gender ratio below 20%. In its over 5 decades of existence, the position of designation of women as senior advocates in the Supreme Court, which is called the silks in the UK, is also deplorable. In 1977, Justice Leela Seth was the first woman who was designated as a senior advocate by the Supreme Court. The next designation of a woman advocate as senior counsel happened only in the year 2007, when Justice Indu Malhotra became only the second woman to be so designated. The position regarding designation of women advocates as senior counsels in the high courts is not much different. Gender bias is reportedly widely prevalent in law firms and companies as well. A study conducted with 81 women working in law firms revealed that women were being allocated unchallenging work, being forced to remain content with lower professional fees than their male counterparts, and being denied benefits and promotions in corporate positions, jobs. Moreover, 74% of the women interviewed felt that their employers had made little effort in promoting or mentoring women within the organization. Clearly, women remain severely underrepresented in the legal profession. While the number of women graduating from law schools and working at junior levels is equal to their male counterparts, this does not translate to equal representation at the higher levels. More women are entering the legal profession every day, but their upward mobility seems to be hampered due to systemic discrimination. Though women's participation in the Indian judiciary has increased slowly in the recent decades, as at present, the position is abysmal. As Raj has pointed out of the 673 sitting judges of the high courts in India, only 73 are women. I happen to be the only woman Chief Justice out of the 25 high courts in India. In the 70 years since the Supreme Court was established, only 8 women have ever been appointed as judges. Currently, out of 30 judges at the Supreme Court, only 2 are women. Additionally, availing maternity leave benefits often has had negative impact on women's careers, both as lawyers as well as in the judiciary. This has included losing out on promotions despite deserving the same. Moreover, most corporate law firms are unwilling to invest in women and view maternity benefits as a drain on their resources. It is thus not uncommon for women to be inquired about their marital status and plans of having children at job interviews, questions which are never asked of men. I recollect an incident when I was in legal practice. A young lawyer was at an advanced stage of pregnancy and was advised against driving by her obstetrician. She was therefore compelled to send a colleague to seek a short adjournment in a family matter which she was conducting. The trial judge was reluctant in acceding to the request and had commented, "Doesn't she know that there is no maternity leave for a lawyer in the profession?" So far as the judiciary is concerned, I recollect an incident in which the annual confidential report of a woman judge was downgraded because she could not meet the required unit criteria regarding disposal of cases. Her only fault was that she had been compelled to be on medical as well as maternity leave, for which reason she did not have the number of days of work required to enable her to meet the required unit criteria. Instances abound where women working in firms are expected or asked to leave a little earlier than their male counterparts, especially if they take public transport. Working late and traveling alone at night is considered particularly unsafe for women. This reduces their time in office, which leads them to not getting assigned important briefs. Moreover, certain tasks, such as talking to a police officer, are sometimes reserved for men, since it is considered unsafe for women to go alone for such interviews. Women are also kept out of entire fields of practice, such as criminal law, due to stereotypes about the practice. It is not uncommon for a woman to hear that she should not practice criminal law since it may be dangerous or dirty. There is a notion that young women entering the field should stay away from criminal law since they would not be able to handle it and would be required to surround themselves with questionable people. Women are expected to pursue softer fields such as family and child custody laws, which fits their socially assigned roles as caregivers and peacemakers. Women face stereotyping not only from their male counterparts, but also from clients who question their competency. Clients tend to assume that a woman lawyer is too soft to manage an aggressive negotiation or a complex litigation. On the flip side of this, however, women are regarded as being too loud or dominant if they are bold in their approach. Any display of emotions is dismissed as hormonal and plays into the stereotype of women being irrational and overly sensitive. Similar stereotyping is prevalent in judicial assignments and appointments as well. At this juncture, I am reminded of what Judge Linda Ludgate in Pennsylvania, US, has on a plate in her chamber. It says, "Will the man who said it cannot be done get out of the way of the woman who is doing it?" Women lawyers face sexual harassment in varied ways, from colleagues, senior lawyers, judges, and even clients. Law students and interns are particularly vulnerable to such harassment. Sexual harassment laws usually address harassment at the workplace. However, for a lot of women lawyers, the workplace is the courts. Lawyers practicing in courts are not employees of the judges. This makes it extremely difficult for a woman to seek redressal about such behavior. Complaining of harassment also has huge repercussions on the woman's future career because of the power which is wielded by the respondent in the legal profession. Furthermore, I may recount 2 first-hand accounts of women struggling to fend for an opportunity to learn. This is not in too far recent past, and is in the recent past. I recollect the experiences of 2 of my law researchers, which have left an indelible mark on my mind as well as heart. I will not withhold her name, but use the appellation N for her, was a young girl whose late father was a director in a government position and the mother a lawyer in Patna. She was brought up in a conservative background. Her family expected that she would get married on completion of her schooling, which she was resisting, wanting to go for higher education and acquisition of a professional degree. Therefore, at the time of her class 12 school leaving board exams, she went to the examination hall and spent the entire duration of 3 hours without writing a single word on her answer sheets. She repeated this for 3 consecutive years, consequently failing the examination for 3 years. This made her family realize and understand her determination and permitted her to join a bachelor's program in Delhi. Thereafter, despite the family pressure and consequential financial restraints, she went on to pursue her LLB course in Delhi and is now enrolled with as a lawyer with the bar. Why I always feel a little concerned about N's progresses because these 3 years cost her the very valuable opportunity of trying for a judicial appointment as she became age barred for taking the requisite exam. R was another law researcher who came to me from an upper middle class, well-placed family from Delhi. Her mother was a director in a premier educational institution. Yet, before R could finish her 5-year law course, her parents had published a matrimonial advertisement inviting suitors for her marriage without even telling her of the same. As a result, this young girl faced extreme insecurity and apprehension as to whether she would be permitted to or be able to achieve her dream and aspiration of a career in law. Many years ago, in a conversation with several judges, including one member of the High Court Collegium, which had recommended 6 names for appointment as judges of the Delhi High Court, I had pointed out towards the absence of a single woman lawyer's name on the list. To this came the reaction from the judge on the collegium. He asked, "Don't you think there are enough women?" He asked, "How many of you are there on the bench?" I had answered, "We are 7. 7 out of the 35 then." To this came the reaction, "Don't you think there are enough women on the bench?" I couldn't resist asking the gentleman judge, "Don't you think there are enough men on the bench?" Professor Ved Kumari, a law professor at the Delhi University, who had been appointed as a chairperson of the Delhi Judicial Academy, had following very interesting observations to make after her experience in the judicial trainings. She had observed that merely increasing the number of women judges at the lower level did not necessarily lead to an increase in the appointment of women judges in the higher judiciary, and that there has to be a definite policy towards the same. She has also observed that there is extreme reluctance between both male and female judges to gender sensitization programs at every level. From the word go, the reaction is that there has been oversensitization. Ved also observed how almost all women judges were wanting out of the outstation weekend trip, which was organized for institutional bonding for the trainee judges. These women judges espoused family commitments as being the difficulty. It was clearly evident that families felt that such a trip was not an essential part of the work of the judge, and husbands were unwilling to take on any additional responsibility to facilitate the judge in going for the outing. The women judges had no option and were not permitted to negotiate with their families. The male judges, however, had no such problems. Thereafter, the Delhi High Court stated that no exemptions could be permitted from the trip. As a result, the outing was made compulsory for all participants of the training program. An interesting response of a woman judge was to the following effect. One judge reacted, "Hey, this is great. I can always say that there is no exemption from any such program in the future." Another woman judge went on the more normative route, stating, and I quote, "I'm very unhappy that the High Court has permitted no exemptions. I have been able to cook for only 1 day, so my husband and 2 children will be happy. But who will do it for the second day or thereafter? It will be very difficult for them." These conversations highlight a very significant aspect of the working of women judges, and that is that they're either performing judicial duties or discharging familial responsibilities. As part of this, every minute of their extra time is utilized in socializations involving only the extended family. On the other hand, male judges are involved in institutional bonding exercises and socializations and are thus present at all functions. Women never think of institutional socialization as an option in their optional time. Preconceptions surrounding women's roles and abilities, biases in recruitment and nomination processes, and lack of access to informal networks of communications are all part and forms of discrimination being faced by women across multifarious contexts. Different standards of performance evaluation and little or no access to critical developmental assignments, such as memberships on highly visible task forces and committees or important roster allocations, is further reflective of the impunity with which such behavior is being meted out to women, both in the legal profession as well as in judicial appointments. Women are expected to shoulder the burden of childcare and domestic duties single-handedly. This is also seen as a liability by recruiters. Inflexible hours and often hostile work environments make it more difficult for women to manage a work-life balance. Furthermore, organizations seldom promote family-friendly workplace policies or provide supportive infrastructure. Gender-based discrimination is a lived reality for many women. It is no different in the legal profession. In India, women face caste as well as gender-based discrimination, both at home as well as the workplace. The lack of vigorous law enforcement allows for such counterproductive behavior and harassment by colleagues. The reporting and dissemination of information relevant to glass ceiling issues is completely inadequate, if at all. Weaknesses in the collection of employment-related data makes it difficult to ascertain the status of groups at the managerial level and to disaggregate the data. Justice Mary Jean Kuhn, Chief Justice of the Minnesota Supreme Court, once stated, and I quote, "A wise old man and a wise old woman reached the very same conclusion," unquote. Christabel Pankhurst has also said, I quote, "Ability is sexless," unquote. It would thus be useful to analyze why such disparities exist for women, despite having merit, ability, qualifications, as well as experiences equal to, if not more than that of men. Chief Justice Beverly McLachlan of the Supreme Court of Canada has drawn a caution that the arguments towards appointment of women judges is not to suggest that only women can make decisions that take into account women's perspectives. The Chief Justice, however, does say that it cannot be denied that women do provide a useful perspective on legal issues that arise before the courts. The same can be said for women lawyers and senior advocates. The importance of gender diversity cannot be overstated. It is particularly significant in the legal profession, where the presence of women plays a symbolic role in upholding the ideal of equality, helps maintain confidence in the legitimacy, fairness, and impartiality of the justice system, especially amongst the disadvantaged groups. Diversity on the bench and in the bar reflects a more inclusive representation of society and leads to a wider range of considerations in reaching arguments. It brings varied perspectives, values, experiences, and sensitivities to the advocacy and the judiciary, which would prove instrumental in generating creative and just solutions, further propelling change towards what the law requires. Women professionals thus have to anticipate familial demands while juggling with professional commitments, creating enabling environments by way of fairly recognizing the ability and worth of women professionals, having uniform standards for evaluation of merit, permitting flexible timings, ensuring creches and childcare rooms for lactating mothers should be an integral part of every workspace, be it a lawyer's chamber a law firm's offices, or the court complexes. Only then would discrimination stand removed and equality, gender equality achieved. Towards this end, I have mandated childcare spaces and creches in court, which stand inaugurated in the various union territories of Jammu and Kashmir, amongst others in Srinagar, Gandarbal, Budgam, Samba, and a few others. In the words of Michelle Obama, and I quote, "No country can truly flourish if it stifles the potential of its women and deprives itself on the contribution of half its citizens," unquote. It is truly extremely troublesome for me that we are now in 2020, at the end of 2020, are still talking of discrimination, glass ceilings, and deprivation so far as women professionals are concerned. With this thought in mind, as has been said by Michelle Obama, let us envision and strive towards a fairer tomorrow, a tomorrow where equality is the norm and diversity and inclusion its close companions. Thank you very much.
Thank you very much, ma'am, for a compelling tour de force on the journey, but most importantly, some of the very critical issues that are confronting the state of judiciary, the legal profession, including the role of women in law. We will come back to some of those issues very shortly. Now I have great pleasure in inviting Ms. Geeta Ramaseshan, Advocate, Madras High Court, to deliver the presidential address.
Thank you. Honorable West Justice Geeta Mittal, Chief Justice of Jammu and Kashmir, Dr. Rajkumar, Dr. Juma Sen, I deem it a great privilege to be giving you the presidential address on women law and the legal profession. Given the fact that women today constitute half the numbers in law institutions, and we take maybe many things for granted, it is necessary that we take a peek into the not so distant past about our entry into the field. I know that Dr. Juma Sen has done excellent work on the first women lawyers of India, and Justice Geeta Mittal has made a reference to it, but I would still need to go a little bit into those areas to give a historicity into where we are today. It was just about 100 years ago or so that Regina Guha of Calcutta wanted to practice. It was not permitted, and a spirited battle wherein the term person in the Legal Practitioners Act was argued to include women was not accepted. A 4-member bench of the Calcutta High Court held that she was not entitled to enroll as a pleader. In 1921, you had Sudanshana Wala Hazra of the Patna High Court, who again challenged the issue pertaining to the General Clauses Act. And here is what the court held. And I just wanted to, of course, the court did not permit her to do so and said that the act should be amended. But I wanted to quote to you what the bench held. An appeal has also been made to us on the ground of intelligence and capacity of women to be fit compeers of men in the forensic area, and that the rapid advancement of the country in the matter of education amongst females require that these rights in all spheres, including the profession of pleader, should be recognized as being equal with men. This is quite true, is the observation of the court. But having held that, they went ahead saying that they recommended the changing the law, even though by that time, Cornelia Sorabji was already enrolled as a vakil in Allahabad. The references that the court made in these cases was to Abibs versus Law Society, the UK judgment, and Bradwell versus Illinois, both of which were cases that challenged the entry of women into the legal profession. All the 3 Indian women were highly qualified, yet had to face extraordinary hurdles when it came to wanting to practice in the legal profession. Cornelia, as is known, could only represent Vardhanasheen and minors under the Guardian and Wards Act. She could not argue. Of course, the Legal Practitioners Act was amended. Women made a mark and continue to make a mark. So how do we understand equality today? And I just want to go not just into us as practitioners of law, but also understand equality, the way it is structured in some of the legislations and in the way in which most people understand. Equality today is understood either through the lens of a formal model or through the protectionist model. Now, the Women's Convention, the CEDAW, addresses equality of what needs to be extremely relevant from the substantive point of view. But if you look at our laws, you will find that either they are in the formal model or in the protectionist model. And I'll just give you two examples. Let's take the Hindu Marriage Act and let's look at interim maintenance and permanent maintenance. This is the only statute that actually came in 1955 that address or that require both the male and the female could be made liable to pay maintenance to their spouse. Such a provision does not exist in the Special Marriage Act. It does not exist in the other laws at all. Question is, of course, you may say, why not? Today women are equal. Why should a woman not be asked to pay maintenance to her spouse? And that is coming from an understanding of a formal model of equality, because this provision in many instances has been used to harass women and not taking note of the fact that a woman's contribution is not just the salary, which she may earn more than that of her husband, but also the contribution that she does to the home. This is only a small example that I'm giving you. But let me also give you another example of the protectionist model. The common understanding, let's say, in criminal law of what we understand as protective custody. Courts routinely direct women to a shelter home on the ground that in a case, like let's take, for example, a sexual assault, instances of women who is the survivor victim being sent to the shelter home are very common, that the perpetrators of the offense invariably come out on the basis of bail. Now, it is not to say that in a given case, a woman may require a shelter. That the entire understanding of the notion of protective custody comes from the fact that women need protection. Therefore, in a given situation, they could require custody, irrespective of the fact whether she was economically within her parameters independent, contributing to a livelihood, taking care of her children, etc. The entire study of protective custody would give us these instances. The third kind of equality, which is the substantive model of equality, which we find, in my view, under Article 15, which say that the state can make special laws in favor of women and children. In the structure of a substantive model, is not easily understood, and it was only recently in the Sabarimala judgment where Justice Chandrachud has made a detailed observation on the issue of substantive equality. So, where do we as women lawyers stand or find ourselves? In the examples that Justice Geeta Mittal gave us, in various examples that I want to share with you, we are viewed only through the prism of the formal model, where, you're equal, you want to be in this profession, you have to deal with it like a man. So don't expect maternity leave. You have to work from morning to not expect any other facility, is the common understanding of our colleagues, of judges, of various people in the judicial process. So let's take this. Therefore, for example, you do not have creches in many of the places. You don't even have restrooms in many of the trial courts. Justice Mittal spoke about creches. It required a court order from her to see that these were put in motion in the various courts in J&K. It required a lot of, in the Madras High Court, it required a lot of not protests but demands from women lawyers for a creche to be put in the campus. So the next, of course, comes not just this, but into the realm of protectionist approach. Yes, women are not allowed to practice criminal law. They are not encouraged to practice criminal law because, examples again which Justice Geeta Mittal gave us. When I joined the bar, there were many seniors who would not take any woman as a junior. They simply felt that some seniors argued that they did not want to keep, they couldn't have women working late nights, while some seniors felt that having women in their offices could cause some kind of a problem. Now, of course, things have changed a lot. Senior lawyers, most lawyers want a woman junior. That the examples that I gave you was not so much in the distant past. How do we develop clientele? That's a much greater challenge. Most of the time, if it is word of mouth, getting a vase is difficult for a woman. And here I'm not talking about women lawyers in cities or in fairly urban areas. If you look at smaller towns, it's very hard for women to make a mark. It's very hard for women to find an office. It's very hard for women to develop clientele, and it is very hard for women to be taken seriously. You can find extreme aggression from the men in trial courts, in the form of, especially in terms of litigation, when a woman represents a client in a magistrate court. And this aggression, to my mind, has translated itself into more aggression. Well, while I think 30 years ago, it was more paternalistic in terms of, okay, you're a young woman, maybe you should not do these things. Maybe you can do only family law. Maybe you can do only civil law. But there was some kind of an encouragement. Today, there can be a strong aggression if young, smart women make their presentations in the courts. So the implicit gender bias swings from a formal to a protectionist model when it comes to women practicing in a court of law. A greater challenge, of course, is to balance with the private and the professional life. Support systems are required, of course, at home. And if that support system is not available, it's very hard in the legal profession for women to make a mark. However, one of the advantage I would say is that for women, this is an easier profession to come back. I mean, you take a break if you have a family, you can also come back easily into the profession. I look at the profession pyramidal, like a pyramid. The top are the very big, hotshot senior lawyers. And the bottom, of course, are, even within the men, a lot of lawyers who struggle. So for women to actually reach midway, I would say, it is interesting, it is frustrating. But it has its own merits if you stay on and push yourself through in more ways than one. you do need, of course, a great support system. Find out lawyers who are encouraging to take you on board, of which there are plenty now, because offices are also requiring competent, good lawyers. And now there is also a tendency to think that women lawyers are much more competent. And therefore, on this push, if you start, I am sure most of you who are here, who want to go ahead in the profession in more ways than one, in litigation, would definitely make a very strong mark. I also want to say that today the profession or the degree of law offers you far greater opportunities than what it did in our days, where, we only had litigation as an option, or maybe teaching. It was nothing else was an option. But today the options are very high, and the sky, therefore, will be your limit. The glass ceiling in this profession is very complex. How do you rate a glass ceiling? Are you rating it on the basis of income, or are you rating it on the basis of a, fairly very successful lawyer in a particular field, in a particular town, who may not be charging that many fees as the men, but would be very successful? So understanding the glass ceiling also in this profession is complex. Yes, I agree that women probably charge less than that of men, but I think that is something which would be, it's only a temporary phenomena. It would actually go ahead as you come through. In my own experience, I want to end with that, is a large part of my criminal law practice was because of the legal aid movement in Tamil Nadu. We had a very strong legal aid movement, which was, and the secretary and others were very encouraging of us women lawyers. They would push our boundaries to go to the police station, file criminal cases, file public interest litigations, etc., which maybe would not have come in my way or in the way of many other women who were practicing at that time. And I think that I just wanted to end with my own experience on that score, except to say that the sky would be the limit, I would say, and not look at it as a glass ceiling. Thank you.
Thank you, Ms. Ramaseshan, for that lot of personal reflection, but also resonating with a lot of hope and aspiration for the young people who are aspiring to be part of the legal profession. I'm going to quickly ask Professor Juma Sen, my colleague, to give her reflections and also talk about the study. We want to take some questions as well. So, Juma, if you can do a 8-minute to 10-minute presentation, that would be nice.
Okay. Thanks, Raj. Thank you, distinguished panel. And it is always a little intimidating to speak in the presence of such distinguished speakers. So I have two cards, as a speaker here, as someone who has practiced in the courts and as someone who has been privileged to be exposed to a lot of archival materials of late while trying to research and recreate the lives of some of these early women lawyers in the legal profession as part of my book on the same subject. So I will speak a bit about the making of the professional legal women subject in the late 19th and the early part of the 20th century through some of the pioneer portias. Legal historians generally, legal historians of early women lawyers are usually unanimous in their opinion that naming these pioneers is just the start. The source problem proves to be a gigantic obstruction when one tries to reconstruct what it was like to be one of these pioneers. Personal records are rarely kept, and it becomes extremely difficult to fill in the context of their lives. And in addition to that, there is another challenge that of capturing the complexity of the lives of these women who were lone voyagers and often the only women to challenge male exclusivity by attempting to enter the legal professions. And they often, created their life because there was no models of the lives they wanted to live. Making the sort of the primary task of their biographers to reinvent the lives their subjects led somewhat difficult. But I think the first thing I would really sort of, that's something that I've been thinking is that what was so unique about the late 19th and the early 20th centuries that women started knocking on the doors of the legal profession across jurisdictions in these decades. And 19th century is admittedly the age of emergence of modern professions owing to a number of factors, and law was no exception either. History, in fact, shows that the idea of law as a distinct profession was being consolidated during this age, leading to the the reconfigurations of interesting questions like who could practice law and how does one regulate the legal profession, along with the setting up of bar associations and as well, law schools in different parts of the world. 19th and early 20th century was also the period marked by women's movement for equal rights across the globe, leading to a number of significant law reforms in the legal status of women, especially with respect to property and family. And there was, in addition to that, there was the complex, very complex rather, transnational feminist solidarity was forged between British women lawyers and Indian women who were imperial subjects, while women across several jurisdictions attempted to enter the legal profession. The freedom struggle had legitimized women's involvement outside the home and family, and it provided a fertile ground for women to access legal profession. In addition to that, this period also witnessed a proliferation of women litigants before the courts, owing to a number of factors, including a reform in women's legal status, which brought more and more women in contact with law. So the figure of the woman in Parda, it kind of emerges as a category bearing rights, whose needs could be served better by women lawyers. So these therefore became the conditions of emergence of women lawyers in this very traditionally masculinist profession during this period. The most well-known of these women was indeed Cornelia Sorabji, was the first woman to study law in Oxford, the first woman lawyer in British India, one of the earliest women barristers, and possibly the first woman to practice in the Allahabad and the Calcutta High Courts. She is, rightfully described as a pioneer, and she claimed her place as one of the, as an individual bearing several identities, that of an Indian subject of the empire and that of a professional citizen, and above all that of a woman. And she negotiated her way into the legal profession by arguing that Indian women litigants needed Indian women lawyers who were uniquely placed to offer professional guidance and comfort. Sorabji navigated her feminism, although she never called herself a feminist, with her claim to the nation and empire in a very complex language of professional citizenship, which was unique and baffling at the same time. Her initial years as a sort of like a roving practitioner of law, and subsequently as a lawyer for women in Parda, have been subject of some critical study in recent years for legal historians who are interrogating the legal profession. The other two remarkable women were Regina Guha and Sudhanshu Bala Hazras, and I have done some work on both their lives, and their names have been lost in history. Both these women formally challenged the Legal Practitioners Act, which deemed women were not persons within the meaning of the legal profession. Regina Guha's case was the first person's case in India, like it was pointed by the previous speakers. The court records, if you actually look at the court records, they indicate that after obtaining a Bachelor's of Law degree from Calcutta University, this was 1916, she submitted an application for admission to be enrolled as a pleader in the Alipur District Court, which was subsequently forwarded by the Calcutta High Court because they did not know how to deal with the question of a woman, trying to get admitted, to the role. And since this was the first instance of an application by a lady for enrollment of as a pleader, her application was heard by a special bench of the of the judicial of the Calcutta High Court for the determination of the question of whether the Legal Practitioners Act contemplated women practitioners. And a bench of 5 judges heard her application. They unanimously came to the conclusion that men are entitled to be admitted as pleaders. She was turned away from the doors of the legal profession. She embraced her life as a headmistress of the Jewish girls' school. She did not live long, actually, at least not long enough to see the passage of the law amending the status quo, and she passed away 3 years after, in 1919 she passed away. So 3 years after Calcutta High Court judgment was delivered. There were others like Mithan Tata, for example, who was not only the first Indian woman to become a barrister, but was also someone who actively participated in the debates surrounding votes for women in England, along with her mother, Hirabai. These were like widely covered by the British media at that point of time. Their efforts were instrumental in providing suffrage to Indian women. The Sex Disqualification Removal Act was finally passed in 1919, which was very, very instrumental in pushing for a formal campaign in India to amend the Legal Practitioners Act of 1879 and allow women entry into the legal profession. Mithan Tata was also the founder of Indian Federation of Women Lawyers and served as the vice president of the International Federation of Women Lawyers. In her formative years, she was an Indian suffragist. Later, as a student of Oxford University, and was the first lawyer to practice in the Bombay High Court. She was also very active she was actively involved in the All India Women's Conference, serving as its president, and played very important roles in the amendment of the Parsi Marriage Act and the drafting of the Hindu Code bills. We don't know these stories because we don't think of these women when we think of the idea of this, sort of a pioneer lawyer. Sudhanshu Bala, had initiated the second person's case in India, which would subsequently generate a campaign to amend the law surrounding the regulation of the legal profession. She was born to Bengali Christian parents, and after their untimely death, she as well her elder sister, Shaila Bala, both of them were adopted by a friend of their father, who was the architect of modern Orissa, Madhusudan Das, who was a lawyer himself and had a successful practice. She recounts in her memoir that how she intended to follow the footsteps of Madhu Das, and she studied law and faced the first barrier when she wanted to write her preliminary law exam and was denied. And then there was a second barrier when, after qualifying, she was not allowed to enroll as a pleader in the Patna District Court. The Patna District Court, incidentally, not the District Court, the High Court, incidentally, they also followed the Regina Guha's case, and they ruled that Sudhanshu Bala was not a person within the meaning of the Legal Practitioners Act and hence not allowed to enter the legal profession. And in what can be described as a riveting tale of resistance, Sudhanshu Bala, along with her sister Shaila Bala, who I already said was a very prominent figure in the women's movement in the early 20th century, and the adoptive father Madhusudan Das, they launched a campaign for the amendment of the Legal Practitioners Act from moving. They also they wanted to move to the Privy Council. They wrote to the members of the Central Legislative Assembly, and the law was finally amended in 1923 with the Legal Practitioners Women's Act, clarifying that women were persons within the meaning of the law and that they could practice. There were other pioneers like Shamkumari Khan, who was born Shamkumari Nehru, who had a very, very prominent practice, who was one of the lawyers who defended Yashpal, a political prisoner in the Meerut conspiracy case. There was Durgabai Deshmukh, there was Anna Chandi, there were so many others. Now, while these women were negotiating their professional space, including the terms on which they were required to conduct themselves, the legal profession too was adjusting itself to these negotiations and changes. And you actually see like how these changes were taking place, because from sartorial negotiations of women lawyers, attire and robes, to toil is the question of toilets for women in the courthouse, which one of the earlier speakers already mentioned. Because these all traditionally always catered to men, to having very limited access to the bar library. These women were navigating inhospitable spaces which were still guarded by the hostile gentlemen's club. I just want to conclude, I can go on and on about all these lives of all these women, but I know that I have been asked to wrap up 8 minutes. I just want to conclude that by saying that 2023 marks the 100 years since the passage of the Legal Practitioners Act, Women's Act 1923. And it is perhaps a good time to reflect on these and curate the lives, lives including the public, private, as well as professional lives of these women in the legal profession. It may demonstrate the complex and multiple negotiations these early women lawyers did, and also explore the individual circumstances of these women and the historical context in which these women presented their claims and lived their lives. On a more personal and institutional note, I would actually this is probably directed at Raj directly, that at JGLS we have more than 50% women as law professors, and 50% more than 50% women who are in leadership positions, and we should perhaps think about taking a lead in setting up 100 years of Women in Legal Profession project in a very disciplined manner. Similar projects have been sort of instituted in other institutions. There's one in Australia, there's one in UK. We should have one here as well. On that note, I will conclude. I think I'm in time, 8 minutes on my watch.
Juma has, thank you so much, Juma. Juma has strategically provided a public pitch on that project. So very exciting. Thank you very much, Juma, for that. So listen, we have a few minutes, and so we need to quickly get into these questions. So ma'am, let me start with this. There are several questions. A lot of people are asking lots of questions. So I know Justice Geeta Mittal is the Chief Justice of the J&K High Court. So I'm conscious of the fact that she may or may not like to answer some of these questions. So ma'am, one major question, and I'm going to paraphrase that question, is this is regarding, women's appointment as appointment of women as judges. If you look at the reservation policy when it comes to OBCs and SC/STs historically, till such time, the efforts to diversify was pursued through a percentage-based reservation. There was not much change that was happening. Attempts were made to pursue diversification of all kinds, but till such time, actual percentage was put in place and state and central legislation was put in place, we didn't see much change. Do you think ultimately for us to achieve the kind of gender diversity that we want in our judicial institutions, the only hope is to put in a percentage-based reservation?
No.
You have the right not to answer the question as well.
No, of course not. I have very strong views on merit. I only said there should be a fair evaluation. We have to have clearly laid down parameters on which you will evaluate, you will assess. There don't seem to be any parameters. What
about judicial services examination, ma'am? Reservation for women there?
Yeah, that's what I was going to say. Where of an examination, we have almost an equal 50% children who are joining the subordinate judiciary. I don't like to use the word subordinate. The judiciary at the entry point are women. It's only when you get the option of using discretion is where the disparity is coming in. Our civil judges, our sub-judges, our magistrates, you have an almost 50% ratio. And this is not only, I saw that in Delhi, I've seen that in Jammu and Kashmir, and I have no reason to think that it's not the same in the rest of the country. So it's only where the discretion come, women are not being put in positions where they would be part of the choice-making group. So, there more and more women are being left out. I've heard Chief Justice Brenda Hale say this all the time. I've heard there were several other, Chief Justice Georgina Wood from Ghana, Beverly McLachlan from Canada. They all said, their advice to women always used to be women in senior positions, that make sure you fill your place with a woman because it will never get filled by a woman. So it's where the choice is happening, that discretion that these kind of disparities are coming in.
Well, thank you very much, ma'am. There's another question which I'm going to ask Ms. Geeta Ramaseshan. This question is about while there has been an increase in the number of women entering the legal profession, how do you suggest one addresses the gender bias that operates in more matters like allocation of responsibilities, even giving of cases within a chamber to women, or in corporate legal settings? To what extent even office spaces, the sort of more slightly less significant but equally important aspects in which the role of women ends up being devalued?
If I were to take, say, Madras city, I think
as I already told you, now there is a situation has come where they want women lawyers. Yeah. But if you were to take really other towns where, women don't have much of encouragement, the challenge is much greater, where, you are then not encouraged to make a representation, but just to take an adjournment. Not encouraged to, just take an adjournment, give that much representation and come out. I think I think one way would be for young women lawyers to get together and start a firm. So that I know it's wishful thinking maybe, but it can be an area where then they can get together and see how issues can be taken by them. But within an office, it is still very difficult. See, Justice Mittal gave us the example of sexual harassment at the workplace. Yeah, it's a huge issue now. All courts are very uncomfortable with it. We don't have a proper structure. So understanding, going and negotiating for yourself in a office is still a very hierarchical profession. Yeah. If you're working in an office, and what we call people senior, right? There is a senior, then the senior calls the shots. So these are great challenges that pose us. I know I've not exactly answered your question the way, it's still, but that is how the challenge comes.
Thank you very much, ma'am. Juma, since obviously the conference, there's another question about, when we are in the law school, if you look at law schools, for example, including ours, there are more than 50% women who are law students. And so in some ways, what ought to be the responsibility of universities when it comes to actively providing leadership in shaping the future of a stronger role for women in law and the legal profession? How do we shape the agenda for the future?
I think, on an institutional level, what one can possibly do, and one way of doing it is encourage women, because, leadership role is not just confined to faculty, in the institution. Leadership role is also confined to students. And if you make good student leaders in a law school, they are the ones who are going to step out, carry that experience with them, and they are the ones who are going to be the future leaders. And that aside, I think there is also this, there is a need to sort of diversify. Because, I think Justice Mittal had, earlier spoken about this, that, there is this tendency, there is this notion that women are only fit for a certain, women lawyers in the legal profession, they're only fit for a certain kind of practice and not for, let's say, criminal law or tax law. You do not automatically think of a woman lawyer. So maybe that is another sort of, that is another space where a law school can intervene by giving that space to students.
Gotcha. Thank you very much, Juma. Ma'am, you will have the last word on this, Justice Geeta Mittal. Justice Ruth Bader Ginsburg famously said the following, and I whenever I read this, I'm like, what a poignant thought process. As much as it's as simple as that. So this is something which he said, and I quote: "When I am sometimes asked, when will there be enough women on the Supreme Court? And I say, quote, when there are 9. People are shocked. But there would be 9 men, and nobody has ever raised a question about that, unquote." So my question to you is that, what's the future? How can we expect a change in the mindset and also change in the reality?
I'm sure, Raj, you're churning out young boys, young men who think that their women colleagues and women students and women friends are just as good at them. when we can create that kind of a level and that kind of a mindset, and when you're not, you're not looking at differences, but the similarities is when we will achieve that. I always remember Justice Rumapal, she tells us about an incident in a lighter vein when in an argument in court, in a case involving washing machines, her male counterpart turned to the lawyers and said, my learned sister will be knowing all about this. I don't. So, I'm sure you heard this anecdote when she reacted and said, "Where's the presumption? How do you know? What do I know about washing machines?" So and it's a very very emphatic statement, which says a lot, without any explanation being there. But the kind of discrimination where women lawyers are expected to do particular kind of cases is it's the same on the bench. You're assigned rosters which will not involve, now things are changing slowly and slowly, but it's not also 100% change, and it's not across the board. But there are judges who are willing to give difficult intellectual property matters, commercial disputes, company law matters to women judges. I have been fortunate, I've had a mix of both. But roster allocations also is done very discriminatorily a lot of times. And responsibilities. You'll be given protocol branch, housekeeping, laundry, the, I don't know, what do they call it? Livery branch, to look after. While as the male judges will get to do the computer, IT branch, these kind of assignments are given to the male judges. So, till we create a body of men who think that women are no different from them and are able to overlook what are the real, are able to look at equality as a real time reality, is when you will have equality on the bench as well.
Well, thank you very much. It's been an absolutely fantastic session. I'm grateful to Ms. Justice Geeta Mittal, Ms. Geeta Ramaseshan, and of course my colleague, Professor Juma Sen, for participating in this Constitution Day Forum. I also deeply appreciate each one of your leadership in the work that we do, and also to inspire many colleagues of yours, many mentees, and of course others in shaping the future of the discourse relating to women, law, and the legal profession. This session is ended. We will be very quickly, in the next few minutes, starting the 16th thematic session of the conference, Relevance of Interdisciplinary Legal Studies During the Pandemic. And I want to once again thank all of you for your presence. Thank you. Everybody is here.
Yes.
Good evening to all of you from India. Good morning to people in the United States, and late evening for people in other parts of the world as well. We are on the second day of this global virtual conference on reimagining and transforming the future of law schools and legal education. We are on the 16th thematic session on the theme relevance of interdisciplinary legal studies during the pandemic. We have a very distinguished group of individuals who have dedicated their life and indeed making significant contributions to the pursuit of interdisciplinary legal studies. I would like to briefly introduce them. We have Professor Dr. Soledad Atienza, Dean of the Law School at IE University in Spain. We have Professor Carolyn Coles, Senior Lecturer and International Convener, Aston Law School in United Kingdom. We have Professor Tom Brooks, Dean of the Durham Law School, Durham University in the United Kingdom. We have Professor Dipanshu Mohan, my own colleague, Associate Professor at the Jindal School of Liberal Arts and Humanities, Professor Dr. B.B. Pandey, Research Professor of Law at Jindal Global Law School at Jindal Global University, and of course, my very distinguished colleague, Professor Dr. Geetanjali Surendran, who teaches at the Jindal Global Law School, a historian who will be moderating this session. Thank you very much, and I'm going to hand this over to Geetanjali.
Wonderful, Raj.
Thank you, Raj. I was about to say good evening, but it's true that everybody's in a slightly different time zone. So let me, rephrase that to a very warm welcome to all of you for this panel on the relevance of interdisciplinary legal studies during the pandemic and after as well. I'm going to sort of jump straight into a very brief introduction to the panel itself, and then we'll get on to the business of hearing these very distinguished panelists. So once again, a very warm welcome to all of you, and thank you so much for joining us today. So there's no doubt that, of course, this whole period of the pandemic has thrown a lot of our certitudes, our certainties sort of out the window. And we are facing unprecedented challenges when it comes to various institutions, to the pressures on our social, economic, and political structures, etc. What is clear, though, is that if we're to solve any of these things, then we do need sort of massive efforts on the parts of researchers, public policy experts, government, non-government, people from a wide sort of variety of fields. For instance, just when we're thinking about the vaccine itself, that's dependent on the free sharing of clinical surveillance geospatial data. You again need people from the fields of biomedical sciences and intellectual property rights regimes, people who are aware of these things to come together and start thinking about how to move forward, how to do some of this data sharing, etc. And of course, then after that, after the vaccine's actually created, there's a sort of business of patents, and then there's the business of distributing it and figuring out how it's to reach the people it's to reach, costing, etc. So I think in a sense, what's going to come when that vaccine is finally out, or when those vaccines are finally out, is something that we've never really witnessed in history, and it's going to require enormous amounts of collaboration across the board. But this is the only wicked problem we're facing right now, right? We have the issues of environmental degradation. I'm sitting in Delhi. I know a lot of people in the audience may be sitting in Delhi as well. And we're facing the sort of twin problems of the pandemic and pollution, both of which are sort of exacerbating each other in a way. And there's no way that any of these issues around climate change and environmental degradation would remotely be solved without this kind of interdisciplinarity, or anyway these teams of people coming together. And how is that going to happen? And in a way, the discussion that we're going to have today around these kinds of promoting interdisciplinarity, multidisciplinarity in the arena of legal studies, but also further afield in academia in general, would certainly be an important step. We've been talking about it, I think, for decades. The question now is, how do we make it happen? How are we thinking about this in the context of the problems that we face today? I'm going to ask each of the speakers to kind of respond to the different questions that we have for them. And then at the end, there will be some audience questions as well. I'm going to actually ask you all to try and limit your remarks to 3 or 4 minutes, because there are a number of questions and there are a number of you, and we want to be able to hear all of you. And I'm going to apologize in advance if I have to interrupt you at some point. So, many apologies. I'm going to put up this badly mirrored, note at some point to say you have 1 minute left. I think you get the idea. So please do keep an eye on me. I'll do a little bit of timing. We have to end 5 minutes early. But I'm hoping that we can get as many questions and as many responses from all of you. So just to throw out that first question. So what do you feel are some of these challenges? Of course, the pandemic being the most obvious one, but of course there are many others. What are the kinds of problems you think would benefit from an interdisciplinary legal studies kind of approach? Can I ask, shall we just start with a certain kind of order? Can I ask Professor Coles to begin? And then we can move on to Professor Brooks, Dipanshu, Professor Atienza, and then Professor Pandey.
Yeah, sure. Thank you. Well, I think some of the challenges are also actually our strengths of interdisciplinary research, because some of the challenges are the different philosophies that are coming from the different research areas. My own area is intellectual property law. So when you think of the example that you've just mentioned there of patents, of course we need the pure scientists who are doing this wonderful work at the moment with their highly specialist knowledge. But then also we do have the views of the commercial people, which is maybe different issues in with COVID, and is having an impact. But it's always there, this balance of if we didn't have the funding and the money, if these things weren't commercially viable, how long-term can this pure science and this expertise develop? So it is a balance. And then the third element is, of course, the ethics of all that. The ethics of what do we develop, how do we develop it, and how do we apportion the money? So in that way, I think the challenges of those 3 areas, from what I see in my area of intellectual property, are also our strengths, because then as a lawyer, but also a past brand manager in my diverse career, seeing the views of different people help us solve the problems. These are global problems across so many different disciplines: technical, ethical, financial, and therefore we need the researchers to come together. So these challenges are also our strengths driving interdisciplinary research. I'll pause there.
Thank you. Can I ask Professor Brooks actually to also respond? Actually, Professor Brooks is in a sort of uniquely interesting position here, because you're also a professor of law and governance, but you've also worked on philosophy and public policy and a whole bunch of other things. So please go ahead.
Indeed. Well, listen, thank you very much. I'm delighted to be part of this. So in terms of kind of general interdisciplinarity, I think that's hugely important. Law is, of course, laws of different things, laws about how constitutions work, laws about intellectual property, laws of other things. And so I think that law is a kind of not uniquely interdisciplinary type of project. I think many are in a similar type of situation, but it's a thorough going type of interdisciplinary project that combines all the different areas that Caroline so rightly identified. I agree with everything that she said about this. I think when I think about COVID and what it's changed or what might be different or how it affects things, of course there's the issues that were raised. I won't repeat them, but there's then something else that I think is also worth noting in my 3 minutes or less. Putting my hat on as the dean of a law school, is that my law school, like yours, is very international. We have a lot of international staff. We have a lot of international students. And often the way we've taught folks have focused almost exclusively about qualifying people to do stuff right here. Now that's troubled me as someone who's an immigrant, who's not from Britain. How can our international students be a strength beyond the fact of various fee things or people in the room kind of stuff, something kind of more substantive, something more that makes them better lawyers. And I think one thing that's been interesting about the COVID situation is it's really kind of brought to the fore not only the, I don't want to call it reliance, but the deep integration of international people as staff, as students, as users in our communities of our universities. A very big thing. I had a lot of staff who wanted to get home. I have some whose families are abroad. I had students who wanted to travel to different places. But then thinking about these challenges, thinking about these problems, of course, is international. And so part of the interdisciplinarity we might think is thinking about the law of England and how it could be helped by philosophy, political science, other things. I think that's true. We can say more about that, or the laws relating in India and other things. Yeah, sure, maybe that's true too. But that we do not act, our legal systems do not act independently of others. And I'm not thinking even of international law. I'm thinking about our students coming to grips with the different legal systems, that it matters what the law is in the commercial law, matters in the United States and in China and in India and elsewhere. It's not just kind of international level of some kind of, don't call it same playing field, it's not, but having some kind of level like this, but it's also the different systems and ways of thinking that are important, not just for kind of being better lawyers about, thinking more deeply and broadly about contract, criminal, family law, other things, or whatever the domestic area of law is, but also thinking about challenges like this, whether it be intellectual property or other things. You get that vaccine, that's great. How do we get the licensing and so on across different jurisdictions? How do we do that? So the interdisciplinary interlegal system, I don't know what the word is, systemicity. I'll leave it to others. That's me, I'm done, thank you.
Thanks. Can I ask Dipanshu to jump in?
Right, thank you. Well, I'll start by saying that maybe, and the word interdisciplinarity echoes so many times in the conversations we have on a day-to-day basis in everything that we're doing, is that I was wondering if we could probably go a step back and look at, and that's what shocks do. My training initially in the discipline of economics was focused in research a lot on looking at economic crises and how they shape new paradigms of theoretical edifices, right? Like what kind of macroeconomics works in a certain environment, what doesn't work, how does it intersect with areas of regulation, policy response. And one of the things that often brought me back with every shock that would happen is the true insights or the roots of interdisciplinarity lay down in a fundamental deepening of knowledge within the discipline. That is, that intradisciplinarity paves the way for the way disciplines evolve. And what I mean by that is, and I think I'll just use a concept from the work of Karl Polanyi in The Great Transformation. And this is something which I wrote about in a paper last year, where the idea of embeddedness, right, which tries to look at the actions of individuals, economic, legal, or systems, as always part of and parcel of networks of social relations, right? The moment we start looking at disciplines and structures of knowledge creation, right, and pillars of knowledge creation from an embedded perspective, I think it helps you a lot, whether it's particularly in areas of public policy. The way I'm seeing and understanding is that most lawyers, let's say, are far more interested in the procedural and institutional parameters of functioning of, and I can come back to this later, on what parameters of law and order would mean. Economists are largely looking at, and the way I see it, and particularly within the discipline, is on the methodological tools of how we are doing impact assessment, how we are analyzing. And the focus of that does not bring a more embedded perspective out of the sociology of relations or the context in which we are staying. And what the pandemic has done it's thrown the fault lines of a very deeply heterogeneous, polarized, even stratified society right out in the open, right? It's asking us some of the most fundamental questions, whether our processes of knowledge creation in any way are actually rooted or embedded in the culture or in the social context in which we are staying. And I'd probably argue that that's not the case. In fact, what we are facing as a problem, which the question tries to ask, is a disembedded view of law. It's disembedded from other fields and branches of social sciences. There is a conscious effort. I see that happening a lot at Jindal, that there is cross communication across, and I've learned tremendously from legal scholars, jurists, and I would say historians like Gitanjali herself, to know and understand how we go back and look at frameworks that can help us develop perspectives that are not perceived to consequentially be inclusive, but are inclusive in the way in which we start working, right? And I think that's something which we really need to. I have a few examples and illustrations, but let me come back to this as we expand upon this.
Thanks very much. Sorry, can you all hear me? Thanks very much, Dipanshu. Yeah, I mean, a historian often would approach a law and order kind of issue in terms of social crime, perhaps, and thinking about other. Yeah, no, I mean, I think that's a very well taken point, that you think about the knowledge in context. What does it do? And, you know, are we, what is our distance from subjects and distance from our particular lived situations or the lived situations of our subjects? Thank you. Professor Atienza, would you like to jump in?
Thank you very much to Jindal University for organizing this fantastic conference and for inviting me to debate on this topic, which I think is of particular relevance for law schools. And of course, we're talking about interdisciplinary, so this affects all disciplines. But I think in particular, the law cannot be taught in isolation from other disciplines. And this is the reason why it is of particular interest to us. And I would like to approach this interdisciplinary aspect maybe from a different point of view, which is the what are the challenges and how can we promote teaching programs that are more interdisciplinary? I think the biggest challenge to teaching law programs that are interdisciplinary is the regulation. It is the academic regulation and the regulation to access the legal profession. This is what makes many law schools design programs that are fully and only legal, that only comprehend legal aspects and do not include other disciplines. Now, one way to overcome this challenge is what many law schools are already doing, which is launching either dual degrees in law and in another discipline, or what I believe is more sophisticated, more complex, and even more enriching, which is multidisciplinary programs, such as the traditional PPE in philosophy, politics, and economics, or PLE in politics, law, and economics. These kind of programs are designed to offer very ambitious students who are looking for a very comprehensive and a very open and wide training, the education that will allow them to try to analyze and to solve problems from the different perspectives. And this is precisely what the pandemic has, I believe, made even more clear for us, that current complex world problems cannot be solved only from one perspective. They must be seen from the legal perspective as well as from the political one and the economic one, or from the social perspective as well as from the labor one and from the economic one. So I think the pandemic has only made us see even closer how we need to bring disciplines together, and we need to try to train the future professionals, and in particular the future legal professionals, with this multidisciplinary approach. And I very much agree with what Professor Brooks was saying about the international approach, because I think the international legal education makes us closer to a more multidisciplinary legal education. And the term that Professor Brooks was mentioning, I think interlegal system education, I call this multi-jurisdictional education. So the more we can train students to understand other legal systems, either by teaching international law, transnational law, comparative law, or by teaching additionally other legal systems to their own legal system, this will enrich the training of the students, and it will prepare them to practice the law with a more multidisciplinary aspect.
Thank you so much, Professor Atienza. Can I ask Professor Pandey to jump in here?
Yes, Gitanjali, I come in here. I have a different take from the point of view of law. The pandemic has taught us 4 areas for interdisciplinary knowledge. The first area is healthcare and patients' rights. The second area is again right-centric on healthcare providers' rights. The third area is economic and social fallouts resulting from lockouts and massive unemployments. And the fourth, which is very typical in India as a fallout, is domestic tensions and domestic violence rise in them because of resulting from lockouts and massive unemployments. Now, these 4 fallouts have, from the point of view of law, important issues arise. The remedies that law has so far in respect of these 4 areas is on equality. There is a growing disparity in the field of employment rights, in the field of even education. Many of those who cannot afford this web-based education are excluded from educational benefits. And this will have far-reaching implications for equality in the future days to come. The second is rights, constitutional rights and statutory rights. That issue flows from, and the remedies seem to have limited import. This came to light in the case of a great migrant march in India. And for 7 weeks, even the Supreme Court that denied that they have any rights. But after 7 weeks, the Supreme Court took suo motu cognizance and started rattling out rights of the migrant marchers who were, as if on account of lockouts, as a fallout of COVID. Then the third is justice issue. Justice in domestic violence cases, justice in unemployment cases. New dimensions of justice are opening up. And the roots of these injustices, these violences that are hidden in the society have to be, can be exposed only with interdisciplinary knowledge, and knowledge from all sources will have to come in. Now, this has importance also for human rights issues. Unless you see them as human rights problems, they have very limited in many countries. They would say that it's a clashing with sovereignty. We have a right to control them the way we want, but it's a human right of all people to be given healthcare rights, to be given employment rights to be given, violence, domestic violence, tensions, release them from tensions. So these are the issues that are very important for interdisciplinary legal studies. And I would come in Gitanjali later on. These interdisciplinary legal studies have at least three, from the perception of the knowledge dispenser. Knowledge dispenser will generate knowledge, will bring in different viewpoints in their new knowledge of legal studies. Then knowledge managers, those who are running the institutions, they have different roles to play. And then knowledge receivers, students who are to read these interdisciplinary legal studies, they have to look for a different kind of insight into the subject, traditional subjects. And I said, COVID has come as a blessing. Blessing because the legal studies had become, law is an autonomous system. Therefore, and within the autonomous legal system, different subjects have their different boundaries, and we'll study them, we'll teach them as per these boundaries. But COVID has taught us that these boundaries have to break down. New boundaries, new lines have to be created. And this is a great advantage of pandemic. I think a blessing of the pandemic. Thank you. I'll come in again later on.
Yes, absolutely. Thank you so much, Professor Pandey. Actually, right at the beginning, I think Professor Coles had said that there is a way in which, what was the exact word that you had used, that we don't necessarily need to see the pandemic as of course it is a crisis, but the challenges could also throw up something positive from them. You had used a different word, which I haven't picked up on. Anyway, I think this is a good moment for us to think about, think more deeply about the question, or reflect more deeply on the question of legal education, in fact. I think, as I mentioned earlier, interdisciplinarity, multidisciplinarity, these words have been around for a long time. We've been talking about it for a long time. And in Jindal and other places in India, we have the BA LLB program somewhat as an outcome of this. A 5-year program that brings together BA subjects, as well as, they have to do a certain number of BA subjects, actually a large number of BA subjects, as well as their 3-year LLB. So that was, I think, that envisioned something like this, for better or for worse. But I think disciplinary boundaries have shown a great resistance to being knocked down, or to really softening up, as it were. So quite with as much granularity as you feel you wish to suggest, how do we make interdisciplinarity happen in a law school, and sort of tagging on with that, how do we encourage collaboration? That's another thing that I think in Jindal we think about very often is, how do we think about collaborating across in terms of research? How do we, across fields, how do we think about teamwork even? Let me open that. Perhaps we can start with Professor Atienza, since you were talking quite squarely about the sort of law school program, a multidisciplinary law school program, and the challenges there.
Thank you. I believe that in order to promote a more interdisciplinary research, and to promote what I was mentioning, to design and to offer more interdisciplinary programs, the main thing is to have this as part of the strategy and the plan of the university and the law school. Now, once this is at the core, and once this is one of the principles and the values of the school, I think there's two different lines. In order to promote interdisciplinary research, each institution needs to design a plan that creates the right environment, as well as gives incentives to faculty in order to do this. So the situation for many academic institutions is that law schools, as well as other parts of the university, as other schools, are silos, and they work independently as an autonomous institution within a larger institution. So if the law school does not design a plan to put faculty together, to have to build a stronger relationship, to communicate with other faculty members, this is not going to happen. Now, once the school designs a plan for joint seminars, for workshops, that creates the right environment for them to talk and to be able to reach points of connection, points of interaction among faculty from different disciplines, this will be more likely to happen. The other part, as I mentioned, is the incentives, to give some incentives to faculty if this is what the institution needs to promote. What the pandemic, I think, has done in this area is that these very challenging times that we are all living has made many institutions and many people really have an aim to cooperate and to help one another. So in many institutions, we have seen teams or departments or schools that were working on their own in a very independent way had to reach out to other schools, to other departments, or even to other universities, even to their competitors, both to ask for help and to offer help. And I think we have seen some very positive examples of this during the pandemic. So if we could create this environment of cooperation among the law schools, that would help us to promote the interdisciplinary research. And in terms of teaching, of training, as I mentioned before, the more programs that we can design from scratch, from this either dual degree program approach or even more sophisticated multidisciplinary programs approach, this will also make faculty work together in those programs and will also enable for more opportunities for doing joint research.
Thank you. Yeah, so research environments, I think, are absolutely key to getting faculty to collaborate. I completely agree with you there. Professor Brooks, would you like to come in?
Well, I agree with that too. So, but let me try not to, again, let me try to say something that isn't just repeating things and try to have something a bit different. So but complementary. So one kind of model or one way of approaching this that I like to think about is and kind of some models of how law schools have been created and thinking about what our mission is and then getting clear about what our mission is and then using that to think more clearly about how we best achieve that mission and strategy. And I think that's a kind of a direct route towards the more interdisciplinarity angle and also thinking about branching and connecting with other legal systems now as well. So very briefly, again, in my time, so there's one kind of model of kind of an academic only, thinking about the law degree as an academic qualification primarily. That's what it does. A model you see in Europe, I think going back to Bologna, about 1,000 years ago, the oldest in Europe program, and where it was an academic degree run and organized and managed very well, but like any other program, like it was philosophy, like it was history. And so while it cared very much about recruiting people, a qualification was the main goal. A lot of attractions to that. We're all academics. We all care about the higher study of law and kind of digging in. The problem, of course, is if it's too esoteric, then we have this kind of wonderful theories that are theories about theories and that are not as connected to the world as it might be. The other model, another way of thinking about it, is something, and that way of thinking about law as a qualification, a more purely academic exercise, has its roots in a kind of what I've seen, a more continental European way of thinking about how law degrees work and how they're organized. And when I travel to the continent to discuss with other deans what they're doing at their schools, and I ask questions about what partnerships they have with firms and with the bar and other types of things that they have in their countries. I get, these kind of bizarre looks like, what do you mean? We stay on campus. My main job is sitting in my department, just like the head of philosophy, just like the head of history, just like the head of physics. I stay here and I manage my staff. I don't go to the big cities and talk to law firms and try to get money from them and placements and try to replicate anything they do. That's dirty. That's not academic. That's not what we do. That's wrong. It's not what we do. That's what I often hear. And the same thing happens a lot across the UK, to be fair. I'm not throwing stones at a glass house. The other side is, I don't want to say better, but I'm going to say different, is it goes too far the other way. So in my home state of Connecticut, I'm from New Haven, there's a law school called Yale. About 40-minute commute from there is a spot called Litchfield. And Litchfield Law School was one of the oldest in the common law jurisdictions. You can visit the museum in Litchfield Law School, but sorry, no one's had a visiting appointment there. They're not around because they've been closed for a very long time. They've got two former vice presidents who were graduates. They didn't do qualifications. They didn't do degrees. The purpose of a law school was about an apprenticeship. If you couldn't find a buddy or a family friend who could sort you out and let you sit in the corner and see how this is done and then use that to get yourself angled in, you could pay money to this one bloke who could teach you in his lounge, because that is a massive thing. If you're not going to beginning to think about technology and e-commerce and other types of things, then you are well and truly living on another planet, because everywhere from Burundi to everywhere else is moving in this direction. It's something that law schools need to begin to be doing more stuff about. And the other thing is, in terms of practice, is in engaging across different legal systems. People can, like or not like, various things and going on different countries' legal systems. But China and India and America and others are not going anywhere. The EU, people need to know about these things. And the big firms in Delhi, the big firms in London, and the big firms in New York are trading with each other. And we need to have some greater familiarity. It's not enough just to be good, knowing some things about things on the ground in one jurisdiction. We need to go beyond that. We know that and do that well, both by connecting with what's going on in practice, that kind of view of law, thank you, as a kind of a glorified apprenticeship kind of program. So it's important that we keep our roots. That's very important, though that's not a veto on what we do. It's just a kind of a sense check as to where things are going. Of course, not all our students will want to be lawyers and will go to be lawyers, and that's not bad. That's not bad. We should keep in mind that as well. And then on the other side, of course, that connectedness to the academic study. So I think when we think these things together about where our sector is in terms of legal services, right, where law is, to get that right, law is interdisciplinary, thoroughgoing by its nature. That thoroughgoing interdisciplinarity is not just about connecting to economics and philosophy and other things. It is also connecting to different types of systems, and that and there's various things changing. Its relation to technology is changing. In terms of the way advocacy works in a court has changed in every country. In every country, right. One of my colleagues is a Chinese lawyer. We have a Center for Chinese Law here, and hits a button, boom! I'm seeing all these administrative courtrooms in China talking in English, and live. Not all of them, but a number. And this is different. This is different, and we need to be alive to all of that. That's my thought.
Thank you. That I think you put out a lot of different things for us to think about. What exactly is the sweet spot in some ways for a law school? In fact, one of the audience questions that's just come to me is, so what is a course going to look like? What is an interdisciplinary course actually going to look like? Is it going to be highly theoretical? And therefore, I think the question also suggests unemployable. The person comes out of it is unemployable. Or is it going to be practice-oriented, which has its own issues? But we'll get to that question. Can I invite Professor Coles to make her comments? And then Professor Mohan and Professor Pandey, I think, can just follow from there.
Yes, just to pick on, thank you. Just to pick up on the that point you were talking about earlier on. And my point had been that all these challenges are our strengths. That was the word that, And it's our
Yes,
strength.
that's what I was looking for.
And it's our strength because it forces us, encourages us to bring in the different understandings of the pure scientist, of the politician. All these areas have different ontological approaches to the way that they learn and their awareness of knowledge. I think I would follow up on the point that Professor Brooks said about the use of various techniques that we can do within universities, and it kind of answers the point in terms of what will a university degree look like, is the value of the placement opportunity. So really having a look around at the universities that embed that, not only as a sort of add-on, but some universities are embedding that within the modules, and you're doing assessment based on the placement. The other aspect is really using the diversity within your university. So making sure that your staff are diverse, not only in their disciplines, but also in their perspectives, in their origins, and for the students as well. So international students and their contribution that they make, and in all the different areas, will be really key there as well. So, and then finally, what I would make in what a degree will look like is there is a huge change that I'm not sure whether your participants are up to speed with in the UK LLB, in the strict regulation of it has very much been relaxed. So the UK is moving away from 7 key subjects that you must teach starting in a couple of years' time. So there's going to be a lot of opportunity of putting different sorts of modules. Maybe they may be some philosophy-based, some regulation-based, some business-based. Many universities have law clinics where people can practice not only giving that legal advice, but also the communication and the sensitivity and the kindness and support that, again, COVID is showing us that's so important. So to answer the question, what would a university degree actually start to look like? I bring back it should be something that calls on the strengths of the pure scientist, the finance, the regulator, but also the ethical, philosophical areas, put that in, as well as the practical experience that might come from a placement, practical experience and social experience coming from the sort of clinical education, the idea where the student is acting as an advisor, and do have a look at the huge change that's impacting every UK law school, because it's coming from the national regulator, that they're opening the doors to UK law degrees to have much more diversity and difference within their modules. So that's my answer to the question.
Thank you. I saw that I have the word strengths written right at the top of the list of things, and somehow I just couldn't find it when I needed it. Yeah, I mean, not to be facetious about this, but it is we've heard before that we shouldn't let a good crisis go to waste. So maybe this is I think what I'm hearing for all of you is that this is actually the right time for us to start rethinking legal education in certain ways to deal with these kinds of issues this is probably not going to be the last one, right? Professor Mohan.
Yeah, so I'll from being more of an optimist, I'll be more cautious in the degree of optimism. And I say that because I think the way, at least I'm seeing it, the way higher educational institutions are, looking at this is less of an opportunity, but more temporarily trying to sail our way through this. There are really less structural changes being made in really adopting technology in making education accessible. I'm seeing this entirely in context to, India has no homogeneous structures. There are 3 Indias that you can look at within the country. So I'm just talking about the one which is right at the bottom of the pyramid. Professor Pandey has pointed out a couple of points already. And I think till the time as I said, our process of knowledge creation does not transcend from a coded dictionary to a more perceptive and intuitive pursuit, I think this is the way it is going to be. You have systems of teaching and learning which are largely focused, as Professor Brooks pointed out, on coded knowledge. And particularly this is true of legal education per se. Procedural, institutional, how is that I can get an extension on a date in the course? What happens to sentencing? How do you file an appeal? Yes, as important as that is, if you're trying to expand on the intuitive base of a student and make him or her more perceptive, sensory, intuitive, in a more Eastern knowledge sense, karmic, all of those structures of knowledge processes need greater exposure. And I think that, yes, clinical education is a way forward, but where are the incentives? You have to ask yourself the question, I say this to students all the time, in Jindal itself, there are many students who do clinical courses, but they don't see the incentive. They want to end up in a corporate and commercial legal firm. And you don't blame them. Why? We all made those choices ourselves at some points of time in our respective pursuits. So I'm seeing COVID or a pandemic as a tight slap in our faces. You know, we really need to look at what are we trying to do here. There is a crisis in hand, and I'm going to take just a quick minute to say and just expand what Professor pointed quite eloquently put out, that three major areas where lawyers and legal, when I'm saying lawyers, I'm talking about those who are interested in the pursuit of litigation, and those who are already exposed to legal education, both would want to get a better understanding of. The first is economic and social rights and issues around economic and social rights. Just talking about rights and the classic Bentham and Hart divide, we are right now in a governance system, I'll be honest and I'll speak out loud there, which sees rights as children of law, not as parents of law. This is the debate that Bentham and Hart had on what did we see as rights to be. So this is not a very rights-based social system or political system of our pursuits. To give you an example, Model Tenancy Act, Madhya Pradesh state in central part of India, they invited me for a consultation to see whether this was just 3 days ago, and they're passing a law so that can make rental housing more affordable for people. This is a realization made from the massive migrant seasonal labor crisis that saw chunks and chunks of people moving out, not being able to come back. And it was not a crisis of the lockdown, it was a crisis of a rental housing availability. People couldn't stay at their homes and they had to leave their wherever they were staying. Now, what happened as a result of this was that when I saw the act, the Tenancy Act, it has absolutely no mention of the social context in which we are a part of. When I say that, what it means is it takes neutral terms like a tenant and a landlord and brings out very eloquently the structure and the language of law. The main issue is not of the relationship between the tenant and the landlord. It's about those who do find it difficult to get rental housing or housing per se. That's single working women, people from certain communities, classes, and there's nothing that was mentioned there. And we created a structure of conversation around that to build and you'll be surprised to know very few legal minds on the platform were even saying, well, let's do this. The idea was, listen, we need to get this done in 24 hours and we're getting this fast. So this is the way things get done, right, in the system where we are looking at. The second is healthcare, which was also pointed out. ASHA workers, this is the accredited healthcare social activist class. I am talking day in and day out to an average 30 people as a part of a team to understand what ASHA workers are going through. They haven't been paid and you'd be surprised to know the average pay was less than.
Dipanshi, I'm so sorry to interrupt, but would you like to just explain what an ASHA worker is?
Yeah, that's what I was trying to do. So the ASHA worker starts for an accredited social healthcare activist. This is the main medical service provider for ensuring that all maternal deliveries happen institutionally in public healthcare systems. They are technically, in legal terms, considered a volunteer and are paid a stipend. They have no access to minimum wages. All they're paid is rupees 2,000. I think that would roughly come to around what, 30 to 35 US dollars a month. And they have not been paid 30 to 35 US dollars a month for the last 5 months. On an average, I'm talking about in the state of UP where we're trying, and there's enough sample there. So when I say this, I mean, if you're really trying to improve healthcare and talk about rights of medical service providers, at least understand what they're going through, what was on the contrary happening. Any ASHA worker who resigned or confessed or put out this as a complaint was not only let go, was charged with the police criminal act right here. I'm just talking about how law is being used in that sense. The final point is on justice. And to anyone who's asking, how do we learn and how do we teach students? I mean, I'm just reading 2 quotes and any one of you may be probably able to guess this. Quote 1, liberal requirements of justice include a strong component of equality among citizens, but that is a specifically political demand, which applies to the basic structure of a unified nation state. Humanitarian duties hold in virtue of the absolute rather than the relative level need of the people we are in a position to help. Justice, by contrast, is concerned with the relations between the conditions of different classes of people and the causes of inequality between them. This is Rawls. And I see this a potential for a sociologist, an economist, a legal scholar, a political scientist, all to make out something from what has been said here. That is the way you have to try imparting knowledge where you are discussing a concept in the process of its social context and political context and economic context, right? The final quote is one which I don't know if you'll probably guess, and I'm going to ask any one panelist to maybe guess this. Justice, the last and greatest of the 4 cardinal virtues, took place according to this system when each of the 3 faculties of the mind, prudence, benevolence, and propriety, confined itself to its proper office, without attempting to encroach upon that of any other. When reason directed and passion obeyed, and when each passion performed its proper duty and exerted itself towards its proper object, which was suitable to the value of what it pursued. Can anyone guess who's this? This is Adam Smith in the Theory of Moral Sentiments. And we see Adam Smith as the founding father of what? Modern economic thinking. So there's a lot for us to, I think, go back. And I think for each one of us to go back to our own disciplines and learn more about that. Before we, I mean, these conversations are just one of the pathways. But that's what I think I'll probably pause there and we'll come back.
Thank you. Thank you so much, Dipanshu. I think the importance of social research is something you very, very firmly established there. Lots to talk about, but I'm so sorry that we need to move on. Professor Pandey, would you like to comment?
I think sir is on mute.
Sir, Professor Pandey, you're on mute. You'll need to unmute yourself. Sunai nahi de raha aapka awaaz.
The idea in the sense that it is not what conflict of law has already one system of law interacting with another system of law, another autonomous system, civil law system, and another people doing it only for the sake of limited corporate practice. Not that. When I say interdisciplinary knowledge, it has to be a revisiting of legal knowledge, which has not been done. That's why I say pandemic is a blessing. This has given us an opportunity, this has given us a challenge that we, once for all, I had a discussion with Raj the moment this migrant problem surfaced, and I said, Raj, it is high time we should set up a center for migrant legal and sociological studies in Jindal Global Law School. All sociological, all economic, all legal problems of the migrant population. Who are the people? Why they migrate? Why they walk back in millions? Now, this is the kind of knowledge that we have to, knowledge generators have a very heavy responsibility. It is much more than what UK model has been practicing, what even Professor Brooks is talking about. It is much more. You have to generate, you have to bring together ideas from economics, from philosophy, from sociology, and then give to legal education a new perspective, a new way of looking to human needs, a new way of looking to human wants. I remember a long time back when this food right petition was being argued in the Supreme Court. I had done some work on food rights, and Senior Singhvi Sahab, he was arguing for them, and he wanted my notes for arguing in that Kishan Patnaik case, Kalahandi petitions. And I made them available to him. But I at the same time thought the legal profession is so distanced from the problem of hungry people, people who need food. Why? Why should it happen? And then later on, the Human Rights Commission took up, Justice Verma, J.S. Verma, the chairman, he took up and he said, Pandit, we have passed an order. So that is the idea. Interdisciplinary knowledge will have to dig into new areas and bring in together new knowledges, new awarenesses, which has been for the first time underscored and brought to us by this pandemic. That's why I call it a blessing. This knowledge has come, Greta Thunberg had been talking about it on the environmental plane. But this time, this came in a much stronger warning. And this is time for us to revamp the whole legal education system itself. And therefore, I call it a big challenge for the knowledge dispensers, those who will generate knowledge, who will create this kind of new legal linkages and collaborate with people, economics, philosophy, sociology, and look to the society around us. Mohan, this young scholar has been very impressive. He has been talking of Chhattisgarh problems, the problems of the housing problem of, these are the problems that have to come on board. They've been ignored for much too long. They've been just skirted under the carpet, but that should not happen. And law has been talking of autonomy, of higher problems. And I remember Herbert Hart in one of his quotes saying that the problem of dispossessed and the problem of we are not bothered about them because they can care not to bother about them. Legal system, if you make for only people who are haves only, what about the have-nots? They will struggle. So I think this interdisciplinary knowledge to me is a very pious and a very big challenge that needs to be met right
Thank you.
now. And tomorrow may be too late because our system will become irrelevant for us, so for the society, larger society. Thank you.
Thank you, Professor Pandey. Actually, we don't have a lot of time left, but I did want to take one or two of the audience questions. We've covered a lot of the ground in terms of the questions that have come, but there is one. If I could just ask you all to make a quick 1.5 minute comment, although it's the kind of issue where we could probably go on for some time. Sorry about this, but it is what it is. The discourse on the relationship between climate change and zoonotic diseases has gained traction during the pandemic. Do you see this as an area of potential interdisciplinary scholarship and partnerships? Could I ask Professor Atienza to start? Give us a quick comment.
Thank you. Yes, very much. And we have seen already in the past few years, and we will see more multidisciplinary programs, for example, in the area of sustainability, from a legal perspective, from a management and business perspective, as well as from an economy and an environmental perspective.
Professor Coles, thank you. Professor Coles?
Yes, indeed. I mean, the strength to our knowledge and our understanding of looking at an issue from all these different aspects is going to be the way forward. The issues are global, and therefore we need to tackle them in a global way, and that includes not only global in terms of nationhood, but also in terms of subject matter. And that's the way I think we will. I'm confident that we will be able to solve them, but we'll need everything we've got all together.
Thank you. I mean, actually, one of the maybe interdisciplinary things that have come out of the environmental challenge has been environmental humanities, actually, just sort of looking at, and it's sort of separate rubric altogether. Professor Brooks.
Yes, and I think one of the things to kind of try to say something a little different but complementary is one thing is not only do students have a greater interest in these issues, not only are we're all now not experts, but we're all more knowledgeable about coronavirus structures than we were 6 months, 8 months ago, which itself is interesting. What's also fascinating is this raises another issue that's related. A lot of people wonder about, could we really, a lot of people, accept the scientific consensus on climate change, believe we need to do things, some questions as to which areas should be talking to each other more and other types of things. But one thing that has been really interesting is that people wonder, would they really be that shocked? Would we really be willing to kind of change our fundamental lifestyles, like not being in cars, use buses less, work from home, other ways of working. And we've been seeing kind of a dramatic decreases in carbon emissions and other things, which has been remarkable. So not only do I think that there's this opportunity now, greater interest, knowledge, and all the rest of it, which is a great way of spurring people to want to collaborate more. And when that happens from the bottom up, other things follow that are good. At the same time, the other thing about climate change of actually trying to stop it or do something about it, it seems that we've been making some progress on that, and long may that continue.
Thank you so much, Professor Brooks. Professor Mohan, quick comment?
Yeah, well, just, climate change, let's start from where we teach. I think as an experiment, we did this last year where I just took students for the class back in our campus. And I was taking the class half of the time in the sun. And then I could see everyone sweating, bullocks, like almost. And after half an hour, I asked them, well, are you comfortable? And they were like, well, of course not. Why are we not inside the classrooms? I can now justify saying that social distancing norms can justify taking classes outside if the weather allows you to do so. But then they said, well, we can go to under a tree and do the rest of the session there. And we did exactly that. And I said, well, now you understand why trees are important, not around on campus, but just the place. And you'd be surprised too, these are graduate students. They don't need to be told this verbally, but when it becomes a part of your lived experience of sorts, it just makes, we generate the maximum amount of waste in the entire Sonipat area. That is, as a university, but we are also kind of having the largest green cover presence. So there's a lot that we can do, but as I said, this is a good point. Take sessions more where you can. I know at Durham and other places, maybe it's difficult doing that with the cold, but where you can, I think just make the lived perceptive experience of students to be more engaged with nature.
Yeah, this is reminding me of the environmental law. One of my colleagues who teaches environmental law, his very first class, took his students for a bird walk around campus, and it was very successful actually. Professor Pandey, the final word is yours.
I think that, to my mind, this interdisciplinary knowledge, knowledge of future that I have in my mind, knowledge that has not been in existence so far, or it is only in patches, will not only serve the lawyers and the judges, will also serve the legal policymakers, will also serve the legal administrators, will serve the media, will serve and have a more enlightened society ultimately. Therefore, this interdisciplinary knowledge is different from merely a law course knowledge that we are acquainted with at the present. Maybe that's a very far-fetched and a very ambitious thing for an old man like me to think of it and dream. It is a dream which may never come true, because legal education holds its grounds and very strongly it holds its ground. But my plea is that legal education requires a revamp, a thorough revamp. And that is a legal education that will be more acceptable in the society, that will create a future society where legal policy makers, legal will be more attracted towards legal studies ultimately.
Great. Thank you. I think that's an excellent note to end on. Thank you so much. I think we have to move on to the next session, but I'd like to thank all of our wonderful speakers. I think that we could have extended this session to a couple of hours more, maybe at least, and, got into greater details about various things. But I think you've all brought in.
Thank you so much. Thank you so much, Gitanjali.
Thank you, everyone.
Dean Tom Brooks, Professor Pandey, Professor Coles, and of course, Dipanshu. Obviously, as Gitanjali said, I echo her thoughts and deeply appreciate your presence. We are, of course, immediately moving to the next session. I look forward to hosting all of you on campus in India. Thank you very much.
And we'll
Thank you. Always a pleasure being here with you. Sorry for the delay.
No problem. Good evening from India. Good morning to people in the United States. Good afternoon to people in Europe and other parts of the world. My name is Raj Kumar. I'm the founding Vice Chancellor of Jindal Global University. I would like to extend a warm welcome to all of you. The second day of this global virtual conference on reimagining and transforming the future of law schools and legal education. We are, of course, on the 17th thematic session of this conference on the theme Executive in Continuing Legal Education during the pandemic, role of law schools and judicial institutions. We have with us a very distinguished group of individuals, leaders of bar, as well as the bench, who have kindly agreed to participate in this conference. Let me begin by introducing Professor Suzanne Rapp, Professor of Commercial Law at Brunei University, London, barrister at Cyril Court Chambers, London, law lecturer at the University of Oxford, United Kingdom. Pleasure to see you, Suzanne. We have with us Professor Dr. Mohammed El Zhori, Dean of the College of Law, Al Farah University at United Arab Emirates. My very dear friend, Siddharth Luthra, Advocate of India, and of course, another very dear friend, Honorable Dr. Justice Emmanuel Kabuja, Judge President of the East African Court of Justice at Arusha, Tanzania. I am also grateful to my colleague and dear friend, Professor Dr. James Dumbara, Professor at Jindal Global Law School at Open University, who has kindly consented to be the moderator of the session. I will now hand over this panel to James and will be watching all of you, hearing you behind the scenes. Come back shortly. James, over to you.
Thank you, Dr. Raj. Thank you, esteemed panelists. It is my distinct pleasure to be part of this panel and to be part of this exciting conference. So I will be speaking about the continuing legal education. As we all of us know, the COVID-19 crisis has completely or fundamentally changed our lives. It has changed the legal, it has changed the economic and the social order. So the pandemic has created a virtual workforce, which performs remotely. We are also working from sometimes our respective houses. Although this ensures a sustenance against the challenges of the pandemic, working virtually has got its own limitations. Particularly in the legal field, the professional landscape is now marked by the closures of law firms, depleting clientele, cancellation of physical meetings, and appointments with clients. So in a way, virtually everyone is suffering. But at the same time, fighting this pandemic has also taught us how to reskill ourselves. We have to actually live in this world. We have to master the technology. And at the same time, we have got an opportunity to participate in this global reordering. We have to also admit the fact that the post-pandemic reconstruction would require a different kind of a skill set. It is in this context that the executive education programs become extremely important and topical. And this is an area where the legal profession should also be facing the challenges head on. Moving online provides a great set of opportunities for law schools to provide executive education programs, either through the online mode or in a blended format. The blended and the asynchronous modes of learning would facilitate the participation of legal professionals who otherwise cannot afford full-time education. Further, the skill transfer, that gap can be shortened. There are many advantages. So in this particular context, the continuing legal education is also a form of a continuous learning opportunity, and it also provides you a window of opportunity to learn new skills, learn about new ethical considerations, and it will actually allow us to grow ourselves. And in a way, we have to become a T-shaped lawyer in a fast-paced, in a fluid marketplace. So there are so many challenges involved here. I would definitely say that the lawyers, the judges, the legal academia, we are all bracing a major challenge, but at the same time, a great opportunity. And since we have got an excellent team of people, both from the academia, the legal services sector, and also from the universities, we should actually use this opportunity to get their feedback and take the valuable suggestions in reshaping our economy and the future of the legal profession. So without further ado, let me go to some of the esteemed speakers that we have with us today. I think each speaker will be given around 3 to 4 minutes to give a response to a particular topic. And I would like all the panelists to be extremely concise and respond to the questions in the period available. And if we have got a bit more time, then we can actually take a few questions from the audience as well. So let me, turn to the first speaker. I think it is Mr. Siddharth Luthra, Senior Advocate. So this is a question relating to the legal profession. So we know that it is imperative on the part of the lawyers to continuously update their knowledge and keep themselves abreast with the developments in law and society, especially in a rapidly changing environment. My question is, how has the ongoing pandemic changed the legal industry's demands and expectation with respect to the new areas? What are the skill sets which are actually required from the legal professionals? Over to Mr. Siddharth Luthra.
I speak as a litigating lawyer, and I must tell you, the change has been in two sets of changes. So far as law firms are concerned, the mechanism of physical filing, preparing documents, physical conferences, all of that had to change overnight. Law firms had already, most of the large law firms already had some infrastructure in place, but they had to upgrade and they had to change. The second is imbibing a balanced work from home culture, where while the office is now at home, at the same time, there is also a home life or a personal life left. The lawyers, as you know, rarely have much of a personal life. The third is, so far as counsels are concerned, senior counsels and counsels, we've all had to change and develop and adapt to electronic courts, VC courts, and to electronic handling of documents, and to be able to use electronic devices effectively. We've had glitches, and I must tell you, I was one of the first, possibly the first lawyer who got an anticipatory bail from the Supreme Court on WhatsApp because the communications had failed early in March. Today, of course, things have changed a lot. But on the unfortunate part, there are a number of layoffs, as you pointed out, and a lot of people need to reinvent themselves to make themselves relevant, because there was this entire range of paralegals who was processing documents. Today, the need for the paralegals is reduced, and that sector of our industry is going to get impacted. With work from home, there was a lot of support staff that used to add up to the law firms. That used to get impacted. And the worst hit in the legal profession is the fact that trial courts took a long time to open. Now, if the trial courts and the original side courts in a country don't function, there is going to be no appellate work. The appellate court lawyers have gone through a constraint of work, but that constraint is going to continue because the impact is still being felt. So all of these are concerns which we need to deal with, and it is time. All of us have had to evolve, and as time goes by, we are all in a process of constant evolution where we are trying to meet with the new challenges. One of the biggest problems in India is you have different program softwares for different courts. So I have to switch if I'm appearing courts. The advantage, of course, is the ability to be in different jurisdictions on the same day. I've appeared in 4 different high courts on the same day. I could have never done that in the physical world. So there are challenges and advantages, but eventually what we really need to do is reinvent ourselves in a manner where we learn skills which make us effective in a virtual world. And virtual courts are a very different ballgame. And I can tell you that now from the last 7 months.
Thank you, Mr. Luthra. I think that was a very, very valid intervention. What you said is absolutely right. Now the world has become a stage for everyone. You can operate from any part of the world at any time. So it has basically expanded the opportunities, but at the same time dwarfed the opportunities for some categories of people, which you rightly pointed out as the paralegals. The second question which I intend to ask Honorable Judge Emanuel is something related to the functioning of the court itself. So if you heard from Mr. Siddharth Luthra, the legal profession has become very demanding. It has become very time intensive as well. So the one question which I would like to know, given the need to be well versed with technology to engage in effective outcomes, how useful would it be for the members of the judiciary to have a short-term legal technology program? How can the judiciary leverage support of law schools to develop such executive learning programs? Over to you, Mr. Judge Emanuel.
Thank you very much, Mr. Moderator. First of all, let me appreciate Jindal Law School for having invited me to this very important topic. Jindal Law School has defined itself as an institution which thinks about tomorrow and acts today, so I really appreciate you for that. It is true that we faced an almost dramatic shift from how we used to conduct business in court, and it's not only my court, I think it's all the courts worldwide. But this was to be expected even without COVID. The courts, most of the courts at least that I have interacted with, were trying to adapt to a more virtual world in certain aspects of the court. But when COVID came, the challenges of COVID led every court to, all the courts were thrown into the deep end, and they learned how to swim in an extremely difficult world. If any of us judges, if you were asked last year whether we will work the way we work today in the virtual world, we would think that it is a fictional movie, but it's happening. However, having said that, there are quite a number of challenges which we face as judges, and which I do believe we can partner very well with law schools, because law schools can easily be able to develop curriculum which is relevant to the virtual courts. I do believe that it's incumbent upon the courts to partner very closely with the law schools. I've seen this in one of the jurisdictions, and this is in Singapore. I've seen that in Singapore, the universities, the law schools do have executive courses which they've developed, and I was privileged to attend one of those courses. So it is possible that we can emulate what has been done elsewhere, but it is also important that we learn a lot from these jurisdictions which have advanced in terms of executive curriculum for continuing legal education for judges. Let me point this one thing as I conclude. This big bang that happened to all the courts have led the courts to learn what can work virtually in a virtual manner, what should be done physically, and the difference between the two. What we've noticed is the preliminary stages of cases can be handled in a virtual world, even beyond COVID. That I believe the courts should continue doing so for purposes of efficiency. But there are certain aspects of the sessions of courts which it is difficult to in future beyond COVID continue handling in a virtual manner. The advocates here will tell you that cross-examination is not necessarily effectively done on a platform such as this. I do believe that if courts get together with the law schools, they can look at the most appropriate sessions which can be handled in a virtual manner and what can be handled in in a physical manner. Because I do believe that COVID-19 and challenges that come with it are an outlier. I don't believe that it will continue like this. But let's start COVID-19 and its challenges as is an eye-opener on what can be achieved. Thank you very much.
Thank you, Justice. I think you mentioned some important points. This kind of a blended approach that we use now in the case of legal education can be a solution with respect to the courtroom functioning as well. I'm also very glad to know that some of the universities like Singapore have taken an initiative in this particular regard. So now let me turn to Professor Susan. My question is actually with respect to the legal education sector. So now most of the lawyers have got ample amount of free time, so they can join a large number of online programs. So my specific question is that, given this particular opportunity, that physical campuses have been temporarily shut down, how can law schools leverage technology to provide legal professionals easy and flexible remote access to executive education programs? At the same time, what are the various limitations of online learning, especially in relation to short duration programs? Over to you, Professor Rab.
So I speak partly as a practicing member of the bar, as a legal practitioner, but also as a professor of commercial law in an academic environment. So I bring a multidisciplinary perspective to these issues. And what I see is a growing need for there to be that nexus between the academic classroom and the practice of law. And recognizing some of the observations that we've mentioned earlier, that inevitably there is a huge part of the legal profession that is recognized as becoming redundant, and not just for the interim, but causing a real question about future sustainability and business models. And that's where I think it's very important for there to be transferable skills that are useful in the legal sector, but also elsewhere. When it comes to online learning, and I speak here from a number of initiatives I've been involved in, I teach at traditional bricks and mortar universities such as Oxford, but also with the Open University in the United Kingdom, which in the early 70s pioneered itself on distance learning. So they had something of a head start in the sense of already online learning was within their DNA. And the message we take away from this experience must be that this is an opportunity, but ultimately those who are not agile enough to respond will fall by the wayside. Online learning, can it replicate the experience of physical? Well, I must say I had some skepticisms at the outset. I had a 5-day program I was supposed to deliver physically in April, and within a week transformed this, working with a technology provider to allow for that to be delivered through a virtual platform that involved virtual breakouts and looking at how you can simulate a physical environment. Yes, it has its other challenges, but it is not as straightforward as putting a PowerPoint on a screen and delivering it in a webinar format. But I have been inspired and motivated about what is possible. But what has been really interesting for me on the nexus between academia and the real life practice that this has indicated is that the training techniques that we've seen, the education techniques, are actually deployable in the real world to resolve disputes. And with the courts involved in social distancing, with the stop-start that has been experienced around the world, this has been a focus on alternative dispute resolution, which the merits have been recognised for many years. And this is an opportunity now to really realise and deliver on that and invest in that as a practice area. I have seen a rise in my own mediation practice, my online arbitration practice, where not only are we teaching people how to mediate and become arbitrators through an online forum, but we are actually mediating and arbitrating those disputes. And that eases the backlog on the courts. So I would like to see a synthesis between education, training, but also practical deployment of these techniques through real life dispute resolution. So it's gone from outside of the classroom and into the real world.
Thank you, Susan. I think, thank you, Susan. It is an excellent point. What you said is that the law schools which are not agile or who are unable to actually come out with innovative programs of who fail to adapt will actually fall by the wayside. I mean, that is something not only true for the law schools, but for every profession, including the courts. But I think there are major challenges. Actually, your emphasis on the synthesis is extremely important, given the fact that there is a significant disconnect between what the law schools do at the moment and the professions do. Because when people actually graduate out of the law schools, that is the end of education for them. So this is a significant opportunity as well. Let me again turn to Dr. Siddharth Luthra. This is with respect to the continuing legal education. Given the fact that the continuing legal education enables lawyers to constantly evolve in knowledge, competence, and efficiency, which in turn improves legal professional standards and also to increase public confidence and legal professionals and the judiciary as a whole. So what do you think about the significance of the continuing legal education in the context of India and the Indian legal profession?
Well, you know, the Bar Council of India, which is our regulatory body, came out with a directorate of continuing legal education, and it has not achieved its objective. So what is necessary is for the universities such as yours to step in, because today we are at a crossroads. You know, we are at that stage where the legal profession is now having to deal with a marriage between technology and practical life. There was a lot of things that we did in the physical world. The simplest thing was, you know, using a vehicle, going to a government office, going to get a property registered, the most basic essential needs. Now, all those basic actions which we were doing from morning till night have now been reduced to the virtual world, and therefore there are regimes that will need to be developed and legal mechanisms will need to be developed to deal with these new relationships and the new formation of these relationships. There are great opportunities. Companies which have adapted have come out with technologies. Today we are on Zoom, and that's something which nobody was using. It was unheard of. VCs was not only inaccessible, it was rarely used. Nobody wanted to do VCs in the legal profession. We all wanted physical meetings, clients as well as lawyers. We never thought we'd be in VC courts. All of that has changed, and according to me, it is important for continuing legal education to address the application of technology to practical life and the legal opportunities that arise out of this. This is essential for us to be able to better advise our clients, as also to develop legal regimes while governments act, because legislation is going to take time. Meanwhile, the advisory work, the documentation work, the disputes that arise out of this are going to be, unfortunately, immense. At least, well, great opportunities for lawyers, not necessarily for the clients. And that's the focus. And that is a niche area which only law schools can achieve. And that will, according to me, is the new barrier which you have to cross.
Yeah, I think, thank you. That is a valid point. From a simple, economic assessment, the new virtual courtroom hearings and other things open up a significant amount of opportunities and at the same time cut down the transaction cost. So you don't have to physically travel to a place in order to have a meeting. All these things can be done virtually, that is a significant economic efficiency. But at the same time, I agree with that. We have to be nimble. The law schools will have to actually provide qualitative improvement in the education as well. I think these are challenges. Now, let me again turn to Justice Emmanuel. I think so. We have been going through this pandemic, and the pandemic has opened up a large number of new age issues. For instance, cyber fraud, data privacy issues. So some of these issues will definitely occupy the time of the courtrooms in the post-corona world. Given the transition in the subject matter expertise required by certain lawyers, Justice Emmanuel, what areas in your opinion should be the focus of developing executive education programs?
Thank you very much, Mr. Moderator, for that very important question. You are right in pointing out that certain issues have arisen, or certain disputes, crimes, if you may, such as cyber fraud, data privacy issues, cyber-related disputes generally have arisen as a result of the use of this technology. I do agree with you that these are the issues that the law schools have to pay attention to. But even within these issues, what is more important for the judiciary is how do you deal with the evidence as a judge when it's presented to you? As you will all agree, these issues involve a lot of science. So it is also natural that sometimes there will be requirement of expert witnesses before the courts. So it is very important that judges are trained. I know judges don't like that term of being trained, but this is the new world that we live in. But I do believe that judges should be trained on how to deal with sciences in courts, and when this science comes in form of evidence, and how to deal with the expert evidence that comes with that. This is very important. So for us on the bench, the most important part is dealing with evidence. And this is what the law schools, when developing this executive continuing legal education, should pay attention to.
Yeah. So thank you. I think let me actually recall a statement which is attributed to Winston Churchill. I would like to learn, but I wouldn't like to be taught. I think this is especially true with judges, given the fact that the challenges will be extremely, I think, new in the future. Judges will have to learn a lot of things. And law schools and other executive education programs shouldn't actually call, I think, call them a classroom, maybe an interactive opportunity. So there are various ways in which we can interact. So now let me ask one question.
Just because you cited someone, I also want to cite someone in 2 seconds, and this is Alvin Toffler, who said that he's an American author. I like this quote. He said that the illiterate of the 21st century will not be those who cannot read and write, but those who cannot learn and relearn. So yeah. Yes.
I think that is well. That is well said. That is well said. I really appreciate that comment. One more question to Professor Susan. So this is with respect to the executive legal education. Given the fact that the average batch size of executive programs in law could include people with varied backgrounds and attributes, varying professional backgrounds, in what manner do professors develop a teaching methodology which can benefit all categories of people, irrespective of their professional backgrounds or diversity, including their cultural background?
So the topic of diversity and inclusion is a huge one, which I can't possibly do justice to in the 3 minutes that I have, but is something which has really come to the fore in these times. And I think we need to look beyond just issues of culture and the more obvious diversity metrics such as gender, race, and others, but also looking at socioeconomic factors as well. And I think that's where, when we are all reliant on technology, the patchy covering of fast, high-speed internet access is a palpable concern. And I can see that resonates in India, but it is also a phenomenon in the United States. And it is not confined to jurisdictions that may have other income disparities. In the United Kingdom, there are huge efforts to try to achieve much greater rural coverage. So I think we have to come at this not by taking as a given that everybody is going to be able to get online at the same time. Some households will be sharing one mobile phone for all learners, whether they are school children or whether they are in tertiary education. So I think we need to get real that some of our students may be very privileged, but others may be in households where they are sharing devices with a few hours a day. And I think that brings us to think about how can we adopt a more blended approach here, which caters for that. And I think the mix between both the synchronous, real-time exchange and asynchronous, which allows people to do things at their own pace. I've seen desert-based education systems in recognition of that, which we can be inspired by from the Middle East, with people studying at their own pace. And we're seeing more of this through educational tech. I was due to travel to Hong Kong in the summer to deliver a 10-day program to judges and others in the public sector. It was progressively delayed because we thought at some time we'll do this physically. But ultimately, we ended up doing it virtually. And you will think, that is an 8-hour time difference. How can that be managed? And it can be when people want to do it, but it requires flexibility on all sides. We mentioned the point about an inclusive curriculum and looking at different subject areas. I think here one important subject area we're missing is the need for education around emotional intelligence. And I don't call that soft skills, but the techniques that really do distinguish people and empower them and let them improve their life lot. And that's where these challenging times have focused all of us on the need not just for intellectual resilience, but emotional resilience as well. And I believe these techniques will be the key to social advancement and diversity in the future. And I'm going to end with a quote here to mirror the quotes that have been given by my eminent colleagues here. But I must say this is more from the world of movies than it is from law and politics. And you might have viewed the Game of Thrones, which is an export from closer to my home. If you haven't, don't worry about that. But that talks about chaos as a ladder. And there's an iconic line in that series where one is told that chaos is indeed a ladder. Many try to climb it and they will fail, and they never get to try again, and the fall breaks them. But some are given a chance to climb, but they refuse. And I think this is the biggest challenge for us in diversity now, which is accepting a huge attainment gap. But this is an opportunity, but we must not disillusion ourselves and say that before we can do any of this, we need to sort out the issue of access to technology in the first place.
Thank you. I think, thank you, Susan. It is an excellent observation. You also pointed out the need for synchronous as well as asynchronous kind of learning. In a place like India, we know that even most of the lawyers do not have a private place for themselves to sit and attend these kind of online programs. I'm not talking about even their ability to pay for the programs. So, these are very major challenges, the diversity. And of course, I think the lack of ability to even absorb. These are major concerns, actually. Let me again turn to, Justice for a comment with respect to the legal profession. So the question is that given the nature of learning in executive legal education, and that this learning will actually go online, how can we engage with the distinguished leaders of the judiciary to add more practical experience to the learning outcomes? So in short, how can we make sure that the leaders of judiciary, either sitting judges or maybe retired judges, can actually contribute to the practical learning experience?
Thank you. Thank you very much once again for that question. And you're right in pointing out that there is always a way that either sitting judges or retired ones could contribute to the training of new judges and as well as other people in the legal sector. I do believe that there should be development of systems for judges and senior practitioners to spend periods of time as visiting academic fellows at university law schools. Such programs have been in existence in certain law schools. I can name of one that is at the University of Hawaii, where senior lawyer judges are invited. I participated in it as a visiting judge, and I attended the university for a week. I was provided with office accommodation and gave a couple of lectures, including public lectures, participated in staff seminar, and otherwise engaged in informal discussions with staff and students. It was a very rewarding and enjoyable experience for me. And I do believe that it's a two-way process. I also do believe that there should be development of a system under which academics could be visitors to particular courts or particular judges' chambers for a suitable period of a week or so. The visitor would have the opportunity to observe court cases and, subject to appropriate protocols, to talk with judges and associates about questions arising in the cases. The protocols obviously would have to be formulated with some care to deal with issues of confidentiality and conflict interests. So I do believe that there's an opportunity here for both the judges to participate in legal law schools, as well as for academic to also come to courts, as long as certain protocols are observed, given the work of the courts. Thank you very much.
Thank you. I think that is again a valid observation, because this presents an opportunity for judges, students, and faculty members to interact, actually learn from each other, and basically facilitate a greater interaction and knowledge creation. So these are all positive things. Maybe in this context, I would like to ask one more question to Mr. Siddharth Luthra. So given the fact that the legal profession is going through a difficult period, especially in the context of COVID-19, and that many professionals have got an uncertain future, what could be your advice? What could be your take on the youngsters who may be joining these executive education programs, or the people who would like to join the program in the future? How will this category of people benefit from this program? And what is your general advice, how the legal profession as a whole will evolve after COVID-19?
My eminent colleagues have said, one of the things that's come out of the pandemic is that we've had a lot more time on our hands, which we never had in the past. So the transit time, the physical time, all of that has been reduced. Professionals do have time on their hands. The initial phase of the pandemic was a phase of confusion when we didn't know how long it would last. But speaking for myself, I don't see things settling down till maybe middle or the end of next year. And therefore, this is a very crucial time for legal professionals to reach out and hone their skills, to improve themselves. We are missing out on crucial courtroom moments. A lot of our learning is in court. A lot of our learning is in our offices with interaction with our colleagues. So that has to be replicated, and the only way that can be replicated or the gap can be filled up is by reaching out and accessing executive legal education programs, because that will bridge the gap. That will also enable us to hone our skills and to use this period as a period of development. This is not a lost time. We're not going to get this time again. For those of us who survived the pandemic, this time is not going to come back, but this is a time when you can invent and reinvent yourselves, as the judge said, to learn, learn, and relearn. And for that, it is for us to work towards that self. We have to move on. We have to come to terms with this pandemic and move forward. And if we have opportunities like this, I mean, today I'll tell you, I've taught in Jindal Law University as an adjunct professor. I taught elsewhere. Now that's the teaching part. But I'm looking for programs where you will teach me. Are you going to do that is my question.
Mr. Moderator, I think you are muted.
James, you're muted.
Yeah, sorry about that thing. So thank you, Mr. Sudhar Luthra. So we have got the fourth speaker, Professor Mohammed El Dasuki. He is the Dean of the College of Law at Al Falah University. So Professor, I have just one question to you. Given the fact that most of the campuses in many jurisdictions are completely shut at this moment, how do you view the evolution of this continuing legal education as an opportunity for law schools around the world and also within your own jurisdiction?
Yes, Doctor, at the beginning, I'm sorry for joining late because some unexpected errors. I would like to thank thank your university about this conference. This is the topic of the hour. As well as inviting me and my colleague to this conference. According to the e-learning, most of the universities used e-learning before the crisis of COVID-19, but especially under this crisis, all the university uses these facilities not only as e-learning, but also as a distance learning. Maybe at the beginning, we are all, I'm sure, faced a lot of problem with the students, with lecture, exams. But I'm sure now all the faculties or the colleges all around the world are so familiar with these facilities. Now, for example, we are in UAE. The distance learning will continue at least this semester, and the next semester, second semester, we don't know up till now what will happen. But anyway, we suppose we will continue as e-learning and also distance learning. We are ready. All the world are ready now, students and all in structure also.
So
yes, but the thing makes me optimistic that this crisis now make us, for example, join at this conference without leave our countries. So, I wish to visit India actually, but facilitate this this conference. What I mean in the next period, it will be a very, very a good opportunity to collaborate between colleges to, for example, providing joint academic program and awarding also double degrees. I think that will happen. Most of the countries, they cannot maybe like or feel uncomfortable with the distance learning. Now, I think most of the countries can allow now this kind of learning. It's not the quality is we are sure the quality is very نقدر نقول is effective, not bad, very good. I am optimistic about that. Also at the courts here in UAE, especially in Dubai, Abu Dhabi, we as a courts using the distance, for example, the sessions now we are using it. Can I say the courts before the crisis and now practicing the lawsuit and remote sessions. The crisis already affected all the sectors in the world, but in the next also there are some good things will happen, as I told you. I wish I answered the question.
Thank you. Thank you. That is a very, very useful observation. It is a fact that even before COVID-19, a large number of educational institutions had collaborated for providing online programs, twin or dual degree programs and other programs. So as the necessity is the mother of all adaptation, I'm sure these kind of activities will flourish in the future. We have got a few set of questions from the participants. So maybe I will actually read out one of the questions. The first question is, as all courts have gone online, how can the judicial institutions in the present pandemic times extend practical training opportunities to the students pursuing executive courses who may miss out on valuable internship experiences? I think anyone can actually answer take this question.
One of the biggest problems that we are having is for young lawyers and law students is the inability to be present in court. And that has led to, a lot of our learning would happen watching good lawyers, great professionals performing in court. You may not be in that case, but you would learn a lot from listening and hearing others and the interaction you would have and the exchange between judges and lawyers. The virtual courts, barring few high courts, do not allow access to third parties. There are, because of technological constraint, barring high courts like Uttaranchal High Court in Nainital in India, most of the other high courts, only the parties can get a specified number of links. Initially, there was only one link per matter or two links on each side. Today, of course, that's increased. But interns and law clerks, young lawyers, they do not have access. Even lawyers and law firms are not able to give access. Of course, we're trying to add and give people online internships as far as possible, but that's not the same experience. So the great opportunity that judges can give young lawyers and law students and courts can give is to give them the opportunity to do online internships. Of course, there are security issues and privacy issues which will have to be taken into consideration, because earlier the physical files used to be at the judges' chambers where they would be viewed by the law clerks and the interns, and now these files will have to travel electronically. But having said that, that would be a great mechanism for young lawyers and law students to understand the functionality of courts in the VC era, as also be able to watch and learn and experience from courts.
Thank you.
Maybe I can add to that. Yeah, thank you very much. I think as judges, as someone who sits at least on the bench, a president of the court, I think we should consider this, that part of what we should do as our duty is to train young lawyers. So we should take that as one of the duties of in our profession. So there's nothing that stops judges, and I've done so even during this COVID period, to have a one-on-one with some of the law clerks to explain to them what is happening, despite the fact that a lot of functions have been put electronic. So it is incumbent upon us to know that in our profession, in the legal profession, the most important aspect of training is apprenticeship. So we should take that into consideration and find time amidst all the challenges that we have and time to train these lawyers. But I may speak of the experience of my court. We have allowed third parties to be able to follow the cases virtually, including law students. And the reason being that the philosophy behind this is that the courts should be open. So even if they, as they go virtual, I do believe that the IT people can help and do allow as many participants as possible. And at the beginning, it was a bit difficult. So we allowed media houses to be part of the processes of the court and be able to broadcast. And then later on, we went to live streaming of the hearings, and it has really helped a lot. And I do believe we'll continue improving on this. But taking in mind that in our legal profession, one of the most important things that you can do is to mentor others who will take over from the positions that we sit in today.
Thank you. Thank you, Justice Emmanuel. I think you made some excellent points. So, there are difficulties in maybe live streaming the court sessions, maybe in different jurisdictions. And the second point is that, okay, I will definitely give the chance to Susan as well. So Susan, would you like to say something?
I think I just wanted to just wrap up on the conversation earlier with some perspectives from the UK and the challenge of open access, but also restrictions on making hearings available online isn't to be underestimated. Some of the innovations of our UK Supreme Court with live streaming of hearings have been very inspiring even before COVID. But certainly my own professional practice has been affected by similar tensions that Mr. Luthra has mentioned around other cases, particularly where there are reporting restrictions on trials. So I think bringing that into the education dimension, what it tells us is that if we impart learning just by telling people what to do or getting them to read something, they're going to absorb a very small part of it. If you then demonstrate it, they will gain a lot more. But giving them the opportunity to get on their feet gives them a much more valuable experience. But one of the great benefits that we have with technology and recording is actually playing back somebody's performance to them and getting them to see how they perform can help with some of the advocacy techniques. And I've certainly been working with that over the last 9 months with a course on practical skills in dispute resolution, which was one of the gifts perhaps that COVID had given to us in allowing for that much more kinesthetic experience with a body demonstrating and then playing back to the student. This is what the observer sees of you. And that is something we can do in an online environment, which will help with advocacy skills.
Susan, thank you. I want to take one more question. So this is actually a question with respect to teaching. And since you are a teacher, my question is to Susan. Is the Socratic method of teaching better apt for students who want to work in judicial services rather than normal textbook teaching? How do we incorporate this method in executive legal programs?
Well, I speak here as both an academic and a practitioner, because ultimately looking at teaching methods and development of skills ultimately has to look to what are we going to do with this, and that may not necessarily be practicing law or being a member of the judiciary. But if we're trying to evolve our current learning techniques, one key area is around legal reasoning. And I think that's where traditional didactic skills of looking at rules, looking at learning and dispensing knowledge are not the skills that are highly valued in a courtroom, because of the need to engage as much of that with evidence. And I think that is where these interfaces need to be looked at, and looking at a blended approach, unpacking legal rules, intersposing evidence, and enhancing skills of reasoning, and equipping lawyers for the future, not just with knowledge and rewarding them for memory skills, but rewarding them on their ability to harness information and reason in a coherent way. And I think that is our biggest challenge for the future, because those are skills which I believe are undervalued in the current education system, but are highly valued in the real practice of law. And translating that is our next big goal.
Thank you. So thank you, Susan. In fact, we do not have much of time. We are nearly running short of time. So as a concluding remark, what I can say is that we have all become resilient now. I mean, had this kind of an online education program been offered 1 year earlier in 2019, there would not have been too many takers for it. And most of us sitting here and exchanging our views as part of this conference would not have even learned how to use the Skype, or maybe Zoom for that matter. So all of us are very familiar with the technology now. Judges are familiar with the WhatsApp, and they're also familiar with all the technologies. I think even people in the 60s and 80s, 70s, the senior citizens, they have learned the trick of the game. So these are the positive things. I think the spillover benefits will be huge. So I feel that Professor Rajkumar's vision of continuing this legal education program and taking it at a very big level, at a huge level, has got huge benefit for the society. I teach in a program which has got numerous students, and I don't think that any one of them could have attended this kind of a legal education without this online platform. So we are sitting in the midst of an opportunity. There are many challenges, and we have to be adapt and adaptable. So let me actually turn the phone, the Zoom over to Professor Rajkumar for the concluding session and for winding up the session.
And thank you so much for all of you. I particularly want to thank my very dear friend, Mr. Siddharth Luthra, for sparing time from his busy schedule. I call him, in many ways, the non-billable hours that he has given to us for being part of this panel. Thank you so much, Suzanne, for your very thoughtful reflections. Thank you, Emmanuel. So good to see you. And of course, we also briefly had our other speaker, Professor Mohammed Bisowski, and thank you so much, James, as well. In fact, one of the things that many of you reflected is in relation to what extent executive and continuing legal education through these platforms can go beyond the COVID-19 crisis. This is the new normal. In fact, this morning, Honorable Dr. Justice Chandrachud, Judge of the Supreme Court of India, when he delivered the Constitution Day lecture, he quite passionately talked about the fact that some of the fundamental challenges of access to justice can be addressed using some of the technological new age technology that has been brought to bear in the access to justice delivery mechanisms. So with those words, once again, thank you very much. Be safe. We will be quickly taking a break and then move into the 18th thematic session on potentialities of the pandemic, industry, professional, and academic collaborations. We have Honorable Mr. Justice Matthew Cooper, Judge of the Supreme Court of New York, Professor Jayant Krishnan from Indiana University, Mr. Nishit Desai, founder of Nishit Desai Associates, Professor Idiko Maskar, head of the law school from Columbia, Professor Aman Lahavi, Dean from at the Interdisciplinary Center Herzliya in Israel, will be joining us shortly. Thank you very much.
Thank you.
Thank you very much.
Good evening from India. My name is Raj Kumar. I'm the Vice Chancellor of OP Jindal Global University. Good morning to my friends in North America and Canada. Good afternoon to our friends in Europe. I would like to extend a warm welcome to all of you to the second day of the global virtual conference on reimagining and transforming the future of law schools and legal education. We are at the 18th thematic session on the theme, Potentialities of the Pandemic, Industry, Professional, and Academic Collaborations. We have a very distinguished group of individuals who are leaders in their own right, who have contributed to many aspects of innovation and transformation in their respective walks of life. We have with us Professor Ildiko Zegedi Mazak, Head International Relations Law School, Pontificia Universidad Javarna in Colombia. We have Professor Amnon Lahavi, Dean of the Hadi Radner School of Law, Interdisciplinary Center, Herzliya from Israel. We have Professor Jayant Krishnan Milt and Judy Stewart, Professor of Law, Indiana University, Bloomington from United States. We have with us Mr. Nishit Desai, founder of the Nishit Desai Associates, and lastly, not least, Honorable Mr. Justice Matthew Cooper, Judge of the Supreme Court of New York, United States. I'm very delighted that my good colleague, Professor Erickson Gudmunter, professor at Jindal Global Law School, OP Jindal Global University, will be moderating this panel. I request Professor Gudmunter to take this forward, and I'll join you shortly. Thank you very much.
Thank you, Raj. Well, good afternoon, everybody, near and far. Well, I think everyone prefaces conversations nearly wherever we are in lobbies or in virtual sessions like this by saying, if there's anything we have learned from the COVID, et cetera, et cetera. And I would like, on the basis of what we're discussing here, to identify two things. The first is, of course, the need for collaboration. Now, this is not a new lesson for any of us. We all know how important this is in our academic environment. Jay, you just mentioned the cooperation you have between your academic institute and the Nish's law office. And we all know, for instance, in Jindal, we pride ourselves on having 200 plus cooperation with other universities and other institutes abroad. But what we have learned, I think, quite clearly, is the immediacy of this type of collaboration. Now, we've seen this in the very casually in the field which matter a lot in the field of health and medical improvements and innovations. But it's no less important in the law. And where are we in the law? We all know that the law moves rather slowly. You might say this is a rather ponderous discipline. Well, we have learned that we have to move quickly in all these fields, and not only quickly for what we're discussing today or the present situation, but in the future. And I think we'll give a little time at the end for each of us to speculate on what the future brings, whether we see some sustainability in what the lessons that we learn here. We're thinking in terms of three themes. First of all, because we're in the academic environment, it's very important to our students to know the effects of how to react to the COVID as far as their studies are concerned, and then their future, and then the link between that is the internships that they would have with practitioners, and if I ask you, Matt, also how that's going with respect to the interns in your court. Secondly, what this leads to the prospects, what this means for the prospects of our students in the immediate future, the soon to graduate, the seniors that are with us, what is their immediate future? How can they adjust to this? How can we help them through collaboration adjust to these concerns? And then finally, and I know this is directed to our academic colleagues, research. What have we learned